Hello, good afternoon, and welcome to Unacademy. This is a marathon session on Indian polity, strictly relevant for the Prelims 2026. The PDF of the session will be available on my Telegram channel. The link to join the channel is provided in the video description, but that PDF would be available once the session is over. Clear? Let's get started, but first up, you should have covered the 3 Bare Act videos available on our YouTube channel. That's number 1. This is in white because we have covered it last year. Doesn't change anything. Please attend these 3 videos. Very important, crucial for your prelims examination. So far as current affairs is concerned, you would know that there have been 3 live sessions on current affairs. One, where we covered current affairs of January till June, then June onwards till December, then January 2026 till April 2026. These 3 videos should suffice your current affairs for Prelims 2026. Then last year, we conducted a marathon where we discussed the PYQs from 2013 till 2024. Now, how these PYQs are important? Sometimes the questions get repeated, but sometimes you understand what sort of questions are asked in the examination. And while discussing these PYQs, I have also explained the concept surrounding those questions. So please attend this session as well. Plus, I have released 2 videos on this YouTube channel where in one video I have covered all the statutory bodies, non-constitutional bodies. And in the other video, I have covered all the constitutional bodies. This is also something that you should attend. Lastly, all the PYQs and MCQs based on those PYQs. These 4 sessions are available on Unacademy app. Please watch those 4 sessions as well. Once you have understood all these lectures plus today's marathon, I am confident that you should be able to solve maximum questions in the prelims examination from this subject, Indian polity. Now, how are we going to proceed today? 1, we will cover part by part, section by section, and every 2.5 hours, I will respond to your doubts. So whatever doubts you have, park your thoughts, park your doubts. 2.5 hours later, I will give you an opportunity that you can ask me any questions related to the parts that we have covered till then, and I'll be more than happy to assist you. Today's session is going to be lengthy, whether it takes us 10 hours or 12 hours or 14 hours, whatever it takes, we will complete the syllabus today. Clear? So like this video, subscribe to our channel if you haven't yet, and let's get started and start a fascinating journey of Indian polity. Now I'm asking you, if my voice, audio, video is clear, please let me know so that we can start. Great. 2 announcements before we begin, and this is specifically for those who are attempting civil services examination in 2027 or beyond. Tomorrow at 5 p.m., I am conducting an AMA session. Ask me anything. Whether it's with regards to your optional selection or current affairs strategy, book list, any preparation doubts you have, please come to the session tomorrow on Unacademy Platinum and let's kickstart your UPSC journey. Plus, for the first time, we are announcing this. We have been working on this app for a long time now, and finally we are launching it. Unacademy Sprint. Learn daily with 5 free lessons, crisp concepts, crisp analysis, crisp explanation, and I can promise you that you will be able to retain concepts better by watching these videos. Fantastic app. This is one of the best apps that have come from the Unacademy group. Download this. The link is provided in the video description. Let's get started and let's look at first things first. We will try and understand basics so that conceptual clarity is taken, and then one by one we will jump to various parts of the Constitution, various chapters, various issues. So basic and conceptual clarity is required at the start. And for that, you would know that in Indian polity, basically, what do we study? We study the Constitution of India. We also study the judgments of the courts. We also discuss the laws enacted by the Parliament. We also discuss the current affairs updates. But first thing that you must know is what is a constitution? Because from this particular topic, questions have been asked previously, and this becomes a very important topic for your examination. You would know that this constitution was given to us by the Constituent Assembly, which met for the first time on 9th of December in 1946. And for the next 2.5 years, our founding fathers took a lot of time, looked at various constitutions of the world, and gave us a beautiful, lengthiest constitution of the world. But first things first, what are the functions of the constitution? This is something that you have to keep in mind. There is a lot of diversity in our country. Religious diversity, caste diversity, linguistic diversity, tribal diversity, which means when there are different sets of people residing within the territory of India, I may have different expectations. You may have different expectations. I may focus on issues in a one way. You may focus on issues in a different way. And this may result in chaos also. This may result in conflict also. How do we minimize the conflict? If all of us agree that we will follow basic rules, those basic rules are provided by the Constitution. So the first function of the Constitution is to provide a set of basic rules which all of us will follow. So at least there is a minimal coordination within the sections of the society. Second function of the Constitution is who has the power to make decisions for the society. Constitution has to specify who has that power. That power is with the government, that power is with the legislature. How this government will be constituted, that is the second function of Constitution. Third and the most important function, is the power available with the government unlimited? Or is there a limitation on the powers available with the state, available with the government? And this is where you need to understand doctrine of limited government. What is this doctrine of limited government? Doctrine of limited government says that the powers available with the government, they are not unlimited. There is a limitation on the powers of the government. And that is the most important function of the Constitution, imposing limits on this government so that the government cannot trespass your rights. That's the most important function of a constitution. Fourth, enable this government that you have to fulfill the aspirations of the society. Because after all, what is this constitution? Constitution is a document of people's faith and aspirations. What are the aspirations of the people? That government should be capable of realization. And that is the fourth and the most important function apart from doctrine of limited government, that it has to enable the government to fulfill the aspirations of the society. But lastly, this is the word of NCERT. If a question is asked, which of the following best reflects the chief function of the Constitution? This question has been asked previously. All these are the functions of the Constitution. Provide a basic set of rules so that there is coordination. Specify who has the power to make laws and make decisions. Impose limits on the government, on the state. Allow this government to realize the aspirations of the people. But according to NCERT, the most important function is that it provides a fundamental identity to the people. And what sort of identity? Political identity as well as moral identity. Political identity, we are all the citizens of this country. So that is now our political identity. We are Indians. That's how the Constitution starts. We, the people of India. But it also gives us the moral identity. Moral identity in the sense, whatever religion you subscribe to, whatever ideology you have, when the government makes decisions, when the legislature enacts laws, when decisions are to be taken, what is it that we will keep in mind? The morality of our religion, of our caste, of our linguistic identity, or is it the constitutional morality? For example, Joseph Shine case. The Supreme Court had to decide the constitutional validity of Section 497 of Indian Penal Code. This was the provision related to adultery, whether adultery is constitutional or not. Supreme Court struck down Section 497, declared it unconstitutional, invoking constitutional morality. Why? Because this section would have construed that women are the property of the men. Wife is the property of the husband. If this is the morality formulated by your religion or your caste or your personal morality, but that cannot trump constitutional morality. Constitutional morality deals with equality. How can you treat women as the property of the male? So this was the ground on the basis of which the Supreme Court struck down Section 497. So what Constitution gives us? According to NCERT, the most important function of a constitution is to express the political identity of the people. But that is both political as well as moral identity. Clear? Done. Then second important concept, federalism. Is the term federalism defined in the Constitution? No. Does Constitution refer to federalism anywhere in its text? No. Yet this federalism, Supreme Court has said, is part of the basic structure of the Constitution. Which means no constitutional amendment can violate federalism. But what do we mean by federalism? For that, we take a look at the Constitution of United States of America, which is considered to be the oldest federal constitution of the world. Long story short, whether this constitution is federal or unitary, how do we decide? We take a look at the Constitution of the United States of America and compare this constitution with the Constitution of United States. If it meets the criteria of the US Constitution, it is federal. If it is not meeting, then it is something else. But what are those characteristics which make US Constitution a federal constitution, a federal polity? For that, there are 6 things that you have to keep in mind. Dual government. One government at the center, one government in the states. That means governments in all the states and government at the center. Federal government, state governments. Constitutionally divided powers. Distribution of powers, as we call it. Some powers are available with the center, some powers are given to the states. Third, supremacy of the Constitution. Constitution is supreme. For example, in case of United Kingdom, we say Constitution there is not supreme. They have an unwritten Constitution. In United Kingdom, there is a concept called parliamentary supremacy, which means British Parliament can do anything. There is no limitation on the powers available with the Parliament in Britain. So we call it constitutional monarchy, because who is the head of the state in UK? It's the king. And the king is occupying that post because of heredity. That means the head of the government is not elected. The head of the government is a monarch. But even then, Britain is a democracy. Britain has a constitution. Although that's not a written constitution, it is an unwritten constitution, but we call Britain a constitutional monarchy. India is constitutional republic. We are a democracy. We have a constitution, but head of the state, who is the head of the state? The president. President is elected by the people of India, although not directly, indirectly, which we will discuss later. So India is a constitutional republic. Britain is a constitutional monarchy. But in Britain, since they have an unwritten constitution, Parliament is supreme. Supremacy of the Parliament. There is no limitation on the powers of the Parliament. But when it comes to written constitutions, such as United States, such as India, constitution is supreme, not the legislature. Written constitution is the most important criteria to be determined whether a particular constitution is federal or unitary. So why do we call US Constitution a federal constitution? Because it provides for dual government. because it provides for division of powers or distribution of powers, because the Constitution is supreme, because the Constitution is written, because the Constitution is rigid. Now, rigidity does not mean that it is impossible to amend the Constitution. Rigidity does not mean that it is very difficult to amend the Constitution. Rigidity means if at all Constitution needs to be modified, changed, amended, altered, it has to be a joint act. Both the center as well as the states, they have to come together to amend the Constitution. It cannot be unilaterally changed by the states. It cannot be unilaterally changed by the union, by the center. It has to be a joint act. And independent judiciary, because if at all there is a doubt, if at all there is a dispute between the center and the state with regards to dual government, distribution of powers, whatever doubts, those doubts must be adjudicated by a judiciary which is independent. That means judiciary which is not biased in favor of the center or biased against the states or vice versa. All these characteristics make US Constitution a federal constitution. We also say we are a federal constitution. But in our federal constitution, the Supreme Court has said in the SR Bommai case that federalism is part of the basic structure of the constitution. Despite the fact that we are a federal constitution, we have a federal polity, our constitution makers gave a unitary bias to our federal constitution. Unitary bias in the sense that more powers are given to the center as against the states. Why is this ideal or not ideal? That is the subject matter of mains examination. We will not go into the analysis of this. But we have to understand for the prelims examination, what are those centralizing features of Indian federalism? What are those characteristics of our Indian constitution which we say is biased in favor of a strong center? Number one, we have a single constitution. One common constitution for the entire country, center as well as states, unlike United States. Single citizenship. If there is dual citizenship, we say that's a feature of US federalism. Strong union list. Schedule 7 talks about distribution of legislative subjects into union list, state list, concurrent list. Who has the power to make a law on union list? Parliament. How many items are there in the union list? 97 items, which means more powers are given to the union as against the states. Strong union list. That's the feature of unitary bias to our Indian federalism. Residuary powers are with the center. If there is an item which is neither in the union list, state list or concurrent list, which means it's a residue left over, who has the power to make a law on this residuary item? That power is with the parliament. That power is with the union. Parliament can alter the state boundaries under Article 3 of the Constitution. Who has the power to reorganize the states, bifurcate the state, trifurcate the state, merge states, create union territories? That power is available with the parliament. Emergency provisions, Article 352, 356, 360. And the purpose of these emergency provision is to somehow temporarily convert our federal polity into a unitary polity, which we will discuss today. The governor, I don't need to explain it. The governor appointed by the center, accountable to the center therein. All India services. How many All India services do we have? 3 All India services. IAS, IPS, Indian Forest Service. These officers appointed by the center, trained by the center, can be dismissed by the center, removed by the center. States can maximum suspend an All India service officer. But where do these All India services individuals, officers work? They work in the states. Centralizing tendency. Integrated judiciary. In United States, each state has its own Supreme Court. But in India, we have an integrated judiciary. District courts, high courts, Supreme Court, which means a case can reach way till the Supreme Court. Integrated judiciary. That's also a centralizing feature of Indian federalism. Parliament's power over state list in certain situations. When we will discuss center-state relations, there are some areas where Parliament can make a law even on the state list. Article 249, Article 250, 252, 253, which we will discuss later. These are also centralizing features of Indian federalism. Unequal representation in the Rajya Sabha. Uttar Pradesh has 31 MPs in the Rajya Sabha. Sikkim has only 1. Tamil Nadu has 18. Telangana has 7. Unequal representation of states in the Rajya Sabha. Unlike United States, where each state has 2 senators in the Senate, in the upper house of US Congress. Integrated election and audit machinery. Election Commission of India, which means the Election Commission of India, which means a body created by the Constitution, one common body organizing elections to the Parliament as well as state legislatures. Integrated Audit Machinery, CAG, auditing the accounts of the center as well as the states. All these give us a complete picture that our Constitution, despite the fact that it is federal, and Dr. Ambedkar also said ours is a federal constitution, yet the constitution makers were conscious of giving some strong powers to the union. And that is what we call centralizing tendency of Indian federalism. Despite federalism, there are more powers available with the center as against the states. Is that clear? Great. What do we mean by parliamentary form of government? There is a parliamentary form of government, there is a presidential form of government. We have embraced parliamentary form of government. And on this, numerous questions have been asked repeatedly in the prelims examination. Just go through the PYQs. This concept is important. What is this parliamentary form of government? We say Council of Ministers are collectively responsible to Lok Sabha. But sometimes UPSC may not ask it directly. Parliamentary form of government means Council of Ministers are collectively responsible to Lok Sabha. Then what? Which means executive is responsible to legislature. But sir, legislature includes President, Rajya Sabha, Lok Sabha. How can this statement be correct? If this is the only statement nearest to this concept of parliamentary form of government, mark it correct. Or you can say the government is responsible to the people. If you want strict legal definition of a parliamentary form of government, that is Council of Ministers are collectively responsible to the lower house of the Indian Parliament, which is Lok Sabha. But what if the statement is not given? Then find out if a statement says executive is responsible to the legislature. If not, find out whether it is mentioned that government is accountable to the people and collectively responsible to the legislature. This is what we call parliamentary form of government. But why have we chosen parliamentary form of government? Maybe that question is asked in the examination. Why have we chosen it? One, because we were exposed to it. We were a British colony. In Britain, they have a parliamentary form of government. They tried to implement this parliamentary form of government in India as well. Let's say through Government of India Act 1935. So we were already exposed to this form of government. So when we were exposed to this form of government, we had some experience in parliamentary form of government. The makers of the constitution thought, let's continue with this, let's persist with this, because we have been exposed to the system. But that's not the only reason. Dr. Ambedkar was asked, why did we choose parliamentary form of government? He said that a government needs 2 things. One is stability, the other is accountability. A government should be stable, and the government should also be accountable. Stability, that means frequent changes should not take place. The government should be allowed to complete the term, otherwise there is chaos. But this government should also be accountable to the people who elected them. Dr. Ambedkar said, we haven't devised such a system yet, which can marry both these features. There is no government, there is no form of government which we can embrace so that it can give us stability as well as accountability. If you want stability, for that, go to the presidential form of government, because presidential form of governments are stable. Because the President of the United States, he will continue to remain in office despite the fact, even if his political party, the grand old party, the Republicans, they lose majority in the legislature, in the US Congress, in the Senate, or in the House of Representatives. But in India, the Council of Ministers, they are responsible to the legislature. They remain in office as long as they have the majority on the floor of the Legislative Assembly. So Dr. Ambedkar said, if you want stability, embrace presidential form of government. If you want accountability, embrace parliamentary form of government. And we think we need accountability more than stability. And for that accountability, we embraced parliamentary form of government. Concept is important. What is parliamentary form of government? And why we chose parliamentary form of government? Maybe a statement is asked. Presidential form of governments are considered to be accountable, more accountable than parliamentary form of governments. You should know that this statement is incorrect. Clear? Parliamentary form of government. What sort of parliamentary government do we have? What are the features? Dual executive. Dual executive in the sense, we have the president at the center, but we have the prime minister as well. We have governor in a state, but we have the chief minister as well. Dual executive. Executive is drawn from the legislature. Concept is important. What is the concept? In a presidential form of government, there is something called strict separation of powers. And what is the strict separation of powers? Executive separate, legislature separate, judiciary separate. Can a member of the executive also be the member of the legislature? No. Can a member of the legislature be a member of the executive? No. But in parliamentary form of government, executive is drawn from the legislature. That's the feature of a parliamentary form of government in India. Because is president, who is the head of the executive, also part of the legislature? Yes. Is governor part of the legislature? Yes. But sir, governor also? Yes. Governor is an integral part of the state legislature. Prime Minister is part of the executive, he is also part of the legislature. And collective responsibility. Collectively, Prime Minister, Council of Ministers, Chief Minister, Council of Ministers, they are responsible to the lower house of legislature, which means they remain in office as long as you have the majority. For example, Mr. Vijay has been sworn in as the Chief Minister of the state of Tamil Nadu. He will survive as long as his government has the majority on the floor of the Tamil Nadu Legislative Assembly. The moment you lose majority, you're out. Prime ministerial leadership is another feature of a parliamentary form of government. Because we say president is the de facto head of the state or de jure head of the state. But who is the de facto head? According to the law, it's the president who is the head of the government. But in reality, it is the prime minister. By the fact of it, it's the prime minister who runs the government, who has the most important powers. Implementation of the powers is with the prime minister. And the feature of parliamentary democracy is that the lower house is dissolved and can be dissolved. Ms. Mamata Banerjee said, I won't resign because I have not won the election. The governor dissolved the Legislative Assembly. Why? Because the term of the Legislative Assembly was over. The term is 5 years. 5 years are over, Lok Sabha is dissolved. Legislative Assembly is dissolved. So this is another feature of the parliamentary form of government that we have in India. Clear? Let's get started and let's look at something else. According to Dr. Ambedkar, why did we choose parliamentary form of government? Because we wanted to prioritize not the stability, but we wanted to prioritize accountability. We needed to give preference to accountability. The government should be accountable to the legislature. That is why we chose parliamentary form of government. Dr. Ambedkar also spoke about constitutionalism. Dr. Ambedkar said, this is the habit that we need to cultivate. This is the sense that we need to cultivate, because democracy is just the top dressing on the Indian soil, which is essentially undemocratic. But what is constitutionalism? the government does not have unlimited powers. And this is where Dr. Ambedkar also spoke about constitutional morality, which we will discuss, that constitutional morality also needs to be cultivated. But what is constitutionalism? The government must be legally limited in its powers, and that the legitimacy of the government will depend upon whether it is observing those limitations. So there are some limitations imposed, listen to me carefully. There are some limitations imposed on the government by the Constitution. Constitutional form of government, constitutionalism. But is this government legitimate or illegitimate? If it is observing those limits, it is legitimate. If it violates the limits imposed by the Constitution, then we say this government is illegitimate. This term, constitutionalism, we can understand through the writings of John Locke and various other American political scientists. The government must be legally limited in its powers. This is also the doctrine of limited government. But what are the essential features of constitutionalism in India? Imagine it this way. If all the powers are concentrated in one body or one individual, do you think that there will be any check on this body, on this individual? No. That is why one feature of constitutionalism is separate the powers. Create bodies such as executive, legislature, judiciary. Judiciary can keep a check on the legislature. Judiciary can keep a check on the executive. Legislature can keep a check on the executive. Through separation of powers, that's one of the most defining features of constitutionalism. Even then, the government may violate rules, may be repressive, may be not taking into account the needs, the aspirations of the people. For example, there was anger against Mamta Didi's government in West Bengal. People voted her out because ultimately popular sovereignty lies with the people. That is also a check on the government. Okay, you do whatever you want to do, but once your term is over, we will have the power of our vote and we will throw you out. Popular sovereignty is with the people. Rule of law. Rule of law, which we can understand through the writings of British constitutional expert A.V. Dicey. Rule of law means what? Nobody shall be sentenced in body or goods except for a breach of law. I have not violated any law. Why should I be arrested? Why should my liberty be snatched? Why should my property be confiscated? Anybody can sue or be sued. I can file a case against you if I'm an aggrieved individual. Does the law say, no, if you belong to this particular religious community or this particular caste group or this particular linguistic group, or you belong to this particular gender, you belong to this particular race, you cannot file a case? No. This is rule of law. And when we say there is rule of law, which means the government cannot arbitrarily arrest me, cannot throw bulldozers on my property. Rule of law. And even if there is a violation, we can go to an independent judiciary, impartial judiciary, and judiciary will protect and uphold my rights. Also, individual rights. Individual rights in the sense, look at the wording of all fundamental rights. The state shall not deny equality before law and equal protection of the laws. The state shall not discriminate. The state shall not do this. The state shall not do that. What is this? What is this that the state cannot do? Limitation. Limitation on the powers of the state. What is this? Constitutionalism. So what is constitutionalism? The government can be, must be, and should be legally limited in its powers. The powers available with the state are not unlimited. There is a limitation. And whether this government is observing those limitations or not, we will then decide whether this government is legitimate or illegitimate. But what are the features that make our system, a constitutional form of government, doctrine of limited government. What are those features of constitutionalism in India? These are the features: separation of powers, popular sovereignty, rule of law, independent judiciary, and the individual rights that are available with the people, which the state cannot trespass. Right? This is about constitutionalism. And then constitutional morality. For example, I was giving you the example of the Joseph Shine case. What if all of us believe that yes, women are inferior and they are the property of the males? That is our belief. That is my belief. That is your belief. But will that belief sustain, or will the morality which is enshrined in the Constitution survive? Constitution talks about equality. It does not talk about arbitrary distinction between man and a man, man and a woman. Constitutional morality means you are adhering to and you promote the core values and principles which are enshrined in the Constitution. For example, look at the Preamble. It talks about dignity. It talks about liberty. It talks about equality. It talks about fraternity. These are the features of constitutional morality. Constitutional morality. Now let's jump to the important aspect. Once this conceptual clarity is done, you know what is Constitution, what are the main functions and roles performed by the Constitution, what is federalism, what are the centralizing features of Indian federalism. When you know what is constitutionalism, what is constitutional morality, why have we embraced parliamentary form of government, what are the features of the parliamentary form of government. Now let's jump to the preamble. But before that, if you have any doubts, let me know so that I can respond to your doubts. Yes, in Navte Johar also, constitutional morality was invoked by the courts. Okay, let's look at the preamble. How and what is the significance of preamble? Look at the wording. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. When you look at this preamble, we can break it into various parts. First is this we the people. But before that, let me talk about legal fiction. A book may be fiction, non-fiction, and you know the difference between the two. Legal fiction has been created here because Constitution says we the people of India, we have adopted and enacted this Constitution. We the people didn't. Our representatives did in the Constituent Assembly. But legal fiction has been created. We say this Constitution has been adopted by the people themselves. Although that is not entirely true or entirely incorrect. But we have created the Constituent Assembly. The Constitution has created this legal fiction to say that it gives weight to this document. This document has been prepared, adopted, enacted by the people themselves. So popular sovereignty lies with the people. So when we look at the preamble, the first thing that it talks about is popular sovereignty. If this Constitution you and me have to follow, if we have to abide by this Constitution, we have to respect this Constitution, where is this Constitution deriving its authority from? Because if it is deriving its authority from a ruling political party, we may not follow it. If it is deriving its authority from one particular dispensation, one political party or a system, we will not accept it. But if it derives its authority from the people of this country and sovereignty lies with the public, ultimate power is with the public, we will have to abide by this Constitution, respect the Constitution. So if this Constitution, we say, is the most sacred document in India, is the most sacred document for the people of this country, where does this Constitution derive its authority from? What is the source of the authority of the Constitution? That is the people. We, the people of India. But listen to me carefully. There is a thing called source of the Constitution and source of the authority of the Constitution. There is a difference between the two. What is the source of Indian Constitution? Multiple. We have borrowed few provisions from US, from France, from Weimar, from Russia, from Japan, from Canada, from Australia. So our Constitution is a bag of borrowings. That's the source of the Constitution. We're not talking about the source. We're talking about source of the authority of the Constitution. If this Constitution is the authoritative text of India, the most sacred document, where does it derive its authority from? The people of India. We, the people of India. Second, it tells us about the nature of the Indian state. That we are a sovereign, socialist, secular, democratic republic. And you would know these two terms, socialist and secular, these were not originally part of the preamble. These were added later through a constitutional amendment, 42nd Constitutional Amendment Act, 1976. Were these the only two terms added to preamble because of this constitutional amendment? No. This another word was added, integrity of. Because previously the Constitution, the preamble read, fraternity assuring the dignity of the individual and the unity of the nation. Then 42nd Amendment also added this word integrity. So three terms were added, socialist, secular, integrity. Then third thing that this Constitution tells us is what are the objectives that we want to achieve through this Constitution. These objectives you have to keep in mind. Justice. Sometimes the questions are asked, what are the terms which are explicitly mentioned in the Constitution? Is social justice mentioned? Yes. Economic justice, political justice? Yes. Liberty. Liberty of thought, expression, belief, faith, worship. Equality of status, opportunity. These terms you have to memorize because you should not be confused if a question is asked. For example, economic liberty. Was it mentioned in the preamble? This was the question asked once. You need to understand that when preamble speaks, it speaks about liberty in terms of thought, expression, belief, faith, worship. Liberty in these terms. Economic, not in terms of liberty, economic in terms of justice. So justice, social, economic, political. Liberty of thought, expression, belief, so on and so forth. Equality of status and of opportunity. Fraternity, a sense of common brotherhood. And the last thing that preamble tells us is the date on which the Constitution was adopted. 26th November 1949. But read preamble carefully. It says, in our Constituent Assembly, this 26th day of November, do hereby adopt, enact, and give to ourselves this Constitution. What if this term is asked in the examination? Preamble talks about the date on which the Constitution is enacted. It does. Because entire Constitution did not enter into force on the 26th of January 1950. There were some provisions of the Constitution which were adopted on this date itself, 26 November 1949. For example, provisional government, election commission, articles related to citizenship chapter, all these were the provisions which got implemented, enacted on the 26 November 1949 itself. But let's recap. Preamble tells us what is the source of the authority of the Constitution. What is the nature of the Indian state? What are the objectives of the Constitution? And what is the date on which we have adopted this Constitution? This date, 26 November 1949, is now celebrated as the Constitution Day. Since 2015, this fact becomes important. And this 26 January 1950 is celebrated each year as the Republic Day. Right or wrong? Right. What is the purpose of the preamble? Supreme Court has said, Preamble sets the ideals and goals which the makers of the Constitution intend to achieve through this Constitution. This Preamble is based on the Objectives Resolution. This Objectives Resolution was moved in the Constituent Assembly by whom? By Pandit Nehru. But this Objectives Resolution was adopted by the Constituent Assembly on 22nd of January 1947. Preamble is based on this Objectives Resolution. Basically, if we want to enact a constitution, prepare this constitutional text, what are we going to achieve through this? Exactly what? What are those ideals? What are the goals that we intend to achieve through this constitution? That is something which is mentioned in the preamble. Because let's look at what the preamble talks about. Objective is we want justice, liberty, equality, fraternity, dignity of an individual. This is what we want to achieve through this constitution. Supreme Court has said in another case, Berubari Union. You don't have to remember the judgments for the prelims, but just understand the concept, because this concept was asked previously in your prelims exam, I think in 2017. Which of the following unlocks the minds of the makers of the Constitution? Because preamble is like the preface to a book. Preface tells us not only about what this book is about, preface also tells us about the author who has written this book. It goes into what is the mindset of this author who has written this book. That's what is captured in the preface. Similarly, if you don't want to read the entire Constitution and you just want to understand what this beautiful document is all about, go through the preamble and you will understand what Constitution would be talking about. But preamble will tell us not only about this book, it will also unlock the minds of the makers of the Constitution. Which means what was the mindset of the people in the Constituent Assembly when they were drafting the Constitution of India? If we read the text of the preamble, we can say that the members of the Constituent Assembly, they were people who believed in justice, in equality, in fraternity, dignity of an individual. So this is how you can understand the minds of the makers of the Constitution. As I told you, preamble talks about the source of the authority of the Constitution, the nature of the Indian state, sovereign, socialist, secular, democratic republic, the objectives that we intend to achieve through this Constitution, and the date on which the Constitution was adopted, which is different from the date the Constitution was enacted. And for that, there is a history. And the history you would know, the history of the Purna Swaraj resolution passed by the Congress in 1929. That session, the Lahore session, it was presided over by Pandit Nehru. Because prior to that, Congress was asking for dominion status, not complete independence. But then this was the paradigm shift in India's struggle for freedom, where the Congress party now said, our goal would be Purna Swaraj, complete independence. And for the first time in 1930, 26th January 1930, Independence Day, and a symbolic gesture was celebrated by the people of this country. And that's how Pandit Nehru impressed the Constituent Assembly, saying that this 26th January date is very important and we need to preserve it somehow. Let's enact the Constitution. Let's implement the Constitution on this date, 26th of January. Right? Preamble is also called as the identity card of the Constitution. For example, Nani Palkhiwala, constitutional expert, one of the best legal luminaries India has ever had, he referred to preamble as the identity card of the Constitution, or the philosophy of the Constitution, or the soul of the Constitution. Preamble. This preamble is not enforceable in a court directly. If your fundamental rights are violated, you go to the court to get your fundamental rights enforced. Preamble is not enforceable in a court of law. But then what is the purpose of preamble? Purpose of preamble is whenever any provision of the Constitution is ambiguous, courts often resort to preamble, take a look at the preamble, and then decide what should be the interpretation of this provision? Simple terms, right to privacy. Is it a fundamental right or not? Matter went to the Supreme Court in 2017. K.S. Puttaswamy judgment was delivered by a 9-judge bench of the Supreme Court. And the court said categorically, unequivocally, by the majority of the 9 judges, 9-0 judgment, that right to privacy indeed is a fundamental right guaranteed by Article 21 of the Constitution. But how did the court come to this conclusion that right to privacy, although not explicitly mentioned in the Constitution, yet is an integral part of Article 21? The Supreme Court said, look at the preamble. Preamble talks about one of the objectives that we wish to achieve through this Constitution is dignity of an individual. We cannot ensure dignity of an individual unless and until they have privacy. So right to privacy is a fundamental right. Which means preamble will be used to interpret the provisions of the Constitution when the provisions of the Constitution are found to be ambiguous. And what is the interpretation that the court will give to this particular provision? The court will read preamble and see whether this interpretation is in harmony with the preambular objectives or not. That's the beauty of preamble. But preamble, one more important fact, was the last item voted upon in the Constituent Assembly. What does that mean? Every single article of the Constitution was debated, thoroughly discussed in the Constituent Assembly and then voted upon. Similarly, preamble was also discussed, voted upon. In fact, it was the last item to be added to the Constitution to ensure that whatever Constitution we have created, enacted, drafted, it does not violate the principles of the preamble. We will check it at the end. But is this preamble part of the Constitution? Yes, it is an integral part of the Constitution. Can this preamble be amended? Yes. Amended subject to basic structure. Subject to basic structure. Secularism is part of the basic structure. Can tomorrow preamble be amended to say we the people of India have solemnly resolved to constitute India into a sovereign, socialist, secular Islamic state or a secular Hindu Rashtra? It cannot be done. Why? Because secularism is part of the basic structure. You cannot amend the preamble to violate the secular principles. Right? You can enrich it. Enrich it in the sense without disturbing the basic structure. You can add more features to the preamble without disturbing the existing ones. For example, by adding the word socialist, did it have any impact on the sovereign nature of the Indian state or the republic nature of the Indian state? No. So you could add sovereign, socialist, secular, democratic, republic. So you can add socialist without disturbing the democratic, republic and the sovereign natures of the Indian state. So you can enrich the preamble, amend it subject to basic structure. Clear? Any questions? Okay. Now let's look at part 1 of the Constitution, Union and its territory. Article 1 says, India, that is Bharat, shall be a union of states. Which means we have a dual name for this country, India as well as Bharat. Which means to respect the sensibilities of the people, one traditional name, one modern name. India, that is Bharat, shall be a union of states. Is this term union of states? One question for you. Does it include union territories or does it exclude union territories? Sir, what are you trying to say? And ask. India, that is Bharat, shall be a union of states. This term union of states, does it include UTs or exclude UTs? It excludes UTs. Why? Because we say this union of states concept is a federal concept. Federal concept means that ours is a federal polity. Federal polity means dual government, distribution of powers. Where do we have dual government? Where do we have distribution of powers? That is with respect to states, the 28 states that we have. Union territories are directly controlled by the center, administered by the center. Who makes laws for these union territories? Parliament. Who administers these union territories? President of India. Yes, there are exceptions such as Delhi, Puducherry, Jammu and Kashmir. But even then, the real power is with the center. So there is no dual government distribution of powers when it comes to union territories, which means these union territories are not included in this phrase union of states. Dr. Ambedkar was asked, why did you use the term union of states? Is that an admission that our constitution is unitary and not federal? He said, no, our constitution is federal. But I've used the term union of states, this phrase, for two reasons. Number one, India is not the result of an agreement between states. So if we look at United States, there were 13 British colonies which came together because of the American War of Independence, and then they decided to come together through an agreement or a treaty and create a political entity called United States of America. That has not happened in India. So India is not created because states got together through an agreement, through a treaty to create this Republic of India. No. And second, no state has the right to secede from the Union of India, which means India is an indestructible union. No state has the right to come out of the Union of India. No state has the right to secede. There is no such thing, no such concept as plebiscite, which is recognized by the Indian Constitution. India, that is Bharat, which means two names, dual name, shall be a union of states, which means this phrase does not include UTs. But union of states is same as federation of states, according to Dr. Ambedkar. The names of all the states and union territories will be specified where? In first schedule. So there is the first schedule of the Constitution which talks about the names and details. It's not only names. For Assam, what is the geographical spread of Assam? Which parts of Assam, which parts of this territory constitute Assam? That description is also provided in the Schedule 1 of the Constitution. So Schedule 1 talks about the names and details of 28 states and 8 union territories. Right or wrong? Right. The same Article 1, it says that in India we can have states, or we can have union territories, or what we can have acquired territories. This can be a potential statement for your prelims examination. Constitution talks about which of the following entities: states, union territories, acquired territories. Yes. But then Parliament has the power under Article 2 to admit into union or establish new states on such terms and conditions as it thinks fit. For example, Sikkim. Sikkim was initially admitted as an associate state in 1975. And then it was converted into and upgraded to a full-fledged state in India. If associate state is not mentioned in the Constitution, because Constitution only talks about states, union territories and acquired territories, how can the Parliament admit Sikkim initially as an associate state? That's the beauty of Article 2. Parliament may, by law, enact a law, admit into union, that means from outside the territory of India. So Article 2 will be used when you are admitting a territory from outside the territory of India. When you are admitting the territory from outside the territory of India, On what terms do you provide for this particular entity? That Parliament will decide. Parliament decided that we will make Sikkim an associate state, even if it is not provided by the constitution. So what? On such terms and conditions as it thinks fit. Then we have Article 3. And this Article 3, I told you previously, is one of the centralizing tendencies of Indian federalism. Centralizing tendency in the sense, who has the power to bifurcate a state, trifurcate a state, merge states, increase the area of a state, decrease the area of a state, alter the boundaries of the state, change the name, alter the name of the state as well. For example, Kerala will now become Keralam. Under which provision of the constitution? Parliament has that power to enact a law under Article 3 of the constitution. Now listen to me carefully. Does this Article 3 also give power to the Parliament to establish union territories? Yes. This is the power available with the Parliament under Article 3. That when you are separating a state, you can convert a part of that state into a union territory. That is provided under Article 3. But there is some consultation which is crept into Article 3. What is this consultation? Listen to me carefully. How can you do this? Increase the area, decrease the area, alter the boundaries, change the name, merge the states, bifurcate the states, split a state. How can you do this? And who can do this? Parliament. How? By enacting a law. But for that, first you need a bill. What is a bill? Bill is a proposal. The proposal is to bifurcate Uttar Pradesh, or bifurcate Andhra Pradesh, or bifurcate Jammu and Kashmir. There's a proposal. Once it is passed by both houses of the Parliament, assented to by the President, then this bill becomes a law and this law would be implemented. Bill is a proposal. This bill has to be introduced in the Parliament. Listen to me carefully. But this bill cannot be introduced in the Parliament without the prior recommendation of the President of India. So basically, this bill will be cleared by the Union Cabinet. Bill will be cleared by the Union Cabinet. Now, Union Cabinet will have to introduce this bill in the Parliament. But you cannot unless and until you seek prior approval, recommendation of the President. You go to the President, President Murmu, we want to bifurcate the state, we need your approval. Please give us your approval so that we can introduce this bill in the Parliament. President will say, no, I am bound by the Constitution to consult. Consult whom? That state which is going to be affected by this bill. So if you are bifurcating Andhra Pradesh, I will send this bill to the Andhra Pradesh legislature and seek views of Andhra Pradesh legislature. Views. In what time? That time period is not mentioned in the Constitution. But that time period will be specified by the President. Which means a bill which talks about reorganizing Andhra Pradesh is cleared by the Union Cabinet. Union Cabinet wants to introduce this bill in the Parliament. But before that, you need the approval, the recommendation of the President. We go to the President. President says, hold on. I'm going to refer this bill to the Andhra Pradesh Legislative Assembly because it is going to be affected by this bill. And I will tell them, seek their views on this bill. In what time? How much time should I give them? That I will specify. Give me your views on this bill in 10 days, in 15 days, whatever it is. Time period is not mentioned in the Constitution, but this time period would be specified by the President. But once these views are given to the President, President can then give approval to this bill to be introduced in the Parliament. But what if these views which the President has received from the state, the views are Please don't bifurcate the state. We reject the bifurcation. These views are not binding on the president. These views are not binding on the president, which means president can still give a go ahead to the government. Government will introduce this bill in the parliament. Trap points for the prelims. In parliament, should it be introduced first in Lok Sabha and then in a Rajya Sabha? Or since it involves reorganization of a state, Rajya Sabha is the federal chamber of the parliament. It represents the interest of the states in the parliament. This bill necessarily has to be introduced in the Rajya Sabha. Where? This bill can be introduced in either of the two houses of the parliament. Either in Lok Sabha first or first in Rajya Sabha. Or first in Lok Sabha, then in Rajya Sabha. Or Rajya Sabha and then Lok Sabha. And this bill requires simple majority in both the houses. And once this bill receives simple majority in both the houses, it is then sent to the president for her assent. And once she gives the assent, this bill becomes the law. And that is through this law, Parliament can reorganize the states in India. Right? Language has been an important issue. There were various committees set up. For example, Dar Commission. For example, JVP Committee. For example, States Reorganization Commission. A 3-member commission consisting of Fazal Ali, H.N. Kunjru, K.M. Panikar. JVP committee is the acronym for Jawaharlal Nehru, Sardar Patel, Vallabhbhai Patel and Patabi Sitaramaya. Both Dar Commission as well as JVP committee rejected language as the basis for the states reorganization. Should states be carved out in the name of language? Dar Commission of 1948, JVP Committee of 1948 rejected it. They said, no, not on the basis of language. Then on what basis? On the basis of administrative convenience. What is this administrative convenience? For example, Bengal was partitioned in 1905. What was the reason Bengal was partitioned in 1905? Option number 1, to divide Hindus and Muslims. Option number 2, to displace Calcutta as the center of the revolt against the British Empire. Option number 3, administrative convenience. Option number 4, all of the above. What is the right answer? What's the right answer? The right answer is administrative convenience. Why? Hidden motive was, ulterior motive was to divide Hindus and Muslims. Hidden motive was to displace Calcutta as the center of the revolt against the British Empire. But Britain did not say that we are partitioning Bengal because of these reasons. They said administrative inconvenience, because Bengal is such a massive province that it becomes very difficult to govern it. To govern it better, for administrative convenience, we are going to partition Bengal. Dar Commission, JVP committee also said administrative convenience should be the basis for reorganizing the state and not on the basis of language. But States Reorganization Commission, which was set up in 1953, which gave its report in 1955, it said language can be the basis for reorganization. But what it did, it rejected one language, one state formula. What is this one language, one state? Which means inherent within the recommendation is administrative convenience. Because if for one language we give one state, Then this one language becomes one state. The state may become massive. For example, by that logic, the entire North India would be one state because these are Hindi speaking areas. No, we can have multiple Hindi speaking states. We can have states in the name of language, Hindi, but we can have multiple states, not just one state. Why? Because then it will become administratively difficult to govern that state. Administrative convenience, but yes, language can be the basis for reorganization according to States Reorganization Commission. Right? Then it was on the basis of the report of the States Reorganization Commission that States Reorganization Act of 1956 was passed. 14 states and 6 union territories were carved out. It was on the basis of the States Reorganization Act that zonal councils were established. And these zonal councils are now statutory bodies. And these zonal councils I have covered in that video where we covered all the non-constitutional bodies. Right? Perfect. Let's look at another chapter, citizenship. Very important chapter for this year's examination. First, let's look at the constitutional provisions. Then we will look at the Citizenship Act. Citizenship, it's covered under Part 2 of the Constitution. But basically, who can be the citizen, who cannot be the citizen? How can you acquire citizenship? How can you lose citizenship? That Constitution has said this power should be given to the Parliament under Article 11. Who can become the citizen of India? Who cannot become the citizen of India? How do we regulate the matters related to citizenship? This Constitution has said this power should be given to the Parliament. Parliament can invoke Article 11, enact a law, and regulate all matters related to citizenship. Then what is the purpose of Part 2 of the Constitution? It talks about status of citizenship at the time of the commencement of the Constitution. Now, when did the Constitution commence? For citizenship matters, it commenced on 26th of November 1949. When Constitution was enacted, related to citizenship provisions, 26 November 1949. For the rest of the provisions, 26 January 1950. But whether you are a citizen or not at the time of the commencement of the Constitution, now, right now, for that we have Part 2 of the Constitution. After the commencement of the Constitution, it is for the Parliament to decide by enacting a law under Article 11 of the Constitution. For example, Article 5 talks about citizenship at the time of the commencement of the Constitution. Right now, are you a citizen? If you were born in India, you are a citizen. If you were residing within the territory of India immediately 5 years before, that means for 5 years you were residing within the territory of India, even if you were not born in India, you are a citizen. Then what will happen to those who have migrated to India from Pakistan? Because Article 5 talks about citizenship of those who were born within the territory of India or those who have been residing within the territory of India for 5 years. You are the citizen of India. But what about those who migrated from Pakistan? There was a massive migration of the people from what became Pakistan to India and from India to what became Pakistan. If you have come back to India before 19th of July 1948, you are the citizens of India. So what will be the citizenship of those who migrated to India from Pakistan? If you have migrated back before 19th of July 1948, you are the citizens of India. What about those who migrated to Pakistan? If you have migrated to Pakistan after 1st of March 1947, You are not the citizens of India. Because there was migration. Migration into India, migration out from India. Out migration, in migration. If you migrated from Pakistan to India, you have deadline, you have a cut-off time, 19 July 1948. Migrate before that, you will become the citizen of India. But sir, you're talking about in retrospective. Because this is not the provision that we have drafted in 1948. This is the provision that we have drafted and adopted in 1949. Yes. So retrospectively, we said, whoever migrated to India from Pakistan till 19 July 1948, you are the citizen of India. Whoever migrated from India to Pakistan after 1st of March 1947, you are not the citizen of India. But what about those who are born in India or born to Indian parents, but they are now residing abroad? They have not acquired citizenship of any other country, but they are residing outside the territory of India. You can also become the citizen of India provided you register there. We will have an Indian embassy, we will have an Indian consulate, register there, you can become the citizen of India. India does not recognize dual citizenship. Now, is this something which Constitution has prohibited? Or is this something that legislature has prohibited through a parliamentary law, through a statutory law? Constitution also, Article 9. Any citizen who voluntarily acquires the citizenship of a foreign state will not remain the citizens of India. That's Article 9. Now listen to me carefully. Part 2 of the Constitution talks about citizenship at the time of the commencement of the Constitution. After that, Parliament has to enact a law. Under Article 11, that's the power available with the Parliament. But if you are a citizen of India according to Article 5, 6, 7, 8, 9, 10, will you remain the citizen of India according to Citizenship Act as well? That is for the Parliament to decide. But what Constitution says? Yes, if you were given citizenship because of Article 5, 6, 7, 8, you will continue to have the citizenship even after the commencement of the Constitution, but that would be subject to this law. Subject to the law enacted by the Parliament under Article 11, which means who has the unfractured power to regulate all matters related to citizenship. That power is available with Parliament under Article 11. Right or wrong? Right. And this is the law. This is the provision which was invoked by the Parliament, used by the Parliament, and that's how the Citizenship Act was passed, enacted by the Parliament in 1955. And it is this law which talks about acquisition of citizenship, loss of citizenship, so on and so forth. Let's now talk about who can become the citizen of India. You can become the citizen of India by birth. But listen to me carefully. There is something called Jus Soli and Jus Sanguini. How do we determine citizenship? You are born on the soil of a country. Regardless of who your parents are, doesn't matter. You are born on the soil of our country, you are the citizen of my country. If you are born on the soil of my country, and I will not look into whether your father or mother or grandfather, grandmother, whether they were citizens or not, I will not go into that. I will just have a relationship with you. You were born on the soil of my country, I will give you citizenship. If a country follows this principle, we say this is the principle of Jus Soli, law of the soil. But there are countries where no matter where you are born, even if you are born here or you are born outside the territory of my country, doesn't matter where you are born. So your place of birth will not be the most important factor. What will be the most important factor is who your parents are. Are you related to my country through blood? Through the blood of your parents. We say that those countries follow the principle of jus sanguinis, law of the blood. We were following the principles of jus soli ever? Or we were always following the principle of jus sanguinis? Till 1987, we were following the principles of jus soli. Which means till 1987, the position of the law was, according to the Citizenship Act 1955, if you were born on the soil of India, we will not ask who your father is, who your mother is, whether they were Indians, they are Indians or not, doesn't matter. You were born on the soil of India, you are a citizen by birth. Then after 1987, the law changed. Till 2003, we said, no. Not only if you were born and at least one of the parents should be an Indian. At least mother should be an Indian or a father should be an Indian, which means we move towards the concept of jus sanguinis. Then the policy makers realized that there is another problem. Illegal migrants come from outside the territory of India. They marry an Indian and children are born. These children are also the citizens. Because at least one of the parents is an Indian, but the other is an illegal migrant. This can be a security nightmare for us. That is why the law was amended in 2003, and the amended law says, now if you are born on the soil of India, you can become an Indian provided both parents are Indians, or one parent is an Indian and the other is not an illegal immigrant at the time of the birth. So right now, if the child is born, we will look into, is this child born on the soil of India? Yes, but that does not guarantee citizenship. We then have to look at what is the relationship of the parents. Are they Indians? Then this child is an Indian. If one of the parents is an Indian and the other is a legal migrant, foreigner, legal, the child is an Indian. But if one parent is an Indian and the other is an illegal immigrant, this child will never become the citizen of India by birth. So this is by birth. Then by descent. You are not born on the soil of India. You are born outside the territory of India, but to an Indian parent. Or both the parents are Indians. But you want this child to remain the citizen of India. What you do, the child is born, let's say in United States of America, you go to the US Embassy, Indian Embassy in US or consulate in US. You register the birth of your child within 1 year of the birth. Within 1 year of the birth, you register the birth of this child at an Indian Embassy or consulate in United States. The child is an Indian. We do not recognize dual citizenship, but this is the only instance in which dual citizenship is recognized. Recognized why? How? The child is born not in India. The child is born outside the territory of India. And in that country which recognizes dual citizenship, for example, United States, Canada, Australia, New Zealand, more than 100 countries of the world, they recognize dual citizenship. If a child is born outside the territory of India to an Indian parent in a country where they recognize dual citizenship, this child will have a dual citizenship of that country as well, Indian citizenship as well. But when you fill this form, as a parent, when you fill this form, that I want my child to retain the citizenship of India, you have to specify that this child is not holding the passport of any other country. You have to hold only the Indian passport. You may be citizen of both the countries, but passport should be Indian. Does that mean this child born outside the territory of India to an Indian citizen remains dual citizen forever? No. Only till the child now turns 18. Now that you have turned 18, now that you are a major, You have 6 months to decide whether you want to continue only as the citizen of India or you want to continue as the citizen of that country. You cannot now continue to hold dual citizenship. So dual citizenship only in those instances where the child is born outside the territory of India to an Indian parent in a country which recognizes dual citizenship, but this is only valid till you turn major. Once you turn 18, you have 6 months to decide whether you want to continue with the Indian citizenship or you want to continue with the citizenship of that country. But there are other ways also. For example, registration. Someone marrying an Indian, but this person is neither born in India nor born to an Indian parent outside, but this individual is married to an Indian. Don't worry. Come to India, stay in India for 7 years, and you can apply for citizenship through registration. Naturalization. You are not born in India, not born to an Indian parent outside, you are not even married to an Indian, or there is no way you can register to become the citizen of India, because marriage is not the only way in which you can register as the citizen. There are other ways also, other conditions also, or should we say, for some other groups of people, you can apply for citizenship through registration. For example, you are holding this card, OCI, Overseas Citizen of India. This Overseas Citizenship of India, it's a scheme under the Indian Citizenship Act of 1955, where you are a foreign national. So OCIs are foreigners. If you are holding the OCI card, does that mean you are an Indian? No, these are foreign nationals. But these foreign nationals may once have been Indian citizens. But they went to other countries, they renounced their Indian citizenship. Now they are foreign nationals. Or they were eligible to become the citizens on 26th of January 1950. Who was eligible to become the citizen on 26th January 1950? If you were born on the territory of India, but you are now outside. Or your parents were born within the territory of India, but you were born outside. You could have registered the birth of your child at an Indian embassy or a consulate outside, but you did not. So you were eligible, but you did not apply for citizenship. Or you were citizen once, but now you have renounced your Indian citizenship. You are a foreign national. You still contribute to India through remittances. You still contribute to India through soft power. So we will give you, under the Citizenship Act of 1955, a card called OCI card. You are an OCI card holder. You can enter India without visa for life. Or you can say this is your lifelong visa. You don't have to ask for visa every time and each time you enter India. You don't have to report to police or FRRO each time you come to India. No, these are some of the benefits that we are giving you. But can OCI card holder buy agricultural land? No. Can he do journalism activities in India? No. Research in India? No. You have to take the permission of the government for that. Can you go for mountaineering, trekking? No. You have to take the permission of the government of India. But you, OCI card holder, is a foreign national. Now this foreign national wants to become the citizen of India. Is there any way? Yes. What is the way? Registration. What registration? You come to India, stay in India for 5 years, and then you can apply for Indian citizenship. Through registration, there are multiple sections of the people who can get citizenship. One is OCI. The other is if you're married to an Indian. But what if you don't have an OCI card, you're not married to an Indian, you were not born in India, you are not born to an Indian parent outside India, but still you want to become the citizen of India. You love this country. There is an option, naturalization. But under naturalization, there are strict conditions. If you want to become an Indian citizen through naturalization, and that is how Professor John Drays, Mother Teresa, Adnan Sami, they became the citizens of India through naturalization. There are some conditions. Conditions are, you should not be from a country where Indians are not allowed to become citizens. You should have a knowledge of any language mentioned in the 8th schedule of the Constitution. You have to renounce your previous citizenship. You have to stay in India for 14 years. And then you can apply for Indian citizenship through naturalization. But listen to me carefully. Very important point. Very, very important point. Extremely important point. Central government. Which ministry is responsible for all these citizenship matters? Ministry of Home Affairs. I told you there are some conditions that you need to fulfill if you have to apply for Indian citizenship through naturalization. The central government can waive off any or all such conditions. Now listen to me carefully, very carefully, very carefully. Technical point, but listen to me. If I'm somebody who has performed well and contributed in the field of world peace, art, human progress, scientific advancements. For example, Albert Einstein wants to become an Indian through naturalization. Will the central government tell him, no, you come to India, stay in India for 14 years, learn Hindi, and then we will give you citizenship? Albert Einstein wants to become the citizen of India, provided he's alive. He's not. I'm just giving you an example so that you understand. Or let's say Lionel Messi wants to become an Indian. He doesn't even understand English, or he doesn't speak English. Should we tell him that, no, you come to India, stay in India for 14 years, learn Hindi, and then you can become an Indian citizen after 14 years? No. The central government can waive off any or all such conditions. Does that mean that Lionel Messi can stay on as the citizen of Argentina as well and the citizen of India as well? Yes or no? Strictly according to the law. The law is clear. The central government can waive off any or all such conditions. Maybe one of these conditions can be you can stay on as a dual citizen. Possible. The central government can waive off any or all such conditions. That you can stay on as the citizen of Argentina as well, the citizen of India as well. Possible. If you have contributed gloriously, spectacularly in the field of art, literature, human progress, scientific development, world peace, so on and so forth. So one way in which you can become the Indian is by birth, other by descent, other by registration, other by naturalization. Or if you cannot become the Indian by birth or descent or naturalization or registration, even then you want to become the citizen of India, you can only hope and pray that your country is acquired by India. That's the only way in which you can become an Indian. So when India incorporates a foreign territory, then you can become the Indian citizens. But listen to me carefully. Tomorrow, for example, India incorporates Pakistan, which is a foreign territory, and now Pakistan becomes the part of the territory of India. Does that mean every Pakistani automatically becomes the citizen of India? No, central government will have to specify. The central government will have to specify and say that these are the people who will become the citizens of India. Others, no. So Field Marshal, no matter how many titles you give yourself, we will specify that once your territory is acquired, Asim Munir is not the citizen of India. Hafiz Saeed is not the citizen of India. Imran Khan is not the citizen of India. Maybe the performers of the Coke studio, yes, you can become the citizens of India. So the central government will have to specify who are the people of this territory we have acquired, incorporated, who are these people who will become the citizens of India. That does not mean automatically all the citizens of the country which you have incorporated or the territory you have incorporated become the citizens of India. These facts are extremely important for your prelims exam. Right? Great. But if there are 5 ways through which you can acquire Indian citizenship, there are 3 ways through which you can lose as well. One is by renunciation, and that's how lakhs of people do each year. According to the Home Ministry data, 2,15,000, 2,75,000. These are the individuals who every year renounce their citizenship. That means renunciation is a voluntary act. I want to acquire the citizenship of another country. Since India does not recognize dual citizenship, I will give up voluntarily my Indian citizenship because I have acquired the citizenship of another country. But what if I have a minor child when I renounce my Indian citizenship? This minor child also loses Indian citizenship. But now this minor child attains the age of 18. Minor child attains the age of 18 and suddenly watches a movie, Swades, Ye Jo Desh Hai Mera. Suddenly becomes emotional and patriotic and wants to come to India and generate electricity for farmers and for the rural people. Can this individual who was once Indian citizen, listen to me carefully, can this child who is now a major, who was once an Indian citizen, but because of the fault of their parents, he or she lost her citizenship. Now you come back to India after you have attained the age of 18, you can resume your Indian citizenship. Which means you can register again and become the citizens again. Renunciation. Second is termination. Now what's the difference? I voluntarily acquire citizenship of another country. But I want to convey to central government as well that, hey boss, I have acquired the citizenship of another country. Since you don't recognize dual citizenship, I am voluntarily giving up my Indian citizenship. So I convey. What if I don't convey? What if I don't convey? Law has to be precise. Law has to be categorical. That the moment you acquired Indian citizenship, the moment you acquired foreign citizenship, on that date itself, your Indian citizenship is terminated. And that's what termination is. When does your citizenship get terminated? When you acquire the citizenship of a foreign country. Even if you don't renounce it, it is still terminated. But can you voluntarily give up your citizenship through war at the time of war? No. During wartime, the central government may say, we will not accept your renunciation. This fact is important. But if you can lose your citizenship voluntarily through renunciation or through termination as soon as you acquire the citizenship of another country, is there any other way in which you can lose your citizenship? The third way is deprivation. Now, what is deprivation? Listen to me carefully. You are giving it up voluntarily, renunciation. You have acquired the citizenship of another country, but you have not given up Indian citizenship. Your citizenship is terminated. But now you have not acquired citizenship of any other country. You are only the citizen of India. But the central government realizes that you acquired citizenship of India through fraud. Acquired? Can you acquire citizenship through birth? No, you're entitled to citizenship through birth if your parents are Indians. That's your entitlement. Or through descent. Which means who can be deprived of citizenship? Only those, listen to me carefully, only those who acquire citizenship through registration or naturalization. If you have acquired citizenship through registration or naturalization, but for registration and naturalization, there are some conditions which you need to fulfill. You have to stay in India for 14 years. Not necessarily you have to stay in India throughout 14-year period. That means you should have never left this country, but you should have stayed in India for 11 of these 14 years. For that, your entry into India, exit into India, all this is documented. What if you give false declaration? What if you hide facts? We told you that you have to give up your Indian citizen, you have to give up your previous citizenship once we give you Indian citizenship, but you have not done that. We told you that one of the conditions is you should have a working knowledge of any language mentioned in the 8th schedule. You said, yes, I have a working knowledge of Hindi, but that's not the working knowledge that you have. You have faked it. You have misled us. Or you were convicted in any country, and here you told us that you are a clean person. You have not been convicted at all. Now we got to know that you have been convicted. We will deprive you of your Indian citizenship. If you are disloyal to the Constitution, if you are out of the country for 7 years continuously, and you are not a student of any university, or you are not working somewhere else, and you are not every year, even if you go outside, every year you have to make your presence felt. You have to tell the Indian government that I want to retain my Indian citizenship by filling a form at an Indian embassy or a consulate. You acquired Indian citizenship through registration or naturalization. But within 5 years of you becoming the citizen through naturalization or registration, you have been convicted in any country, not only India, any country, and sentenced to a jail term of not less than 2 years. If that's the case, we will deprive you of your Indian citizenship. Renunciation is clear. Termination is clear. Deprivation is what? Can an Indian citizen by birth be deprived of his citizenship? No. Can an Indian citizen by descent be deprived of his citizenship? No. Who can be deprived of the citizenship? If you have acquired citizenship through registration or naturalization. On what basis? If you are disloyal to the Constitution. If you have been convicted in any country and sentenced to not less than 2 years in jail. If you acquired citizenship through concealment of facts, through misrepresentation, through fraud, if you're disloyal to the Constitution, if you're out of the country for 7 years continuously, you will lose your citizenship through deprivation. Right? Great. Now there is another concept which is similar to citizenship called domicile. There is only one citizenship and only one domicile. Are you a citizen of India and citizen of Maharashtra? No, you are only the citizen of India. You may be a resident of Maharashtra, but you are only the citizen of India. There is no dual citizenship. Are you a citizen of India and domicile of Karnataka? According to the court, you have only one domicile, which means you are domiciled within the territory of India. Your domicile within the territory of India. Then what is this domicile? Court has said you can use this concept domicile to get admission in engineering and medical colleges, to get admission in educational institutions. What is domicile? Number one, this term has not been defined in the Constitution. This term is not the same as that of residence. You are currently residing in Karnataka, but your roots are in Bihar. Can you become the domicile of Karnataka just because you're residing in Karnataka right now? No. Domicile means permanent home, which means residence plus the intention to reside there for an indefinite period. You were born in Delhi, but then you migrated to Maharashtra, in Mumbai. Now in Mumbai you're residing. But you have been residing in Mumbai for so many years that we can assume that your intention is to reside in Mumbai for an indefinite period. You can become the domicile of Maharashtra, and as such get favorable admission criteria in colleges and universities in Maharashtra. This is the purpose why domicile can be used according to the court. But domicile can be of two varieties. Domicile of origin, which is same as that of your birth. You were born in Delhi, and by logic you stay in Delhi. By logic you are working in Delhi. So you are the citizen of India and you are a domicile within the territory of India and the domicile of Delhi, because you have made Delhi your permanent home. You want to reside in Delhi for an indefinite period. But from Delhi you shifted to Karnataka. Now you have resided in Karnataka for another 5 years, 10 years, 15 years. That means now your animus menendi, your state of mind has changed. Now you have, through your choice, opted for Karnataka, Bengaluru, and you have stayed there for 15 years, which means now your intention is to reside in Karnataka for an indefinite period. Karnataka can become your domicile. But as a concept, you have to keep in mind there is only one citizenship, there is only one domicile. You are a domicile within the territory of India. But domicile certificate of Karnataka, Maharashtra will help you get admission in educational institutions. That's it. Otherwise, domicile will have no place whatsoever. Mr. Rahul Gandhi's citizenship may be under doubt because a matter is in the court. Court initially asked for, allowed an FIR, later on backed out. But whatever it is, if you acquire Indian citizenship through registration, through naturalization, you have to be administered oath. And how is that oath? For example, I, AB, do solemnly affirm or swear that I will bear true faith and allegiance to the Constitution of India as per the law established. For constitutional functionaries, Prime Minister, President, the oath says, I will faithfully discharge the duties of my office. I will defend the Constitution and the laws. Right? Here, as a citizen, you have to take oath that I will faithfully observe the laws and fulfill my duties as a citizen of India. So duties for citizenship, there is a give and take. Give and take in the sense, state and the citizen. A symbiotic relationship. State confers benefits on the citizens. Citizens have duties towards the state. This symbiotic relationship is what defines citizenship. And you have to take an oath that I will fulfill my duties as the citizen of India and I will observe the laws. But if there is an individual whose citizenship is in doubt, according to the Citizenship Act, a certificate of citizenship can be issued by the central government. You are doubting his citizenship, Rahul Gandhi's citizenship. Central government, which means Home Ministry, will give a certificate, will issue a certificate, and certificate say that this particular gentleman, Mr. Rahul Gandhi, whose citizenship of India is under a doubt, we certify that he is a citizen of India. This certificate can be given by the central government. This is called certificate of citizenship in case there is a doubt on your citizenship. This is a crucial, very important point for your prelims examination, right? And this more or less completes our discussion on citizenship. Any doubts, any questions, please let me know. Any doubt? No. Okay. Let's look at part 3 of the Constitution dealing with fundamental rights. Fundamental rights, you need to know, these are limitations on the powers of the state. We say these are negative obligations. Negative obligations in the sense, look at the wording of these fundamental rights. The state shall not deny equality. The state shall not discriminate. The state shall not deprive an individual of his right to life and personal liberty. The state shall not do this. The state shall not do that. What is this that the state cannot do? Violate fundamental rights, because these are negative obligations on the state, limitations on the powers of the state. Constitutionalism. But who is the state who cannot violate your fundamental rights? And who is the state? You can drag this entity to the court if the state is violating your fundamental rights. That definition is provided under Article 12. And state includes the government of India, the legislature of India, the union legislature, the government of a state and state legislature, local authorities, and other authorities. Other authorities mean if there is an entity which is sufficiently funded by the government, it's a state. If there is an entity which has a monopoly character, it is a state. If there is an entity where the state has a control in terms of appointment, removal, that's a state. If there is an entity which performs governmental work, the character is governmental. For example, educational institutions, hospitals, they perform work which is governmental in character. It is a state, and you can drag them to the court if they violate your fundamental rights. Long story short, what is the state and who is the state which cannot violate your fundamental rights? On whom there is this limitation that you cannot trespass on the rights given to the people under Part 3. That definition is provided under Article 12 of the Constitution. Article 13 talks about 4 things. And listen to me carefully. When was the Constitution enacted? 26th of January, 1950. This is how Part 3 entered into force, Constitution of India entered into force. But prior to this date, there may be laws in force prior to the commencement of the Constitution. What if these laws violate fundamental rights? Can these laws continue even after the commencement of the Constitution, even if they violate fundamental rights, but because they were enacted prior to the commencement of the Constitution? No. Laws which are in force prior to the commencement of the Constitution, as long as they are in agreement with fundamental rights, these laws will continue. The moment they violate the fundamental rights provided under Part 3, they cannot continue at all. But that does not mean this entire law cannot continue. This is where you need to understand a concept called doctrine of severability. Doctrine of severability in the sense, God forbid, if you believe in God, there is some poison in your arm. And the potential is that this poison may spread throughout your body and then you will die. You want to preserve your life. What is the only conclusion? What is the only option? Amputate your arm. Right? Similarly, here is a pre-constitutional law. And now this pre-constitutional law has various provisos, various provisions. 1 or 2 provisions are unconstitutional. In a sense, 1 or 2 provisions violate fundamental rights. Does that mean the entire law is not allowed to continue beyond 26 January 1950? No. only those provisions which are violative of fundamental rights will be severed, which means they won't enter into force. The remaining ones can continue to operate. That's provision number 1. Provision number 2. Constitution says that the state, and I don't have to now tell you who is the state. State under Article 12. This state cannot delete, cannot abridge, modify fundamental rights. And this phrase, abridge, was asked in one of your prelims examination last year, and suddenly people got confused. Where is this word coming from? This word is in the bare act. The state shall not delete a fundamental right, abridge a fundamental right by enacting a law. But what is this law? Law can be an act, law can be regulation, law can be custom, usage, notifications, bylaws. Which means through such laws, state cannot delete, abridge fundamental rights. But there is an exception to this law. And the exception is a Constitutional Amendment Act under Article 368 of the Constitution. Which means, number 1, Article 13 talks about pre-constitutional laws. Can these pre-constitutional laws continue even after the commencement of the Constitution? Yes, as long as you violate, as long as you are in agreement with fundamental rights. But can these pre-constitutional laws continue even after violating fundamental rights? No. Does that mean all these laws in their entirety are gone? No. Doctrine of severability. Only those parts, provisos, will be severed, cut, which violate fundamental rights. The rest will continue. But the state is under a limitation. Hey state, come here. Which is the state? State under Article 12. Don't you dare delete a fundamental right. Don't you modify a fundamental right. Don't you abridge a fundamental right provided under Part 3 of the Constitution. How? Don't you dare enact a law and delete, modify, abridge a fundamental right. But what is this law? Through an ordinary law, you cannot do that. Through an ordinance, you cannot do that. Through a custom, you cannot do that. Through regulations, you cannot do that. Through bylaws, you cannot do that. The only way you can do it is by enacting a Constitutional Amendment Act. Which means only through a Constitutional Amendment Act, you can delete, abridge a fundamental right. All fundamental rights? No. Subject to basic structure. For example, is right to property. Was right to property a fundamental right? Yes, it was. Was it deleted? Yes. Is that not violative of Article 13? Because Article 13 says the state shall not delete, modify, abridge fundamental rights. Under Article 368, you can do that, provided you are not disturbing the basic structure. Right to property was not part of the basic structure. Can Article 368 be invoked to delete right to life, freedom of speech and expression? Article 32, Article 14? No, because all these fundamental rights are part of the basic structure. Even by using Article 368, you cannot delete, modify, abridge these fundamental rights which are part of the basic structure. That's Article 13. Right? Let's look at Article 14 of the Constitution. There are various categories of fundamental rights. Right to equality, Article 14 to 18. Remember the article numbers, because a couple of times questions have been asked. For example, one question was right against untouchability is provided under which rights? Is it right to equality? Is it right against exploitation? Is it right to constitutional remedy? Is it right to freedom? Right to equality. Article 14 to Article 18 talks about right to equality. Article 19 to 22 talks about right to freedom. 23 and 24 talks about right against exploitation. 25 to 28 talks about religious freedom, right to religious freedom. 29 and 30 talks about cultural and educational rights. Article 32 talks about right to constitutional remedy. These facts you will have to remember. This is very important. So in the first category of right to equality, we need to understand Articles 14 to 18 dealing with right to equality. Article 14 is available to any person, which means this fundamental right is available to aliens as well as citizens. Fundamental rights are not exclusively for citizens. There are fundamental rights which are available to both citizens as well as foreigners, aliens. But yes, there are some fundamental rights which are exclusively available to citizens. Which are these fundamental rights which are exclusively available to citizens? Article 15, 16, 19, 29, and 30. But Article 14, it says the state shall not deny to any person, which means to aliens as well as citizens. What? Equality before law, equal protection of the laws within the territory of India. This concept, equality before law, we say is negative. Equal protection of the laws, we say it's positive. Equality before law, borrowed from UK. Equal protection of the laws, borrowed from United States. Equality before law means three things. No special privileges. No matter who you are, no special privilege, because we will treat you equally. The law is equal for everybody, equality before law. Imagine it this way. This is a hospital. And then there are patients who are trying to enter the hospital. Right? One individual he has had a headache. Another individual, sudden drop in the sugar levels. Another individual has been hit on his head by a cricket ball. Another individual has met with an accident. I am the hospital. I am the doctor. Should I prioritize these cases? Or because you came first and you have a headache, I will have to first respond to you. Headache since when? Are you attempting prelims examination? That's why? Okay. What do? Multiple paracetamols? Okay. By that time, the person who has been hit on his head by a ball or who has met with an accident, they may die. I will say I cannot discriminate. Why? Equality before law. No special privilege no matter who you are. This is the negative concept, equality before law. But once we introduce this equal protection of the laws, I have to look at who needs my attention more. I will give you a privilege. Privilege is, I am right now examining this person who has had a headache. Okay, because of the prelims examination, what's your attempt? How many times have you prepared? Have you attended polity? Blah, blah, blah. And suddenly somebody says, doctor, what? There is a person critical. He has met with an accident. I'll say, beta, whether you give prelims or not, I don't care. I have to first take care of this individual who has met with an accident because I have to save his life. So I will leave you and I will directly try and attend to this person. Privilege is given to him. Why? Because like should be treated alike. Now, if this person would come to me, sir, there is another prelims aspirant who is also suffering from headache. I said, wait, I am right now dealing with this person because these are likes, same individuals in similar circumstances. If you are in similar circumstance, I will not discriminate. If you are in different circumstances, I will discriminate. That is positive discrimination. Positive discrimination, and that is allowed under Article 14 of the Constitution. Positive discrimination. Like should be treated alike. Those who are in similar circumstances should be treated similarly. But under Article 14, there are exceptions. When we say no special privilege, no matter who you are, everybody will be subjected to the same law. Nobody is above the law. There are some exceptions. Exceptions such as governor and the president. Listen to me carefully. What if there is a statement given in your prelims examination that the governor of a state and the president of India cannot be held answerable in any court of law with regards to the discharge of their official duties? Is this correct or incorrect? Correct or incorrect? This is correct. Despite the fact that Supreme Court in April 2025, a two-judge bench of the Supreme Court said something, it is still correct. You cannot be held answerable in any court of law with regard to the discharge of your official duties. Can you file a criminal case against a governor while they are in office? File a criminal case against the president while she is in office? No, because this is the immunity that is available to you under Article 361 of the Constitution. And this is an exception to equality before law. Within Article 14, we say there is another right called a right against arbitrariness. Sir, how are these concepts asked in the examination? For example, a question was asked. If a law gives unchecked power to the government, to the bureaucracy, which of the fundamental rights would be violated? Article 14. Why? Because Article 14 talks about right against arbitrariness. Right against arbitrariness in the sense, Chief Election Commissioner and Election Commissioner shall be appointed by the President. How? Constitution says for that Parliament should enact a law. This law was not enacted. Then what happened? CEC and Election Commissioners were appointed by the President based on the recommendations of the Prime Minister. But Election Commission is supposed to be a neutral umpire to hold and organize free and fair elections. How can this Election Commission, which is appointed by the party in power, organize free and fair elections, provide a level playing field? When you are appointed by the party in power, you are accountable to them. You are appointed because you may favor them. This sounds arbitrary. Matter went to the court. And in Anup Baranwal case, Supreme Court said this system of appointment is unconstitutional. Why? Because it violates Article 14. Because students don't realize how Article 14 is violated. Sir, Article 14 talks about equality. How is Article 14 principles violated by the way in which the CEC and election commissioners are appointed? If their appointment is arbitrary in the sense violating the common sense, arbitrary in the sense mischievous, arbitrary in the sense without logic, you are meant to uphold free and fair elections, safeguard free and fair elections. How is it possible that we can expect free and fair elections from you when you are appointed by the party in power? As such, it violates Article 14, which is right against arbitrariness. So Article 14, which is available to every person, talks about equality before law and equal protection of the laws. One is a positive, the other is a negative concept. One borrowed from UK, the other borrowed from United States. One talks about no discrimination whatsoever, no special privileges whatsoever. Everybody is equal before the law. Everybody should be subjected to the common laws. But equal protection of the laws talk about something else. Like should be treated alike. And here you need to understand the concept is called substantive equality. What is substantive equality? Listen to me carefully. Substantive equality focuses on the outcome. Outcome in the sense, same example. Prelims aspirant with a headache. Another individual with a spike in his sugar levels or a drop in his sugar levels. Another individual who has met with an accident and is in a critical condition. He may or may not survive. I need to prioritize. First priority will be this person who has met with an accident. I will ensure that your life is saved. Then the next priority to the sugar patient who has seen a drastic drop in the sugar levels. I may give you something to eat. I may give you a drink to drink first, maybe glucose or whatever, or just give you 2 spoons of sugar so that you can come back to your senses. And later I will give preference to the person who is appearing in the prelims exam and suddenly has a headache, because I know you will be having headache till the prelims examination and even beyond. The point is, I'm focusing on outcome. I want all of you to survive. If I give you paracetamol 10 minutes later, even then you'll be okay, you won't die. But if I attend to this person who has met with an accident 10 minutes later, maybe after that his life will be extinguished. So I am treating you differently, but not because I don't like you, not because of your religion or your race or your caste or your sex or your place of birth, but I want to focus on outcome. That's what we call substantive equality, which focuses on outcome. And the outcome that I'm focusing upon is I want all of you to survive. That's Article 14. Article 15 talks about, and again, it is applicable only to the citizens of India. Article 15 says, state is not allowed to discriminate only on the grounds of religion, race, caste, sex, place of birth. Again, I am a hospital. 3 patients. Now I am discriminating. This prelims aspirant, suddenly he has read the Constitution. He approaches the Supreme Court. My lord, I have been discriminated against. Why? By this doctor. I had a severe headache. He did not even attend to me. He went out. Maybe he had some urgency. No, I know. I've read the Constitution. He discriminated against me because of my religion, or because of my race, or because of my caste, or because of my sex, or because of my place of birth. Am I a state? I am a hospital. Performing a governmental function? I am a state within the meaning of Article 12. I will be dragged to the court. Supreme Court will ask, have you discriminated against him? Say, oh, this guy, prelims guy? Yes, I have. How dare you? Said, what? How dare you discriminate against him? He's saying you have discriminated against. I said, yes, I have discriminated against him. But I was not aware of his religion, race, caste, sex. I could make out, but you never know. Place of birth, I don't know. But I discriminated him on the ground that his condition was less severe as compared to the condition of the person who met with an accident. I discriminated him also on some other ground. If I would have discriminated against him only on this ground of religion, race, caste, sex, place of birth, then it was violative of Article 14. Which means, as a concept, does Article 15 prohibit discrimination? Yes. But you need to understand what form of discrimination. Only if it is on the grounds of religion, race, caste, sex, place of birth. But it does not bar the state from discriminating on other grounds. I can discriminate against you on the grounds of your medical condition. I can discriminate against you on the grounds of age. I can discriminate against you on the grounds of, let's say, your educational qualification. If you are trying to get recruited, or if you want to seek an admission in my school, I can discriminate on other grounds, but not only on the grounds of religion, race, caste, sex, place of birth. But even then, this Article 15 is not absolute, because there are some exceptions. Exceptions are, even then the state is empowered to make special provisions for the protection and the advancement of women and children. Even if there can be no discrimination on the grounds of sex, but that does not bar the state from making provisions for the advancement of women and children, for the special provision for women and children. And similarly, if there can be no discrimination on the grounds of caste, that does not prohibit the state from making special provisions for whom? Socially and educationally backward classes of citizens. Okay, that's Article 15. Article 16 talks about there shall be equality of opportunity in public employment. And Article 16, Clause 2 says the state shall not discriminate against its citizens. Now, this time the grounds have been increased to 7. Previously, there were 5 grounds: religion, race, caste, sex, place of birth. Now, there is residence as well, descent as well. Just because you belong to a particular religion, that should not disqualify you from a government job. So, the state shall not discriminate against any citizen only on these grounds. Does that mean state cannot discriminate at all? State can. On the grounds of age, on the grounds of merit, on the grounds of, let's say, educational qualifications. Suddenly a prelims aspirant who has now read the Constitution approaches the Supreme Court. My lord, UPSC has declared the result of those who have qualified for the mains examination. My name is missing. I have been discriminated only because of my religion, race, caste, sex, place of birth, descent, or residence. Supreme Court will ask UPSC, which is the state under Article 12, please come and defend yourself. Why have you discriminated against him? I said, I have. I said, but why? He did not even appear in the exam. Or he could not qualify the prelims exam. Or the age limit is 32 for a general category, he is 42. Or the minimum age limit is 21 and he is 19. Or minimum qualification is a graduate and he is still in his kindergarten. So on these grounds, I can discriminate. But only on the grounds of religion, race, caste, sex, place of birth, descent, residence, no. But listen to me carefully. If there can be no discrimination on the grounds of residence, exception is Parliament. What it can do? It can prescribe residence as a qualification for certain jobs. Is that constitutional? Yes. For example, if you are from Hyderabad, Karnataka region, known as the Kalyan Karnataka, Article 371, capital J. If you are from these regions of Gulbarga, Bidar, Bellary, Raichur and other, just because you happen to be the resident of these 6 backward districts of Hyderabad, Karnataka region, Kalyan Karnataka region, that becomes your qualification to apply for government jobs. So when, sir, you say Article 16 says there can be no discrimination only on the grounds of residence, how can then residence become a qualification? Because this fundamental right is not absolute. There are exceptions. And the exception is Parliament, not the state legislature. Keep that in mind. Parliament can prescribe residence as a qualification for certain jobs, but these jobs can only be at the state level, not union level jobs. Not union level jobs, only at the state level. Similarly, if there can be no discrimination on the grounds of caste, but for those who are socially and educationally backward, those who are economically weaker sections of the society, states can reserve seats for them in government jobs. And that is how 15% jobs are reserved for SCs, 7.5% jobs are reserved for STs, 27% jobs are reserved for OBCs, and 10% jobs are reserved for economically weaker sections of the society. Right or wrong? Right. But something else. For example, let's assume Parliament enacting Waqf Act and then saying whoever will be appointed as the chairperson of this Waqf board or with the members of this Waqf council, they shall be Muslims. State discriminating on the grounds of religion? by saying that for this particular job post, you should only be a Muslim, you should only be a Christian, you should only be a Hindu, you should only be a Sikh. Is that violative of the Constitution? No. Why? If Article 16, Clause 6. If what? If you are creating a body for that particular religion itself, for example, Waqf Board for Muslims, Gurdwara Prabandhak Committee for Sikhs, or Devasthanam boards for Hindus. If you are creating a body for such religious denomination, then you can specify that the persons who will be appointed to this body shall also profess the same religion. That would not be violative of Article 16. But if you say from now onwards IAS officers can only be Christians, that would be a violation of Article 16. Supreme Court has said in Indra Sani case, also known as the Mandal case, what Supreme Court has said? Number one, if you want to provide reservation to any group, you have to say and convince that these individuals that you are providing reservation to, they are socially and educationally backward. Otherwise, you can't provide them reservation. Second, even if they are backward, but they should not be adequately represented in the administration. Even if they are backward, the concept of creamy layer shall apply. Even if they are backward, reservation cannot exceed 50%. But this 50% is not a rigid cap. It can be breached even in exceptional circumstances. Right? And number 5, whatever you do, if you want to provide reservation, provide. But please ensure that you're not flirting with the efficiency of administration. You can't set the bar so low that when you recruit individuals, it's going to affect the efficiency of administration. Don't do that. If you satisfy these conditions, you can provide reservation. But sir, if the Indra Sani case, the Mandal case, Supreme Court said reservation cannot exceed 50%. How is it that now we have close to 59.5% reservation at the state at this level? Supreme Court said that this 50% cap is only for those who are socially and educationally backward. So for those socially and educationally backward, 50% is the limit. If you add more criteria, for example, economic backwardness, that does not mean 50% cap on economic backwardness also applies. That means all reservation should be subject to 50% cap. If you are providing reservation for socially and educationally backward class of citizens, 50% cap will apply. If you are providing for economic backwardness, you can exceed 50%. This is what the Supreme Court said when petition challenging EWS reservation was filed in the court. This is Article 16 of the Constitution. Now we will discuss Article 17 and 18 and then we will take a break. I'll take up your questions and then we will resume after that break. But stay with me for another 5-6 minutes, then we'll take a break. I understand you may have to go for lunch, eat something, but stay with me for these couple of minutes. Article 17 says untouchability is abolished and its practice in any form is forbidden. But this term untouchability, you need to understand, is not defined in the Constitution. And this term untouchability is not an English word in the Constitution. That means we are not referring to the literal meaning of this word untouchability. Which means if a civil services aspirant preparing for the prelims examination comes and says, sir, I want to sit with you, I'll say, go back. Don't touch me. Am I practicing untouchability? No. Disregarding the humor, if you are suffering from leprosy or during COVID-19, when the world was under a lockdown, when the nation was under a lockdown, we may impose restrictions on you that this particular hospital ward is only for COVID patients. Can a COVID patient approach the Supreme Court and say, my lord, Article 17 violated? What happened? Sir, untouchability being practiced at a massive level. Sir, I had COVID and I was kept in a separate ward. Supreme Court will say, take this person out. You have COVID and you are here, go. Sir, you are also at the Supreme Court, you too. You are practicing untouchability. This is not untouchability. Untouchability, number one, this term has not been defined in the Constitution, which means we are not referring to the literal meaning of this word untouchability. We are referring to the practice of untouchability, the historic discrimination practiced against the Dalits and the tribals in India. That untouchability is abolished and that practice is forbidden. And to implement this law, there is a law. To implement this provision, there is a law called the Atrocities Act of 1989. It is known as Atrocities Act, but the real title is the Scheduled Castes and Scheduled Tribes Prevention from Atrocities Act 1989. And under this law, there is a reverse burden of proof. Normally, the burden of proof is on the prosecution. The state will have to prove that you have committed this crime. But in Atrocities Act, if you are accused of committing atrocity, and what is this atrocity? You are garlanding a member of the Dalit community with chappals. You are tonsuring their head. You are shaving off their mustache, because these were the practices which were done previously. This is how you would torture the members of the scheduled caste and scheduled tribes. If you're socially boycotting the members of the Dalit and tribal community, all this is untouchability. And if you have been found if you are accused of untouchability under the Atrocities Act, you have to prove to the court of law that you have not committed this crime, that you have not resorted to untouchability. It's not for the state to prove that you are guilty. It's for you to prove that you are innocent. Reverse burden of proof. That's Article 17. And we say Article 17 is one of the absolute fundamental rights. No if, no but. It's not that untouchability is abolished, but Prime Minister can practice it. Supreme Court judges can practice it. It can be practiced under these circumstances. No. Article 18, the last article under right to equality, says titles have been abolished. No title can be awarded by the state. But sir, Ravindra Jadeja is called Sir Ravindra Jadeja. Thalapathy Vijay. Sachin Tendulkar, the god of... State has not conferred these titles. Through an official notification, the President of India has not said from now onwards Sachin Tendulkar will be known as the god of cricket. These titles have not been conferred by the state. If fans give these titles, that's it. Fans are not state within the meaning of Article 12. But no title except military or academic distinction. For example, doctor, professor, engineer, field marshal, chief of army staff, chief of defense staff. These titles, which are academic in nature, military in nature, these can be conferred, but others cannot. By that logic, how about Bharat Ratna and Padma Awards? Bharat Ratna conferred by the President, Padma Awards, Padma Vibhushan, Padma Bhushan, Padma Shri. These are not titles. These are awards. Award is different from a title. Award is given for accomplishments, for something that you have achieved. Title is something which adds to your name, such as an appendage. Title, something which used to be given by the British during the colonial era. Sir Syed Ahmad Khan, Rai Bahadur. These titles cannot be conferred by the state because this violates the principles of equality. But titles which are academic in nature, military distinction, those can be conferred by the state. Otherwise, no. This is Article 18 of the Constitution. Okay, so we will take a break and it's 2:37. Let's meet at 3:15. See you on the other side of the break. Shall we continue? If I'm audible and visible, please let me know. Do the states and the union prepare their own list of socially and educationally backward classes of citizens? Yes. States as well as union. But there is a list of SCs and STs prepared only by the center. Let's look at the next category of fundamental rights, right to freedom. Articles 19 to 22. Article 19, it first talks about Article 19(1)(a), which is freedom of speech and expression. Then, right to assemble peacefully and without arms. Right to form unions, associations, or cooperative societies. This term, cooperative society, was not originally part of the Constitution. It was added by the 92nd Constitutional Amendment Act 2011. Right to move freely throughout the territory of India. Right to reside and settle in any part of the territory of India. There used to be right to acquire and dispose of property, which was deleted by the 44th Constitutional Amendment Act 1978. And the right to practice any profession or to carry on any occupation, trade, or business. All these fundamental rights are available only to the citizens. These fundamental rights are not available to aliens. For the prelims examination, what you need to know is what are these rights and what are the reasonable restrictions on these rights guaranteed by the Constitution to the citizens of India. Let's look at reasonable restrictions on freedom of speech and expression. Originally, there were 4 reasonable restrictions. Later on, through various constitutional amendment acts, 4 more reasonable restrictions were added. You may be asked, which were these reasonable restrictions originally part of the Constitution? Security of the state, decency or morality, contempt of court, defamation. These 4 were the original reasonable restrictions under Article 19(1)(a). Later on, 4 more got added: sovereignty and integrity of India, friendly relations with foreign states, public order, incitement to an offense. These were added later. This freedom of speech and expression also includes the fundamental right to know candidates contesting the election, the antecedents of the candidates contesting the election. For example, what is your educational qualification? What is the amount of assets in your name and in the name of your spouse? How many criminal cases are pending against you? You also have the fundamental right to know about the funding which is given to political parties. This is also your fundamental right. But there are reasonable restrictions. Plus, right to freedom of press is also a fundamental right under Article 19(1)(a). Flying your national flag is a feeling of expression, is also a fundamental right under Article 19(1)(a). When it comes to 19(1)(b), which is a right to assemble peacefully and without arms, this is not an absolute fundamental right. Reasonable restrictions are in the interest of sovereignty and integrity of India and public order. Remember these reasonable restrictions, very important. Then right to form unions, associations, and cooperative societies. What are the reasonable restrictions? In the interest of sovereignty and integrity of India, public order, morality. When you look at 2 other fundamental rights, right to reside and settle anywhere within the territory of India, right to move freely throughout the territory of India, These are the fundamental rights whose primary intention is to implement one of the objectives of the Constitution as mentioned in the preamble, fraternity. Fraternity is a sense of common brotherhood. We may have different sets of ideologies. We may belong to different religious groups, different caste groups, tribal groups. So there is a diversity in India. But despite that diversity, from north to south, east to west, we are one. And we are bound together by the sense of oneness, a feeling of togetherness, a common brotherhood, fraternity. And for that, we have the right to move freely throughout the territory of India and the right to reside and settle anywhere within the territory of India. But these two fundamental rights are also not absolute. In the interest of the general public, for the protection of the interests of the scheduled tribe, there can be reasonable restrictions, which means that's how there is inner line permit in some states. When you enter the tribal areas, you need to seek the permission. And there are some areas which are out of bounds for common citizens, where you can't even dare to enter. Why? Because for the protection of the scheduled tribes, your right to move there, your right to settle there is reasonably restricted. Similarly, in the interest of the general public, for example, habitual offender. Somebody who is habituated to committing offenses. Now we can, or the courts can, or the state can impose a limitation, a restriction on you that you cannot enter this state. For example, if you're from Gujarat and you have been thrown out of that state for some time because you may end up committing crimes, for example, then does that mean your right to reside anywhere is restricted? Yes. But is that a reasonable restriction? Yes. Which means imposing restrictions on residents for habitual offenders, that is not unconstitutional. That is constitutional. Similarly, if you have the fundamental right to carry on any trade, any occupation, any profession, this right is also not unrestricted. There are restrictions that can be imposed. For example, in the interest of general public, you cannot claim that I have a fundamental right to carry on any trade, any occupation, and maybe because of that you want to sell narcotics, contraband, psychotropic substances. It is not in the interest of the general public, so your right to carry on any profession can be restricted. You have a right to become a doctor. You have a right to practice. But for that, you need a technical qualification, a professional qualification. So technical professional qualifications can be prescribed for certain occupations. That's a reasonable restriction. Similarly, the state may say, state under Article 12, that for example, in atomic energy, we will exclude the private players. We will exclude everyone else. Only the state will carry out this business, this occupation, this trade. Similarly, for space, maybe, we will impose restrictions on you, but not fully. For atomic energy, we may impose full restrictions on you. This is something which is provided under the Constitution. This is Article 19 of the Constitution. What are these rights? What are the reasonable restrictions on these rights? So you need to understand that there is no reasonable restriction in the interest of sovereignty and integrity of India when it comes to residing and settling anywhere within the territory of India, or your right to move freely throughout the territory of India cannot be restricted in the interest of sovereignty and integrity of India. It can be restricted in the interest of the general public, in the interest of any scheduled tribe. Now, when we look at Article 20 of the Constitution, there are three things that you have to keep in mind. One is the limitation on the legislature. One is the limitation on the judiciary. One is the limitation on the executive. Sir, what are you trying to say? I am saying under Article 20, Clause 1, don't remember the clauses, understand the concept. Under Article 20, for example, Nirbhaya case. This student was gang raped in a moving bus on, I think, December 16, 2012. One of the offenders in this horrific crime was a juvenile. And who is a juvenile? Somebody who is less than the age of 18 years. According to the law which was in operation at the time this horrific crime was committed, the law said this juvenile, if he is in conflict with the law, if he has committed any crime, maximum punishment that can be given to this juvenile is 3 years in a reform home. After that, you will be set free. But after this gang rape, the law was changed. And the law said, if you are in the age group of 16 to 18, but if you are accused of committing a heinous crime, you may be tried like an adult. You may be sentenced to life imprisonment. You may not be given death sentence, but you may be subjected to life imprisonment. What is a heinous crime? A crime is a heinous crime if the minimum punishment is 7 years. So what is a heinous crime? A crime for which the Juvenile Justice Act prescribes a minimum punishment of 7 years. That crime is a heinous crime. For example, rape, for example, murder, for example, dacoity. And if there is a juvenile in the age group of 16 to 18, if he has committed a heinous crime, he may be tried as an adult, provided the Juvenile Justice Board accepts it. But this law was changed after this crime. What happens to this juvenile? Will he be tried as per the law which was in force when he committed this crime? Or will he be tried according to the new law? He will be tried according to the old law, because when he committed this crime, at that time, what was the law in force? Can this law be changed later and given a retrospective effect? Can this law, when we changed it in 2015, can we say this law will enter into force from a previous date of 2012 so that this juvenile can also be booked under the new law? No, this is a limitation on the legislature. Something that we see in United States. No ex post facto criminal legislation, which means can legislature enact a criminal law and give it a retrospective effect? No. A criminal law can only be given prospective effect. That means it can enter into force from a later date. It cannot enter into force from an earlier date. That's the limitation on the legislature. Can civil laws be given retrospective effect? Yes. Can taxation laws be given retrospective effect? Yes. But can criminal laws be given retrospective effect? No. Second is, no person shall be prosecuted or punished for the same offense more than once. You have committed a crime of murder for which you were sentenced to 14 years in jail. Once you are released for the same offense, you cannot be prosecuted and punished again by the judiciary. This is what we call no double jeopardy in United States. You cannot be prosecuted and punished for the same offense more than once. But listen to me carefully. What if you murdered X, for which you were given 14 years? Now you have served 14 years, you are released. Does that mean now you have a free hand that you can commit as many murders as possible because previously you have been convicted for murder? No. If you murder Y, it is a new offense of murder, which means for this act, for this new offense of murder, you will be prosecuted again. But for the same murder, for the same offense, you cannot be punished more than once. This is 20 clause 2. It prohibits the judiciary from punishing the same person more than once. Article 20 clause 3 is a similar right that is guaranteed in US Constitution, which is right against self-incrimination. There are some cases which are not solved. We don't know who committed this crime. We don't know. For example, confession. What is this confession? Police has to investigate who committed this crime. For that, the police has to collect evidence. Dead body, murder weapon, statements of eyewitnesses, circumstantial evidence. What if the police tortures me and says, confess to your crime? Now this can be used as an evidence against me. Now I have confessed. Yes, I have committed murder, which means I become the eyewitness in my case. I am confessing. This is not allowed because right against self-incrimination is a fundamental right under Article 20, Clause 3, which means executive has to independently prove with evidence before the court of law that I was the one who committed this crime. These confessional statements are not valid if given before the police. But confessional statements would be valid if given before the judge. Because the judge will ask me, have you given this statement under duress? Were you tortured for giving this statement? I would say either yes or no. But if I've given it voluntarily, this can be used against me. Because 20 clause 3 says, no person accused of any offense shall be compelled to become a witness against yourself. Compel is important. If you're doing it voluntarily, that too in presence of a judge, your confessional statement is valid. There are certain tests, such as narco-analysis, brain mapping, polygraph, lie detector tests. Can an accused be compelled to undergo these tests? No. Can you do it voluntarily? Yes. Can it be prescribed on the orders of the court? Yes. But even if it is done on the orders of the court, the results of these tests cannot be used as an evidence. But so far as DNA fingerprinting is concerned, this test is valid. DNA fingerprinting allowed, but narco-analysis, brain mapping, polygraph, lie detector test, you can be compelled to take these tests on the orders of the court. But even then, the results of these tests will not be used as an evidence. Then what is the purpose for doing these tests? It may not be used as an evidence, but it can lead to evidence. Through these tests, I am not confessing to this crime, and that confession is the evidence in a court of law. But I might reveal where the murder weapon is. That murder weapon will then be evidence against me. I might reveal where is the dead body. That dead body's recovery, and then the fingerprints surrounding it may be used as an evidence against me. So these tests may not be treated as an evidence, but these tests still have efficacy because they may lead to evidence. Right against self-incrimination is a fundamental right under Article 20, Clause 3. And why these tests are unconstitutional? Because they violate right to privacy, which is a fundamental right. That's Article 20. Article 21 talks about no person shall be deprived of his life or personal liberty except according to the procedure established by law. Which means your right to life is not absolute. Which means you can be arrested. Your liberty can be snatched. You can be hanged as well. But it should be done only according to the procedure established by law. And what is this procedure established by law? There is something called procedure established by law, and there is something called due process of law. What is the difference between the two? Very important concept, has been asked in the examination. This is where it was confusing for majority of the students as well. If you know the concepts, if you have the conceptual understanding and clarity, you won't make mistakes. What is procedure established by law? What if I am arrested, which means my liberty has been snatched? My right to life has been violated. I will go to the court, or you will go to the court on my behalf. The court will perform 3 tests. If these three tests are valid, that means my right to life and personal liberty has been justly denied, constitutionally denied. What are these tests? Number one, there has to be a law. For example, I am arrested for taking a live marathon session on a Sunday for Prelims 2026 with regards to Indian polity. Police comes and arrests me. Why are you taking a live session? Police has arrested me. Matter will go to the court. You will go to the court. Sir, please release this person, this teacher, at least for a couple of days till our prelims exam is over. After that, let him rot in the prison. We are not concerned. But for these few days, please release him because he has been unjustly arrested. The court will ask the police, under what law have you arrested him? Is there a law which says that teaching polity on a Sunday for prelims 2026 is a crime? There is no such law. If there is no such law, I will be set free. What if there is such a law which says teaching polity is a crime on a Sunday? You might say, but this is a horrible law, arbitrary. Matter will go to the court under due process of law and I will be set free. Why? Because under due process of law, there is a golden triangle of Article 14, 19, 21. Listen to me carefully. Article 21 says your right to life and personal liberty cannot be snatched only except according to the procedure established by law. Does that mean any law can be enacted by the parliament and through that law your right to life and personal liberty can be snatched? Or should this law be a just law, not arbitrary law? Does this law need to uphold the freedoms or violate the freedoms? The court has said initially that we follow procedure established by law. Legislature, even if it passes a law which says teaching polity is a crime, that too on a Sunday, the courts will be helpless. We cannot defend you against the legislature. We can defend you against the executive if executive has arrested you without any law. If the executive has arbitrarily detained you, the police has arbitrarily arrested you. But if there is a law, we cannot protect you. That is procedure established by law. But in Maneka Gandhi v. Union of India, 1978, Supreme Court invoked this golden triangle and said, we don't have to look at a law only from the perspective of Article 21, whether law exists. We have to see whether this law is a just law, whether it upholds the freedom. So we have to test any law on this ground, whether it is upholding Article 21, Article 19, Article 14 as well. It should not be arbitrary. And apart from that, we will be following principles of natural justice, which is nobody shall be sentenced without being heard. Nobody shall be the judge in his own case. And the authority shall act bona fide. That means in good faith. For example, there is a case against me. Why are you teaching polity on a Sunday? You went to the court. Court gave me punishment. But I don't know anything about it. The court should have heard me as well. I should have defended myself with my arguments. Why it should not be a crime. Why I should not be prosecuted. If I am not given a reasonable opportunity to defend myself, it violates principles of the natural justice. Second, nobody shall be the judge in his own case. Judge in his own case in the sense, suppose this is a passport authority. And this passport authority is responsible for issuing passport and for renewing your passport as well. I have a passport. Now I'm up for renewal. I am up for renewal. I apply for the renewal of my passport. Passport authority denies it. We will not issue you the renewal. Now, what should I do? I should ideally approach someone else. Hey, passport authority has denied to renew my passport. What if the law says if passport authority denies you the passport or renewal or issuance of a new passport, you have to approach the passport authority again? How will this passport authority, which previously denied me the passport, now will sit on this judgment whether this denial was just or unjust, reasonable, unreasonable, fair, unfair, constitutional or unconstitutional, legal, illegal? You cannot be the judge in your own case. If such a law is passed, which gives the same authority the power to review its own verdicts as well, own orders as well, it is arbitrary and as such violative of Article 14. An authority will have to act bona fide, which means in good faith. Which means whenever you pass a law, we don't have to just look at what the law is. We have to look at what is the intention behind this law. If your intention is bad, that can be a ground for striking down that law. And Supreme Court said in Maneka Gandhi case, we don't only follow due process of law, we follow principles of the natural justice as well. This concept is important. But this concept, principle of natural justice, is not mentioned anywhere in the Constitution. But Supreme Court has said it is an integral part of Article 14 as well as 21. Right against arbitrariness. If you are the judge in your own case, it is arbitrary, as such violative of Article 14. If you're not acting in good faith, it is violation of Article 21 of the Constitution. Principles of the natural justice. Then Article 21 capital A was inserted into the Constitution. It was not originally part of the Constitution. It was added by 86th Constitutional Amendment Act. But before we start, Article 21 has been expanded a lot in the last 1.5 years. Supreme Court said right to menstrual health and hygiene is also a part of Article 21. Right against adverse effects of climate change is also a fundamental right under Article 14 and 21. Right of a woman to adopt children is also a fundamental right under Article 21. So these rights which have been expanded under Article 21, you need to keep them in mind. And we have covered in the current affairs classes. 86th Constitutional Amendment Act, Article 821 capital A was inserted, which spoke about right to education. Right to education is a fundamental right. But for whom? For those children who are in the age group of 6 to 14 years. It does not talk about citizens. It talks about all children. That means it is not only a fundamental right for Indian citizens and their children. It is a fundamental right for everyone within the territory of India. The state shall provide for free and compulsory education to all children in the age group of 6 to 14 years. How? For that, you have to enact a law. And which law was enacted for this? Right to Education Act, which was passed in the year 2009, but entered into force with effect from 1st of April 2010. And it is this Right to Education Act which spoke about 25% reservation for economically weaker sections of the society in private schools in the neighborhood. This was a matter of discussion in the latest Supreme Court ruling. So if there is a private school, 25% seats in this private school shall be reserved for the economically weaker sections of the society in the neighborhood, so that they can also get access to quality education. This was upheld by the court recently, multiple times. But at the same time, it is this Right to Education Act which imposes an obligation on the teachers. on the state that you don't have to only enroll the children, you also have to retain them. So enrollment as well as retention is now the responsibility of the teachers. Plus, no child shall be denied admission for want of documents. No child shall be denied admission for the want of documents. Whether you have the birth certificate, whether you have Aadhaar, whether you have these certificates, on this ground, no children shall be denied education. Plus, it also had a provision of no detention. Now, this no detention policy has been completely given up, or do states have the power to decide whether they want to continue with no detention policy or they want to come out of it? Who has that power? Tell me. States have the power to decide whether they want to continue with no detention policy or they want to junk the no detention policy. So it is not mandatory that no detention policy should be scrapped. It's for the states to decide, because education is mentioned where? Education is mentioned in the concurrent list. These facts are important and relevant for your examination. Let's look at the last article under this category, right to freedom, Article 22. This is a fundamental right which comes into picture after you have been arrested. Once you're arrested, no person who is arrested, which means this fundamental right kicks in after you have been arrested. You cannot be arrested and detained in custody without being informed. Informed of what? What are the grounds of your arrest? But this right to be informed means what? You have to be informed in written. If you are not informed in written, that means you are not following the Constitution. And that is how one of the individuals who was accused of murdering her husband while they were on a honeymoon in Meghalaya, that individual lady was given bail on this technical ground. You are arrested for any offense. The police which arrests you, the authority which arrests you, the authority will have to inform you of the grounds of your arrest. How? In a written format. And that's how the editor of a digital news portal was also released by the Supreme Court. Why? Because he was not informed in writing the grounds on the basis of which he was arrested. But not only is this mentioned, what is also mentioned is you cannot be denied the fundamental right to be defended by the lawyer of your choice. If I want Kapil Sibal to defend me, the government cannot say, no, you will not be defended by him, you will have to be defended by XYZ. I have a fundamental right. Once I am arrested, I have the fundamental right to be informed of the grounds of my arrest in the writing. And I also cannot be denied the fundamental right to be defended by the legal practitioner of my choice. And once I'm arrested, within 24 hours, I have to be produced before the nearest magistrate. But what if I am brought, for example, Pawan Khera is brought from Delhi to Assam, for example. Then the time it takes for Mr. Pawan Khera to be transported from Delhi to Assam, that will be excluded in determining the 24 hours. So within 24 hours of your arrest, Mr. Pawan Khera should be produced before the magistrate in Assam. But it might take some time. Instead of transporting him through a flight, we may transport him through train or through bus or on a bullock cart. so that it takes a lot of time for this person to be produced before a judge in Assam. Because we need to exclude the time necessary for the journey. Okay? Great. Now we have two fundamental rights under this category, right against exploitation. Article 23 prohibits traffic in human beings. Traffic basically means buying, selling of men, women, children like goods. The manner in which we buy, sell goods, in the same manner if we buy, sell men, women and children, it is traffic prohibited under Article 23 because it amounts to exploitation. If you notice, Article 23 does not explicitly mention slavery. But the Supreme Court has interpreted and said slavery is also prohibited as a form of exploitation under Article 23. Article 23 also prohibits begar and other forms of forced labor. Begar is what? You are forced to work without wages. That's begar. This is exploitation, abolished, prohibited by Article 23. Or forced labor can be, I was brought to Delhi to work so that Asian Games can be successfully conducted in Delhi in 1980s. I was asked to come work in Asian Games villages, so I came voluntarily. I was paid wages as well. But later we realized that I was forced to do overtime. I was forced to work in inhuman conditions. I was forced to work, but minimum wages were not provided to me. I was provided with much lesser wages. Isn't this exploitation? By that logic, all the Infosys, TCS, Wipro, HCL engineers are under forced labor because you are not being forced to work. You are doing it voluntarily, but you are paid less, below minimum wages. As such, this is other forms of forced labor, and Constitution prohibits it. Constitution prohibits traffic, begar, and other forms of forced labor. That does not mean Infosys employees are under forced labor, just that they follow Minimum Wages Act, but it's just humor so that you are able to understand what is other forms of forced labor. Where you're doing the work voluntarily, you are paid salary as well, wages as well, but wages are much below the standard. You are forced to work, but forced to work overtime without incentives. Forced to work in inhuman conditions. But the condition is, if you are forced to work without wages, it is exploitation. It is begar. But in one instance, you can be forced to work. And you may not be paid wages either. But who will impose this forced work on you? State. Why? State will ask you to compulsorily work. And the state is not bound to pay you wages either. Why? For public purposes. For example, there is a tsunami. For example, there is a war. For example, there is an earthquake. And we want people to help each other. Compulsory service will be imposed by the state on the people. You have to work. And for that, we will not give you wages either. But while the government imposes this compulsory service on you, the government, the state shall not discriminate only on the grounds of religion, race, caste, class, or any of them. This criteria is important. Can this compulsory service be imposed only on the poor and not rich? On the basis of class? No. On the basis of religion, only XYZ religious communities will be forced to work and others will not be? No. Can we impose this compulsory service only on those who belong to a particular caste? And we tell them, since you belong to this segment where you are cleaning this stuff, so you might well do this stuff as well. On the basis of caste? No. On the basis of class? No. On the basis of religion? No. On the basis of race? No. Which means the state can discriminate. On what grounds? On the grounds of age. On the grounds of sex. On the grounds of residence.
If there is a tsunami in Odisha, why should we ask Punjabis to come to Odisha? We can impose this compulsory service on those who are the residents of Andhra Pradesh, the nearby state, the neighboring state, on Jharkhand, on any other state. This is Article 23. Article 24 prohibits another exploitative practice, which is the employment of children in factories. But who is a child according to the Constitution? Very important distinction. Child who is less than the age of 14. Constitution under Article 24 talks about no child who is below the age of 14 can be employed to work in factory or mine or in any other hazardous employment. For that, there is a law. Which is that law? Child labor. Child Labor Prohibition and Regulation Act. (1986). This law was amended in 2016. According to this law now, here is a child below the age of 14 years. And here is an adolescent. And who is an adolescent? In the age group of 14 to 18 years. This child, who is in the age group of less than 14 years, this child is prohibited from being employed anywhere. You cannot employ this child anywhere. Whether it is hazardous, non-hazardous, doesn't matter. There's a complete ban on the employment of children. But this child is allowed to work in audio-visual entertainment industry, family business, provided this family business is not hazardous. But you can do that only during vacations or after school hours, so that it does not affect your right to education. So a child less than the age of 14, after the amendment in 2016, this child cannot be employed anywhere. Hazardous industry, non-hazardous industry, doesn't matter. This child cannot be employed anywhere. But this child, during vacations or after school hours, can assist her family, his family, or can participate in audio-visual entertainment industry, but in such a manner that it does not affect the education of the child. And for the first time, this law spoke about adolescents in the age group of 14 to 18 years. These adolescents are barred from being employed in hazardous industries, but they can be allowed to work in non-hazardous industries. That's the distinction that you have to keep in mind. This is Article 24. Right? Let's look at Article 25 to 28, covering right to freedom of religion. Listen to me carefully. Look at other fundamental rights. First, equality before law is provided, then there is an exception. Article 15 is provided that there shall be no discrimination only on the grounds of religion, race, caste, sex, place of birth, but there is an exception. Women and children, socially, educationally backward class of citizens, economically weaker sections of the society. Similarly, Constitution gives you freedom of speech and expression, then gives you 8 reasonable restrictions as well. So first there is a right, then there is an exception. First there is a right, then there is a reasonable restriction. But Article 25, which is a religious right, it is unique. Unique in the sense that first there are reasonable restrictions and then there is a right. Constitution says subject to public order, morality and health. This is where people have confusion. People think that our freedom of religion is restricted only under 3 grounds: public order, morality and health. But that's not correct. Because Constitution says subject to public order, morality and health, and subject to other provisions of this part. Which are the other provisions of this part? Part 3, fundamental rights. Which means your freedom of religion is restricted not only on the grounds of public order, morality, health, but subject to all the fundamental rights. Which means you can say that the weakest of all the fundamental rights are these religious rights under Article 25. But what is this right? First is freedom of conscience. Absolute innermost freedom to choose a religion. Freedom from religion as well. You may not choose any religion. You may stay atheist. But once your conscience has told you that you belong to this particular religion, then you profess, practice and propagate your religion. Then you openly declare that I belong to this particular religion. You openly practice the religion. You openly propagate the religion as well. But this right to propagate does not give you no fundamental right to conversion. You cannot say, I will convert others into my religion and that's my fundamental right under Article 25. No. Can you convert others into your religion? Yes. For that, you need to touch upon their conscience. Through bribe, through inducement, through allurement. You cannot be converting others into your religion. When it comes to practicing your religion, members of the Sikh community, they carry kirpan. That is considered, according to the Constitution, profession of Sikh religion. Because once you have made your conscience clear that I'm a Sikh, I believe in the beautiful stories of Sikhism, then you profess I'm a Sikh. Then you practice the rituals of Sikhism, which includes carrying of kirpans. But integral to Article 25 is reform. And this is where it becomes interesting because a 9-judge bench of the Supreme Court is hearing this matter. The Shabrimala reference. What is the issue? The Supreme Court, the Constitution says the central theme of Article 25 is a reform. Reform in the sense we will throw open all the Hindu temples for all the classes of Hindus. Who is a Hindu? Constitution says person who practices Sikh, Jainism or Buddhism also is a Hindu. And this is where it becomes interesting because recently there was a judgment of the court. Judgment in the sense, listen to me carefully. This is the Atrocities Act of 1989, under which if you're a Dalit or you're a tribal, and if you face discrimination, you can file a case before the court. But here is an individual who was a Dalit, ex-Hindu, Dalit. Now he has converted into Christianity. And now he has become the pastor at a church. He filed a case under the Atrocities Act. The Andhra Pradesh High Court, later on the Supreme Court rejected this, saying once you are converting into Christianity, and in Christianity there is no concept of caste, you lose your SC status. That means an SC person, once you convert into other religions, and who is a Hindu? If you are a Sikh, if you are a Jaina, or if you are a Buddhist, or you are a Hindu, you are all Hindus. So if you convert into Islam or Christianity or Judaism, any other religion, you will lose your SC status. Can you reclaim your SC status back? Yes. But for that, first you have to prove that you belong to that religion and you belong to the Dalit identity. then you have to merge with that identity. And then the supporters or the followers of this entity, they will also have to recognize you. Only if you fulfill these conditions can you reclaim your SC status. Otherwise, you can't. Because Constitution Order of 1950 explicitly talks about who is a Hindu. And explicitly says that only somebody who is from Hinduism or Jainism or Sikhism or Buddhism, they may face atrocities and they may be referred to as Dalits. But if you convert, you cannot retain the SC status because religious identity is important. And that is why if you convert to Christianity or Islam, which do not recognize castes, at least on paper, you will lose your SC status. But what about ST status? ST status is not dependent upon religion. ST status depends upon where you were residing, which tribe were you a part of, and whether that tribe continues to recognize you as a tribal. If yes, then you are a tribal. Even if you have converted into another religion, yes, doesn't matter. Why? Because the scheduled tribes order does not link your tribal status with that of your religious identity. Keep that in mind. Further, Article 26. Once you have made your conscience clear that you belong to this particular religion, and then you practice, profess, and propagate your religion, this is about an individual right of an individual person, that my conscience is clear, now I can profess, practice, and propagate my religion. And now all of us, we can also become a denomination. And now this denomination becomes a group. And for this group, there is a right under Article 26. Subject to public order, subject to morality, subject to health, every religious denomination, you have the fundamental right to establish, maintain institutions. Whether you are doing it for religious purposes or charity purposes, doesn't matter to us. Who is this religious group or religious denomination? Devotees of Lord Ayappa, they said we are a separate denomination, separate group. And when we are a separate group, we may have separate rules as well. We may not have the same rules as are applicable on other Hindus. We are a separate denomination. And as such, we may have made our rules. These are temple entry rules. We will block the entry of the women of menstruating age between 10 to 50 from entering the sacred sanctum sanctorum of the Shabarimala temple. On these religious matters, there is something called doctrine of essentiality. Or essential religious practices test. The court will have to examine whether you are a separate denomination or not, and whether your practice is integral to your religion or not. If by allowing entry of women inside the sacred sanctum sanctorum of the Shabarimala temple, if your religious denomination will collapse, then we will give precedence to this practice. We will exclude women. But if it is not an essential part of your religion, even if women are not allowed entry, that does not mean religion will collapse. That means this rule barring the entry of women of menstruating age is not essential religious practice of Hinduism or your religious denomination. So on all these religious matters, this doctrine is used, doctrine of essentiality, which was first invoked by the court in the Shurur Mutt case of 1954. And now the Supreme Court is currently reviewing it, whether courts have the power to determine what is essential to our religion, what is not essential to our religion. Because we may be the knowledgeable persons when it comes to laws, but we may not be knowledgeable when it comes to religious matters. So maybe leave it to the religious leaders to decide what constitutes essential to your religion and what is not essential to your religion. But that's Article 26. Article 27 lays down secular identity of India. How? Did India become secular only in 1978 because of the 42nd Constitutional Amendment Act 1976, when this word secular was added to the preamble? Experts say no. Article 14 talks about right against arbitrariness. Article 15 talks about no discrimination on the grounds of religion. Article 16 says no discrimination when it comes to public employment on the grounds of religion. Article 25 gives every religion a fundamental right to practice your religion, to propagate your religion, to profess your religion. The only thing that we are not giving you is the right to convert others into your religion. But when it comes to taxes, can jizya type of tax be imposed in India now? Where non-Hindus may be asked, you pay taxes, a separate tax, so that we can give you security. Can the tax be used and imposed on one particular group? No. Can a tax be imposed so that the money that we will generate from this tax can be used only for the promotion of one religion or religious denomination? No. Which means this is the laying down of the secular identity of India, where no person shall be compelled to pay taxes if this money that we have generated, raised through these taxes, are used for the promotion or propagation of any one particular religion. That's Article 27. Article 28, can religious instruction or religious worship be provided in educational institutions? One is religious instruction, that means religion may be taught to you. Other is religious worship, where you will practice your religion. Can you be compelled? Constitution says no religious instruction shall be provided in any institution wholly maintained out of the state funds. That means whether it is a government university or a government college, state university or national university, doesn't matter, you cannot give religious instruction. But yes, if this educational institution is owned by a trust, for example, a religious trust, they may provide instructions on religion in their schools and colleges or universities. But at the same time, if you are attending an educational institution, but this educational institution is a government institution, can you be compelled to undergo religious instruction? No. Can you be forced to perform religious worship? No. But what if this is not a government school or a government college or a government university? But this is an educational institution which is recognized by the state or is receiving the aid of the state, which means these are private institutions. Can these private institutions impart religious instruction? Yes. But for that, you need the consent of either the students or the guardian or the parent in case the student is a minor. Because if you are forcing the people, the students, to participate in religious instruction, if you're a minor, you need permission from the parents. Otherwise, no. That's Article 28. Okay? Great. Now, cultural and educational rights under Article 29 and 30. Article 29 says protection of the interest of minorities. But this term minority is not defined in the Constitution. It says any section of citizens, which means now Article 29 is exclusively available to citizens. Any section of citizens, if you have a distinct language, script, or culture of your own, and you want to preserve that culture, it becomes your fundamental right. The Supreme Court has said you can even agitate for the protection and promotion of your culture. Plus, if a school has been established, educational institution has been established, no citizen shall be denied admission to these educational institutions only on the grounds of religion, race, caste, language, or any of them, provided this educational institution is maintained by the state or is receiving aid from the state. Here is a private educational institution. This private educational institution is recognized by the state. This private institution is receiving funds from the state. Then can any citizen be denied admission in these schools? No. Can any citizen or the children be denied from the school? Yes, but not only on the grounds of religion, race, caste, language, or any of them. And Article 30 talks about rights of minorities to establish, manage, and administer educational institutions of your choice. But who are these minorities? Either on the basis of religion or language, which means Constitution recognizes two types of minorities: religious minorities and linguistic minorities. And who are these minorities right now? We have the National Commission for the Minorities Act. They say Christians, Buddhists, Jains, Parsis, Sikhs, and Muslims. These are the 6 religious minorities in India. Whether these minorities should be pan-India, national level, or within the state, we may have the concept of minorities. That matter is still with the court. We will have to wait and watch what the court will rule. But all minorities, whether based on religion or language, you will have the right to establish, manage, and administer educational institutions of your choice. And the beauty about these institutions is, facts very important for your prelims, is that there is no SC, ST, OBC, EWS reservation. Plus, they can hire and recruit own staff. Plus, they can reserve up to 50% seats for their own community. This is Article 30 of the Constitution, right? Now, very quickly, let's look at other rights, other articles, and we are done with Fundamental Rights chapter. This is Article 14, right to equality, right against arbitrariness. This is Article 19, right to acquire and dispose of property. This is Article 31. Article 31 talked about compulsory acquisition by the state. For example, zamindars would have hundreds and thousands of acres of land. And we want this land to be distributed amongst the landless. That's what zamindari abolition was all about. That's what land reforms were all about. But the challenge went to the court. Supreme Court said this is arbitrary. You are snatching from us and giving it to somebody. This is arbitrary. You are violating Article 19. I had the fundamental right to acquire and dispose of property. You are violating Article 31, which says if you want to acquire property, you have to provide us fair compensation. The government responded before the court, before the Supreme Court, and what the government did, amended the law. Parliament added Article 31 capital A. And this Article 31 capital A said, if the state tomorrow wants to acquire land, belonging to a particular private individual. What the parliamentary law can say? Parliamentary law can say anything that we will snatch this land, to take over this land for the better management of this property, that too in public interest. If we will leave this property like this, there is a possibility that this property may be confiscated, or this property may be stolen, or this property may be, let's say, illegally held upon to. In that case, we can enact a law, Parliament can enact a law, and through that law, it can snatch this right even if Article 14, 1931 is violated. Can such a thing be done only by the Parliament? No. State legislature can also enact such a law. But when the state legislature is enacting such a law, it has to take the consideration of the President, which means this bill, once it is passed by both houses of the state legislature or one house of the state legislature, it is sent to the President, and the President will then decide whether he will give assent to this bill or not. If this bill has received the assent of the President, then this bill will continue, this law will continue. That's Article 31 capital A. Someone suddenly may have advised the government that even then there may be a judicial review. Whenever we will enact a law and through that law we will snatch the property, we won't give compensation, even if it violates Article 14, 1931. But what if it is challenged in the court? Article 31 capital B was added, 9th schedule was added to the Constitution. And this 9th schedule of the Constitution says any law which is placed in 9th schedule is immune from judicial review. But two things: shall be deemed to be void or ever to become void. Which means, can we place a law in the 9th schedule retrospectively? Yes. And any law which is placed in 9th schedule is immune from judicial review. But the point is, this was available till 24th April 1973. This was when the Keshavananda Bharati judgment was given. Now, the current status on 9th schedule is any law which is placed in 9th schedule till 24th April 1973, there is no judicial review. Laws placed afterwards, there is a judicial review. Why? Because judicial review is part of the basic structure of Indian Constitution. What am I trying to say? Article 31, it said state can acquire property, because this is where you need to understand a concept called doctrine of eminent domain. Not explicitly provided by the Constitution, but understood to be the sovereign power available with the state. As a state, I have to lay down a railway line. And then there is a land, private land, which is occupying this railway line. I have the right to acquire that land because it is in the larger public interest. That's called doctrine of eminent domain. The power of the state to acquire the land for the larger public interest. It is, after all, for you. It's not for me. But I have to provide compensation. Because if I don't provide compensation, I'll be violating your Article 14, your Article 19, your Article 31. But how can we provide compensation to these zamindars who have held thousands of acres of land? And we want to redistribute this land to the poor, landless janta. In that case, Constitution was amended. Constitution said no matter what is mentioned in Article 13. Article 13 says state cannot delete, modify, abridge fundamental right. But it cannot apply if there is a constitutional amendment. We are amending the Constitution. And through constitutional amendment, we are adding Article 31 capital A. Now the state can acquire land, can take over estate, can take over the business to manage it better in the larger public interest, even if it violates Article 14, 1931. And such a law, if it is placed in 9th schedule, it can never be challenged in any court of law. But that was short-lived because in 1973, a 13-judge bench of the Supreme Court said there is something called basic structure. And later Supreme Court said judicial review is part of the basic structure. So we will have to review 9th schedule as well. But since this basic structure judgment came on 24th April 1973, we will give a prospective effect to this judgment. We'll say all previous judgments are valid. From now onwards, you will have to follow this particular judgment, this particular law. This is Article 31, capital B. Okay? Then there was a case where when laws were passed and these laws were later on declared unconstitutional by the courts. Zamindari Abolition Act was declared unconstitutional. Land Reforms Act was declared unconstitutional. In response to these actions by the judiciary, Article 31 capital A and Article 31 capital B was inserted into the Constitution. But then what the government tried to do in 1971 around, Constitution was amended, 25th Constitutional Amendment Act was passed. Article 31 capital C was inserted into the Constitution. This Article 31 capital C said, if Parliament wants to enact a law to give effect to Article 39B and 39C, these are the two directive principles of the state policy. Socialistic directive principles. One directive principle says the operation of the economic system should not result in the concentration of wealth to a government detriment, Article 39 Clause C. Another directive principle said the means of production shall be so distributed so as to subserve the common good. The material resources of a community shall be so distributed so as to subserve the common good. Parliament amended the Constitution, 25th Constitutional Amendment Act 1971, and said if Parliament wants to give effect to these two directive principles of the state policy, and in the process Articles 14, 19 and 31 are violated, merely on this ground, the law is not unconstitutional. Long story short, Parliament in 1971 gave primacy to two directive principles of the state policy over three fundamental rights. Because previously the position of the court was fundamental rights are superior, directive principles are inferior. Now for the first time, the Parliament is enacting a law and giving superiority to two directive principles over three fundamental rights. Matter went to the court. Keshavananda Bharati. Supreme Court upheld this law, upheld this constitutional amendment. Supreme Court said, fine, two directive principles, 39B and 39C, have superiority over three fundamental rights. Valid. Later on, when emergency was imposed, this Article 31C was amended again. And that is how you can read this amendment. Because, listen to me carefully, when Parliament amends the Constitution, and what if this constitutional amendment is later on declared unconstitutional by the courts? The text of the Constitution still remains the same. It's not that because of that judgment, that provision is deleted from the Constitution. It remains there, but it just doesn't enter into force. It is just not operative. It becomes inoperative. So originally in 1971, the Parliament said if Parliament wants to give effect to these two directive principles, and in the process these fundamental rights are violated, merely on this ground, the law shall not be declared unconstitutional. But then what Parliament tried to do? Parliament said if we give effect to all or any principles laid down in Directive Principles. Which means the Parliament tried to give primacy, superiority to all the DPSPs over 3 fundamental rights. This was done in 1976 during emergency. And finally, matter went to the court in Minerva Mills. Supreme Court said, no, this constitutional amendment is unconstitutional. Because if you are giving primacy to all DPSPs over 3 fundamental rights, you are disturbing the harmonious relationship between DPSPs and fundamental rights. And this harmonious relationship is also part of the basic structure of the Constitution. Which means we will have to go back to the position which was in 1971. Which means right now, 2 directive principles, 39B and 39C, they will have superiority over 2 fundamental rights, 14 and 19, because 31 has been omitted by the 44th Constitutional Amendment Act. Which means, long story short, when we look at fundamental rights, right to equality, right against arbitrariness under Article 14, right to freedom under Article 19, which is the freedom to acquire property, dispose of property. And Article 31, if the state wants to acquire property, it has to provide compensation to the people, compensation to the owner, compensation to the landlord. But if we have to provide compensation, how can we implement zamindari abolition? How can we implement land reforms? That's how Constitution was amended, through a Constitutional Amendment Act. Which means only through a Constitutional Amendment Act can you delete, modify, abridge fundamental rights. What happened? Article 31 capital A was added. First Constitutional Amendment Act 1951. Constitution said, if the state wants to acquire any estate, or you want to take over any property, or you want to take over any factory as well, in the larger public interest. So you want to take over our estate, our land in larger public interest because you want to implement Zamindari Abolition Act. You want to reform, you want to implement land reforms. You can even violate Article 14, 19 and 31. Such a law can also be passed by state legislatures. Such a law can also be passed by state legislatures. If such a law is passed by state legislatures, such a law passed by the state legislature should be reserved for the consideration of the president. And if the president has given the assent, then this state law will also enter into force. Unless and until president has given assent to this law, the provisions of that law passed by the state legislature cannot enter into force. The question before the government was, what if such a law where we are taking over property, estate, factories, what if it is challenged in a court of law? 31B was inserted, again, First Constitutional Amendment Act 1951. 9th schedule was added. Any law placed in 9th schedule, there is no judicial review. Which means now you can't even challenge the constitutional validity of this law because it has been placed in 9th schedule. Then in 1971, Srimati Indira Gandhi was the Prime Minister. She tried to amend the Constitution and gave primacy to 2 directive principles, 39B and 39C, over 3 fundamental rights, 14, 19, 31, which was upheld by the Supreme Court in the Keshavananda Bharati case. But then she received a major boost because of this judgment. Then there was emergency. Then there was mini revision of the Constitution. Then 42nd Constitutional Amendment Act 1976 tried to give precedence to all directive principles over 3 fundamental rights. This the court did not agree in the Minerva Mills case. The court said you're disturbing the harmonious relationship between DPSPs and fundamental rights, which is also part of the basic structure. And by that time, the 44th Amendment had been passed. Article 31 was deleted. 31 was deleted. Not 31A, which continues. Not 31B, which continues. Not 31C, which continues. 31 was deleted. Which means the current status is two directive principles, 39B and 39C. They have superiority, primacy over two fundamental rights, 14 and 19. And fundamental rights are called fundamental because they are necessary for the growth and development of an individual, without which you cannot explore your potential. Every human being has some intrinsic potential. And if you want to explore that potential, you should have the freedom to explore it. And that is why we need fundamental rights. Because no matter what your talent is, if you're not given freedom to pursue it, you cannot explore your talent. You cannot explore your talent if you're discriminated against. You cannot develop your talent if you're denied equality or you're arbitrarily thrown out. That is why we say these fundamental rights are necessary for the growth and development of an individual. And these are so important fundamental rights that they act as limitations on the powers of the state. What if the state violates these fundamental rights? You can directly approach the Supreme Court under Article 32. Dr. Ambedkar was asked, which is the fundamental of all fundamental rights? Because you have fundamental rights. But is there a fundamental right, which is the most important fundamental right? He said Article 32. Now listen to me carefully. What if remedies for enforcement of rights conferred by this part shall be determined by Parliament by law? What if this was mentioned in the Constitution? That if the rights are violated, then what is the remedy? Remedy will be provided by Parliament by law. If this was mentioned, our fundamental rights would have been worthless piece of paper. For example, there shall be Chief Election Commissioner and as many election commissioners as may be appointed by the President, subject to a law enacted by the Parliament. Such a law was never enacted. Neither in 1950, nor in 60s, 70s, 80s, 90s, 2000, 2010, 2020. Finally, this law was enacted in 2023. Because we gave Parliament the discretion that you decide, you tell us how CEC and election commissioners shall be appointed. Parliament may or may not enact a law. Similarly, if fundamental rights are provided by the Constitution, beautifully written Article 14, 15, 16, 19, 20, 21. But we say if these rights are violated, the enforcement, the remedy will be provided by Parliament by law. Maybe in 2026 also such a law would not have been provided. Which means on paper we have fundamental rights, but there is no enforceability. There is no way in which we can get these fundamental rights enforced. There is no remedy available. That's why Dr. Ambedkar said the most important of all fundamental rights, the fundamental of all fundamental rights is Article 32. Because this right to approach the court in case your fundamental rights have been violated, this right itself is a fundamental right. And the courts can issue various writs such as habeas corpus, mandamus, prohibition, quo warranto, certiorari to enforce these fundamental rights. For habeas corpus and quo warranto, locus standi does not apply. Which means the court, while hearing these petitions, will not ask who you are. Why are you filing this case? Are your rights violated or not? No. But when it comes to mandamus, prohibition and certiorari, locus standi applies. Which means only the agreed individual can approach the court, not someone else. But these rights which are provided by the Constitution, can they be suspended also? Yes. All rights can be suspended, except Article 20 and 21. These rights cannot be suspended. Other rights can be suspended, their enforceability can be suspended. only during emergency. National emergency. That is Article 32. Okay? Now, all these fundamental rights have been provided. All these fundamental rights have been provided. But you might have noticed that members of the armed forces, they don't have freedom of speech and expression. They can't form unions, associations, or cooperative societies. Can all the spies come together and form an association? Which means Article 33, what it gives power to the Parliament. That what you can do, you can modify the rights conferred by this part when it comes to application of these rights to certain forces. Which means members of the armed forces, whether you will have all these fundamental rights or we will modify some fundamental rights, who will determine this? Parliament. Members of those who are charged with the maintenance of law and order, for example, paramilitary troops, state police, whether they can enjoy all these fundamental rights or some fundamental rights or others can be modified. Who will determine that? Parliament. Whether the members who are working in intelligence or counterintelligence agencies, RAW, R&W, IB, others, that's for the Parliament to decide. Including those people who are employed in the communication systems of these forces. Long story short, if you are part of the armed forces, if you are part of the forces which are tasked with the maintenance of law and order, if you are part of intelligence or counterintelligence agencies, or you are working in the telecommunication wing of armed forces, counterintelligence, intelligence, paramilitary troops, maintenance of law and order forces, then Parliament has the power to decide by enacting a law whether all these rights should be given to you or whether we should modify certain rights. That is why we will modify. We will not give you freedom of speech and expression. We will not give you the fundamental right to form unions, associations, or cooperative societies. We will not give you X, Y, Z rights. Who will determine that? Parliament. Article 34, martial law. But what is this martial law? Not defined in the Constitution. What is this martial law? Never applied either. What is this martial law? Imagine a situation. There's a grave problem in India, for example, and the local authorities, the government, the civilian establishment, they are unable to control the situation. The police has failed. The paramilitary troops have failed. The government has failed. Massive protests, international protests, so on and so forth. Now, in this situation, what do? We bring in the army. Army will control the situation. They have a psychological edge as well. For example, if there are protests and there are police who are asked to quell these protests, we say, who are these people? They are amongst us. So we can throw stones as well, we can pelt stones as well, we can even attack them. Then comes the paramilitary troops and we can also pelt stones or handle them. But as soon as we see army coming in the vehicles, we suddenly disappear and enter the home. Why? Because police may use lathi charge, water cannons, rubber bullets, pellets. Paramilitary troops may also shoot in the air or may use water cannons, but army is not trained like this. Army knows only one thing: shoot to kill. And we know when the army comes, there may be massive killing because they are meant to control the situation, but they don't know how to control it through hands or through water cannons or through rubber bullets. They know only one way, which is to shoot to kill. If we are bringing army to control the situation, should we not give them immunity? The army will say, if you want us to restore the situation, but we don't know how to control the riot, how to quell the protest, we also know how to stabilize the situation, which means we might shoot to kill. We can kill on mere suspicion also, even if they are not the miscreants, but we may kill on mere suspicion. Article 34 says, all these rights which are provided by the Constitution, these fundamental rights under Part 3, these rights can be restricted. When? When martial law is in place. How? All these people who are tasked with maintenance of law and order during martial law, we will indemnify them, which means we will give them immunity, some sort of. That once martial law is lifted, nobody can approach the court against these members of the forces who were dealing with the situation, controlling the situation, saying during martial law they violated our fundamental rights. During martial law, fundamental rights are restricted. Even after martial law is over, has been revoked, you cannot go to the court saying during martial law our rights were trampled upon by the members of the armed forces. So restriction on these rights conferred by Part 3 when martial law is in force in any area, which means not necessarily in the entire country, it can be in any state, it can be any part of that state as well. That's martial law. Now the last important article under Part 3. Article 16, or let's put it this way. Who has the right to implement these fundamental rights or make a law for the enforcement of these fundamental rights or prescribe punishment in case you want to penalize those who violate these rights? Parliament or state legislature or both? Parliament shall have the power and the legislature of the state shall not have the power. Very important distinction. But with respect to what? Article 16, Clause 3. What is Article 16, Clause 3? I told you Article 16 says there shall be no discrimination on the ground of residence. But sometimes residence can be provided as a qualification for certain jobs. But who can provide residence as a qualification for certain jobs, for state level jobs? That power is only with the Parliament, not with the state legislature. Number one. Number two, we have Article 32, which talks about writ jurisdiction of the Supreme Court, where the Supreme Court can issue writs such as habeas corpus, mandamus, certiorari, prohibition, quo warranto, only for the protection of fundamental rights. Can we give this power to the Supreme Court that you can issue writs not only for fundamental rights but for legal rights as well? For other rights as well, not necessarily fundamental rights? We can. Who will give this power to the Supreme Court? Not the state legislature, only the Parliament. Who will enact a law to restrict fundamental rights for the members of the armed forces, or those who are charged with the maintenance of law and order, or those who are working in intelligence, counterintelligence agencies of the government? Parliament will have the power, not the state legislature. Who will have the power to prescribe punishment for all those acts which are declared as offences under Part 3? Which is an offence? Untouchability is abolished and its practice in any form is forbidden. That will be determined by law, and that law, Atrocities Act, can be enacted only by the Parliament. Prohibition of traffic, begar, and other forms of forced labor. If somebody indulges in begar, somebody indulges in traffic, who has the power to prescribe punishment for those offences? Parliament. But is there any role of the state legislature in Part 3? Yes. Nothing in this article can prevent the state from making special provision for women and children. Who can make special provision for women and children? Parliament as well, state legislature as well. Nothing in this article shall prevent the state from making special provision for socially and educationally backward classes of citizens and reserving seats for socially and educationally backward class of citizens. Who has the power to make such a law? Parliament as well as state legislature. But on all these matters, for example, who has the power to declare residence as a qualification, to enlarge the jurisdiction of the Supreme Court, to provide for restriction of fundamental rights during martial law, or for those charged with maintenance of law and order, to prescribe punishment for those offenses under this law, that power is with the Parliament. For anything else, both Parliament as well as state legislature can come together. This is Fundamental Rights chapter, part 3 of the Constitution. If you have any questions now, please let me know. Can ordinary law be challenged for violating the basic structure? Ordinary laws can be challenged on only 2 grounds. One, violation of fundamental rights. Second, on the grounds of legislative competence. For example, state legislature is enacting a law and enlarging the jurisdiction of the Supreme Court, conferring more powers to the Supreme Court. This can be challenged in the court. This is an ordinary law. And the courts may be told that this is beyond the legislative competence of the state legislature. This is a power which is available with the Parliament. On this ground, ordinary law can be challenged. On the grounds that you're violating fundamental rights, freedom of speech and expression, freedom of religion, so on and so forth. For example, various anti-conversion laws have been enacted. Some of them have been challenged in the court. Ordinary laws can be challenged on the grounds of violating fundamental rights or on the grounds of legislative competence. Only constitutional amendment acts can be challenged on the grounds of violating the basic structure. Okay, let's look at part 4, and this is a very important part from where large number of questions have been asked each year in the prelims examination. Directive principles of state policy. In simple terms, what are those principles that the state has to keep in mind that will direct the state when the state is making policies, when the state is enacting laws? This is what we call directive principles of the state policy. And these directive principles, we say these are positive obligations. Positive obligations in the sense, fundamental rights, we say these are negative limitations, negative obligations, limitations on the powers of the state. Negatively worded as well. The state shall not deny equality. The state shall not discriminate. The state shall not do this. The state shall not do that. The state shall not do this. That means limitations on the powers of the state. That's fundamental rights. Which means in fundamental rights, we are telling the state, stay away. Don't interfere with the life and liberty of individuals. Stay away. Back off. But in directive principles of the state policy, we are urging the state, please come and interfere. Please come and interfere and implement a welfare state, enact a welfare state, establish a welfare state. That's the purpose of directive principle. Please interfere so that you can minimize the gulf between the rich and the poor. Please interfere so that you can establish Panchayati Raj institutions. Please interfere so that you can provide for uniform civil code. Please interfere so that you can separate executive from judiciary. Please interfere so that the means of production shall not be concentrated in fewer hands. Wealth cannot be concentrated in fewer hands. The operation of economic system and means of production should not result in the concentration of wealth to a common detriment. Please interfere so that material resources of a community shall be so distributed so as to subserve the common good. Please interfere so that we can provide for equal pay for equal work. Please interfere so that we can provide for maternity relief. Positive obligations, directive principles of the state policy. But when we say directive principle of the state policy, who is the state? That these DPSP should direct the state that when you are enacting laws, when you are making policies, these are the principles that you have to keep in mind. Who is that state? The state definition is provided under Article 36. And what is the definition of the state? Same, ditto, as the definition of the state under Article 12 of the Constitution, which we have covered. But Article 37 talks about two important characteristics of directive principle. One, they are not enforceable in a court of law. That means if your fundamental rights are violated, fundamental rights are enforceable in a court of law. They have legal enforceability. That if these rights are violated, you can directly knock the doors of the court under Article 32 and uphold, get your fundamental rights protected, safeguard. But if these DPSPs are not implemented, you cannot go to the court. If uniform civil, in long story short, if uniform civil code has not been implemented, I cannot go to the court under Article 32 and ask the Supreme Court, please issue mandamus. Please direct the Parliament that you shall implement uniform civil code. I can't do that because they are not enforceable in a court of law. Why? Does that mean these DPSPs are inferior? No. They are not enforceable in a court of law because the state needs time and resources to implement them. And these directive principles, they do not have legal validity, but they have political validity. They are not enforceable in a court of law, but they are enforceable in the court of the public. How? There was a time in 1998 that the then Delhi government headed by Srimati Sushma Swaraj, she lost power. Why? Because the onion prices shot up. Which means rise of the essential commodity prices. Which means concentration of wealth in fewer hands, rich becoming richer, poor remaining poorer. Which means the standard of living has been affected. Price rise, inflation affects the standard of living. You cannot go to the court and tell the court that since the onion prices have shot up, please dismiss Srimati Sushma Swaraj's government. You have to go to the court of the public and tell the public, vote them out. People voted them out. So who said this? Dr. Ambedkar. Dr. Ambedkar said these are the principles. These guide the state when the state is making laws, enacting policies. You have to ensure that through your policies, you are creating a welfare state. Whether that welfare state becomes a freebie state, whether everything that is given out as free, whether it is 200 units of electricity today announced by the Chief Minister of Tamil Nadu, where on the other hand, he is saying that the state is under 10 lakh crore debt and we will release a white paper on that. Be that as it may, whether it is freebie or welfareism, that's for you to decide, not me. But the point is, the objective of directive principle is to implement and establish a welfare state. If these DPSPs are not implemented, you can't go to the court. Because these DPSPs, they require time and resources to implement. How? If on 27th of January 1950, you were arbitrarily detained, you could have gone to the court would have come to your rescue. But if on the 27th January, Panchayati Raj institutions were not implemented, and if you had the power to go to the court would have directed the government to ensure that you are establishing Panchayati Raj institutions. The government would say, where is the time and resources for us to implement it? Please give us time. We will do it. But please give us time. That is why directive principles are not given legal enforceability. That's not because they're inferior to fundamental rights. It's because the state needs time and the resources to implement these directive principles of the state policy. And they don't have legal validity, but they have political validity. They're not enforceable in a court of law, but they're enforceable in the court of the public. Right or wrong? But although they are not enforceable in a court of law, at the same time, Article 37 talks about second important characteristic of DPSP is that it shall be the duty of the state to implement it. Because these directive principles are fundamental in the governance of the country. And it shall be the duty of the state to apply these principles in making laws. This was the question asked in, I think, 2013 prelims examination. Which of the following are fundamental in the governance of the country according to the Constitution? DPSPs, fundamental rights and fundamental duties, fundamental rights and directive principles. The answer is only directive principles of the state policy according to the Constitution. Right or wrong? Right. These are two important characteristics. But keep in mind two directive principles, 39B and 39C. Because these are the two directive principles which have primacy, superiority over two fundamental rights, Article 14 and 19. The state shall, positive obligation, direct its policy towards securing that the ownership and control of material resources of the community are so distributed as best to subserve the common good. Can private property also be material resource of a community and as such can be distributed so as to subserve the common good? Private, or is it only the government property? Is it only the public property? Can private property also come under the material resource of a community? The answer is not all private property. There can be some private property, but not all. And this is according to the judgment of the court, Maharashtra Property Association, Bombay Property Owners Association. 39C, the operation of the economic system does not result in the concentration of wealth to a common detriment, which means concentration of wealth needs to be minimized. If there is a concentration of wealth, it violates what? Does it violate equality? Does it violate directive principles of the state policy? It violates directive principles of the state policy. Specifically, these are the two directive principles that you have to keep in mind. Listen to me carefully. Some directive principles are socialistic in nature. Some are liberal intellectual in their nature. Some are Gandhian in principle. That means when you look at all these directive principles of the state policy, you can categorize them that some DPSPs are socialistic principles, some are liberal intellectual principles, some reflect the ideology of the Mahatma Gandhi. But is this something provided in the Constitution itself? No. Does Constitution classify directive principles as socialistic, liberal intellectual, Gandhian principles? No. Another important fact that you have to keep in mind. But which are these directive principles which were added by the 42nd Constitutional Amendment Act 1976? Such questions have been asked. Equal justice and free legal aid, participation of workers in the management of the industries, protection and improvement of environment and safeguarding of forest and wildlife. This is what we call all these principles which were amended by 42nd Constitutional Amendment Act. But how do you remember them? How do you remember them? 42nd Constitutional Amendment Act was in 1976. Who was the Prime Minister? Indira Gandhi. Indira Gandhi's son, Sanjay Gandhi. Sanjay Gandhi's wife, Maneka Gandhi. Indira Gandhi believed in socialism. So this socialistic principle, participation of workers in the management of industries, whenever you read this statement, assume it is socialistic and it was added by 42nd Amendment. When emergency was imposed, there was no rule of law in India. So you can say the irony is that when there is no rule of law during emergency, that time a directive principle was provided which would direct the state to provide equal justice and free legal aid. Or you can relate it this way. Since thousands of political workers, trade union leaders, activists, student leaders were arrested, give them free legal aid. For that, Constitution was amended. And third, Maneka Gandhi is known as a staunch animal welfare personal, environmentalist. Protection, improvement of environment, safeguarding of forests and wildlife. These were the three principles added because of the 42nd Constitutional Amendment Act 1976. Right? Very good. Then there were principles which were either added later or modified. For example, 43 capital B, promotion of cooperative societies, added later, 2011. Initially, the directive principle was that the state shall have to take steps to provide for education to all the children in the age group of 6 to 14 years. But this became later a fundamental right. This was done by the 86th Constitutional Amendment Act 2002. Now that since this is already a fundamental right, that's how Article 45 was recast, modified to now provide for early childhood care for all the children below the age of 6. Because 6 to 14, now it is already a fundamental right. This was modified in 2002. Right? Great. Remember these directive principles. Article 49 talks about protection of monuments and places and objects of national importance. Article 50, separation of judiciary from executive. There is no separation of legislature from executive, separation of executive from judiciary, because you can't separate legislature from executive in a parliamentary democracy. Promotion of international peace and security. All these questions have been asked in your previous years. That's why DPSP is a very important chapter. The state shall endeavor to promote international peace and security, to maintain just and honorable relations between nations, to foster respect for international law and treaty obligations and dealings of organized people with one another, to encourage settlement of international disputes through arbitration. All these are directive principles of the state policy under Article 51. This completes our Part 4 of the Constitution, Directive Principles. If there is any question, let me know so that we can move on to the next part. Why do you need a break? Study. Less time now. Okay. Part 4 capital A. We'll discuss Part 4 capital A and then we'll take a break. Part 4 capital A, dealing with Article 51 capital A, it was not part of the original constitution. It was added later. When? Through 42nd Constitutional Amendment Act 1976. Based on the recommendations of Sardar Swaran Singh Committee. But you need to keep in mind that not all the recommendations of Sardar Swaran Singh Committee were accepted. Some were accepted, some were not accepted. Initially, 10 fundamental duties were provided. Later on, one more fundamental duty was provided by the 86th Constitutional Amendment Act 2002. So now we have 11 fundamental duties in total. Clear? Srimati Indira Gandhi was asked, why is there a need to add fundamental duties chapter? She said, people are more aware of their rights. I want to make them aware of their duties as well. The purpose of fundamental duty is to educate people. Educate people and make them responsible as well. Which are these 11 fundamental duties? We will try and remember. But listen to me carefully. To abide by the Constitution and respect its ideals, national flag and national anthem. What about national song? Now, if you disrespect the national song, action will be taken against you. But is this national song mentioned as a fundamental duty in Article 51 capital A? You have to understand, no. But all these fundamental duties, these are not legal duties. Not legal duties, and as such, no mandamus. Legal duty, mandamus, what is the relationship? How can you approach the Supreme Court, and why and on what grounds can the Supreme Court issue the writ of mandamus? Mandamus means we command. For example, there is a public body. For example, this public body, let's say Election Commission. Or let's say the government of the day. The government of the day had to provide me voter identity card. Or the government of the day had to clean the garbage. Or the government of the day, a university had to provide me with, let's say, degree certificate. But they are not doing this duty because they have a duty of providing me degree certificate. They have a duty of cleaning the garbage. They have a duty of providing me electoral photo identity card, EPIC, but they're not giving me. What I will do, can I approach the Supreme Court? No. Because I can approach Supreme Court only if my fundamental rights are violated. But these are my legal rights. I approach the High Court. What High Court will do? A High Court will issue a writ of mandamus. We command this public body, this university, issue the degree certificate to this petitioner. We command. That means the legal duty. You can go to the court will issue the writ of mandamus, command that public body that you have to perform your duty. But what if these students who are now preparing for the civil services examination, I approach the court and say, to value and preserve the rich heritage of our composite culture, these civil services aspirants, they are not fulfilling this duty. I want you, dear Supreme Court, or I want you, dear High Court, issue the writ of mandamus so that they develop and preserve the rich heritage of our composite culture. The court will say, get lost, because these are not legal duties. As such, if somebody is not following them, you cannot come to us and ask us to issue mandamus, because these are not legal duties. Then what is the utility? I told you that utility is to educate people and make them responsible. But can some of these duties be made legal duties? In a sense that if you disrespect national flag or national anthem, can you be booked for violating fundamental duty? No. You'll be booked for violating the law. Prevention of Insults to National Honors Act 1971. If you're resorting to pollution of water bodies, or if you're killing a wild animal, you will be arrested and prosecuted not because you have violated the fundamental duty of having compassion towards the living creatures, wildlife, but because you have violated the Wildlife Protection Act. You have violated the Environmental Protection Act. You have violated XYZ law. That's something that you have to keep in mind. Fundamental duties, not originally part of the Constitution, added by the 42nd Constitutional Amendment Act, based on the recommendations of the Sardar Swaran Singh Committee. Initially, there were 10 duties. Now there are 11 duties. 11th one was added in 2002. These are not legal duties, which means no mandamus can be issued. Constitution does not prescribe any punishment for the violation of these fundamental duties, but these fundamental duties are there for educating the public. They hold educational value so that the citizens can become responsible. And these fundamental duties are exclusively available for the citizens of India, not for the foreigners. But sir, how do we remember these fundamental duties? Some of you would know, some of you would not know. There is an acronym. Acronym in the sense, sometimes I'm slightly worried about sharing it, but then nevertheless we need to share. For example, you are a senior superintendent of police, but you are a corrupt person. One fine morning, you're having breakfast, coffee, whatever, sunny side up. There's a knock at your door. Who's this? There are people from anti-corruption unit. Why are you here? Because we have to arrest you. Why? Because you are a thief, guilty of resorting to corruption. What's the proof? They will show you a DVD. So what will happen now? Now everybody will come to know that I'm corrupt. I have taken this bribe. You will call Arnab Goswami that please don't broadcast this news because the nation does not really want to know that I was arrested and on what grounds. This is what we call in corporate language PR, public relations. Pay the journalists so that they don't publicize the story. Ultimately, you will win. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 fundamental duties. How 11 fundamental duties? To safeguard public property and to abjure violence. Another is to strive towards excellence in all affairs of individual and collective activity. P, to protect and improve natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. A, to abide by the Constitution, respect its ideals, the national flag and the national anthem. C, to cherish and follow the noble ideals which inspire our struggle for freedom. U, to uphold unity, integrity of India. D, to defend the country and render national service when called upon to do so. V, to value and preserve the rich heritage of our composite culture. D, to develop scientific temper, humanism, and spirit of inquiry and reform. PR, to promote harmony and to renounce, where is R? And to renounce the practices which are derogatory to the dignity of the woman. And W, who is a parent or guardian, to provide educational opportunities for children or your ward, if you're a guardian, between the age of 6 to 14 years. Because now it's a fundamental duty on parents, on guardians, that for your children, your ward, you have to provide them educational opportunities if your kids are in the age group of 6 to 14. And I don't have to tell you, it is this fundamental duty which was added by 86th Constitutional Amendment Act. Because of 86th Constitutional Amendment Act, right to education became a fundamental right. 21 capital A was added. So when 86th Constitutional Amendment Act was passed, you have to keep in mind that not only was Article 21 capital A added, Article 51 capital A Clause K was added, and Article 45 was modified. Because Article 45 previously spoke of providing the state, it was a positive obligation on the state that you have to provide educational opportunities to the children in the age group of 6 to 14 years. That was then recast, modified to provide for early childhood care in the age group of up to 6 years. So these three articles were either amended or added by the 86th Constitutional Amendment Act. One related to directive principle, the other related to fundamental duty, and the other related to fundamental right. All the three parts. This is part 4 capital A. Done? Let's take a break. It is 5:30. Let's meet at 6 p.m. See you on the other side of the break. Now let's continue, and now the portions that we shall be covering in this segment, where we will discuss legislature and executive. These are the most important segments for your prelims examination. This is where large number of questions each year are asked in the prelims examination. When we say legislature, we will cover union legislature and state legislature together. Union legislature consists of president and the two houses. One is the Rajya Sabha and the other is the Lok Sabha. State legislature, governor and legislative assembly, and in those states where we have a legislative council. So keep in mind, conceptually, head of the state, president, governor, they are integral part of their respective legislatures. Clear? When we look at union legislature, mandatorily at the union, we have a bicameral legislature where there is Rajya Sabha and Lok Sabha. Articles 168 to 212 talks about legislature for a state, and it can be unicameral or a bicameral. For example, there are 6 states where we have a bicameral legislature in India. Which are those states? Andhra, Telangana, Bihar, Maharashtra, UP, and Karnataka. These are the 6 states where we have bicameral legislature. Otherwise, in all the states, we have unicameral legislature, which means there is only legislative assembly, there is no legislative council. But mandatorily at the union level, we should have 2 houses, Lok Sabha and the Rajya Sabha. And it is this Rajya Sabha which is known as the House of Elders. House of Elders, the upper house, the federal chamber of Indian legislature, whatever you call it. But so far as some facts are concerned for Rajya Sabha, very important. When was the first Rajya Sabha constituted? 1952. When did Rajya Sabha meet for the first time? 1952. But Constitution says House of the People, which is Lok Sabha, Council of States, which is Rajya Sabha. When was this Hindi name Rajya Sabha given to Council of States? It was named Rajya Sabha in 1954. Right? And who was the first chairman of the Rajya Sabha? Dr. S. Radhakrishnan. Who is the chairman of the Rajya Sabha? By virtue of you holding the office of the Vice President of India, the chairman of the Rajya Sabha is the Vice President of India. Clear? Who is qualified to be a member of the legislature? When we say at the union level and at the state level. Listen to me carefully, very important. What is the qualification? You have to be the citizen of India. Age 25 if you want to become the member of the Lok Sabha. 30, not 35. 30 is the minimum age for a Rajya Sabha MP. Ditto for Legislative Assembly and Legislative Council. If you want to become the member of the Lok Sabha, you should be a citizen of India. You must have completed 25 years of age, same as that of the Legislative Assembly. For Legislative Council, 30 years. Plus, you should be a registered voter. In any parliamentary constituency in the country. For example, you have to become the member of Rajya Sabha from Karnataka. Do you have to be necessarily the registered voter in Karnataka? No. You can be a registered voter in any parliamentary constituency of this country. That will make you qualified to become the member of the Rajya Sabha. Similarly, even if you are a registered voter in Delhi, you can be the Lok Sabha MP from Varanasi or the Lok Sabha MP from Wayanad. Clear? But so far as states are concerned, you should be the registered voter of that state. If you want to contest the legislative assembly elections, if you want to contest the legislative council elections, you should be the registered voter of that state. But apart from that, if these are the qualifications, what are the disqualifications? Few things you have to keep in mind. You cannot be holding office of profit. If you are holding office of profit, disqualified. If there is a change in the nature of citizenship, you were a citizen when you contested and won, later on the citizenship changed, you acquired the citizenship of another country, you're disqualified. Mental unsoundness. Or you have been adjudged insolvent. But this mental unsoundness is a legal declaration. That means it has to be proven in a court of law that you are mentally unsound. By that logic, all the members of the parliament should have been disqualified. But it's a legal declaration, not a medical declaration only. If you come under these disqualification grounds, you are disqualified. But who will disqualify you? President? If you are a member of the union legislature? Governor, if you're a member of the state legislature. But do governors and the president act on their own? Do they have a discretion in disqualifying the members of the legislature? No. They will have to refer this matter to the Election Commission of India, and whatever report is given by the Election Commission of India, this report is binding on the president and the governor. For example, if there is a matter that whether Shri Rahul Gandhi is a British national or an Indian citizen, and as such should be disqualified if you are holding the citizenship of another country, this matter should be sent to President. President will refer this matter to Election Commission of India, and whatever Election Commission of India says is binding on the President of India. But are these only grounds on the basis of which you can be disqualified? No, there are other grounds. Which are other grounds? Constitution says further disqualifications can be prescribed by Parliament by law. Which is that law? One law is the 10th schedule. Member of the legislature can be disqualified on the grounds of defection. Second, Representation of the People Act. Representation of the People Act also talks about disqualifications. Disqualifications in the sense, Section 8, Clause 1, Clause 2, Clause 3. Now there is a question. Can a member of the legislature be disqualified from the legislature only and only if this legislator is convicted by a court of law and sentenced to a jail term of 2 years or more? Is this correct? Is this correct or incorrect? Some say yes, some say no, majority say no, thank God. Very good. If you are convicted under Section 8, Clause 1, even if a fine is imposed, you are disqualified. Even if a fine is imposed, you are disqualified. And you are further disqualified for 6 years. Here, if you are convicted for those offences which are mentioned under Section 8, Clause 2, if you are sentenced to 6 months or more in prison, then you are disqualified and you are further disqualified for 6 years after your release. If you are disqualified or convicted under those offences mentioned under Section 8, Clause 3, it is for this that minimum you should be sentenced to 2 years in jail. Only then you are disqualified. For example, defamation. Maximum punishment in a defamation case, in a criminal defamation, because defamation is both a civil offense as well as criminal offense. If you are convicted under criminal defamation, maximum punishment is 2 years. Minimum can be 6 years as well, 6 months as well. So if there is a member of the parliament convicted under criminal defamation but sentenced to 1 year in jail or 6 months in jail, will he be disqualified? No. You will only be disqualified if you're sentenced to 2 years or more. Because defamation is considered an offense under Section 8, Clause 3. If you are convicted under Section 8, Clause 2, for example, adulteration of food, if minimum you are sentenced to 6 months in jail, only then you are disqualified. If you are sentenced to 1 month in jail, 2 months in jail, you will not be disqualified. Here, if you are convicted and only a fine is imposed, you are disqualified. And further, you will be disqualified for 6 years after your release. These are disqualifications, and these disqualifications are common for both state legislature members as well as union legislature members. Keep that in mind. Further, when we look at union legislature, the upper house is known as the Rajya Sabha. We say Rajya Sabha is the permanent house of Indian Parliament. And this permanent house of Indian Parliament means it is not subject to dissolution. But what about the upper house of the state legislature? It can be established or it can be abolished, which is that constitutional provision which talks about creation or abolition of upper house of the state legislature, Article 169. Who has the power to establish or abolish legislative council for a state? That power is available with the parliament. But can parliament act on its own? No. Parliament will have to act on the basis of the resolution passed by the State Legislative Assembly under Article 169. Which means what? For example, we have West Bengal, where there is no legislative council and we need to create a legislative council. Or we have Andhra, where there is legislative council but we need to abolish. Who has the power to either create or abolish the legislative council? That power is with the parliament under Article 169. How will parliament act? West Bengal Legislative Assembly has to pass a resolution, and that resolution is passed by flavor 2 of special majority, which means majority of the 2/3 members present and voting and majority of the total membership of the house. Flavor 2 of special majority. Once they pass a resolution, parliament will have to then decide whether it will accept this resolution or not, which means parliament may or may not. If parliament accepts, parliament will enact a law, and through that law, it will establish legislative council for West Bengal. Similarly, Andhra Pradesh Legislative Assembly. Legislative Assembly is important. Andhra Pradesh already has a legislative council. Does that mean to abolish legislative council, both legislative assembly as well as legislative council will have to pass a resolution by flavor 2 of special majority, request the parliament to abolish the legislative council for Andhra Pradesh? No. This power is only with the legislative assembly. But what if Andhra Pradesh Legislative Assembly passes a resolution urging the parliament to abolish legislative council? Parliament may or may not accept this resolution, which means this resolution is not binding on the parliament. But if parliament accepts, then parliament has to enact a law. Now this is where it becomes technical. Is this law an ordinary law? Or is this law a constitutional amendment act? That means parliament, while abolishing a legislative council, or parliament while establishing or creating a legislative council, does parliament have to pass or enact an ordinary law, or does it have to enact a constitutional amendment act? It is an ordinary law. Ordinary law passed by simple majority. Resolution from Legislative Assembly will be by special majority flavor 2, but parliament will enact a law, ordinary law, by simple majority. Clear? Very good. What is the composition of the Legislative Council? For example, if you look at Rajya Sabha, what is the maximum strength of Rajya Sabha? The maximum strength of Rajya Sabha is 250. 238 are supposed to be elected and 12 are supposed to be nominated. Nominated by the president from the fields of art, literature, science, social service. 238 are to be elected. Elected by states and UTs. Is the Rajya Sabha or do union territories get representation in the Rajya Sabha? Yes. Which union territories? If the union territories have a legislative assembly. How many union territories have legislative assembly? Delhi, Puducherry, Jammu and Kashmir. Which means MLAs of these three union territories with legislative assembly, they get to elect their representatives to the Rajya Sabha. Which means the Rajya Sabha represents states as well as those union territories which have a legislative assembly. Because all union territories do not have legislative assembly, that is why all UTs are not represented in the Rajya Sabha, which means the current strength is 245. Right or wrong? Right. But the fact is, how are these Rajya Sabha MPs elected? States and union territories, their MLAs will vote. How will they vote? Through a system of proportional representation system by means of single transferable vote through open ballot. Through open ballot. What does that mean? That means all the MLAs of Delhi Legislative Assembly, they will vote and elect their MPs to the Rajya Sabha. Which means we will get to know, for example, elections have taken place to West Bengal, to Tamil Nadu, to Kerala. Now you will see more Rajya Sabha MPs from BJP in Rajya Sabha from West Bengal, because now they have more than 200 MLAs in the state legislative assembly. More MPs belonging to the Congress party in the Rajya Sabha from the state of Kerala. More MPs, for the first time, MPs from TVK in the Rajya Sabha from the state of Tamil Nadu. Proportional representation system. But whenever these MLAs will vote, they will have to also display their vote to their party representative. So every party will have a representative, which means some sort of an observer. Which means if I'm an MLA belonging to the Congress, I will have to show my vote to the Congress representative that, see, I'm voting for your candidate, for our candidate, for the party nominee. I'm not cross-voting. But what if I am cross-voting? Can whip be issued in Rajya Sabha elections? Can the political party make it mandatory, binding on its MLAs that you have to vote for the party nominee by issuing a whip? No. Whip is not binding in case of Rajya Sabha elections. Now the question is why? This may be asked in the examination. Whip is not binding in case of Rajya Sabha election because Rajya Sabha election is not considered to be the proceeding of the legislature. Then what is the proceeding of the legislature? Voting on bills is a procedure. Voting on confidence, no confidence motion, adjournment motion, censure motion is the proceeding of the legislature. So voting for Rajya Sabha elections is not considered to be the proceeding of the House. When it is not the proceeding of the House, that means the whip is not binding. Clear? But we have seen in the Rajya Sabha elections that there is cross-voting. Whip cannot be issued. But the question is can. Listen to me carefully. Can not voting for your party nominee in a Rajya Sabha election lead to disqualification of a legislator under the 10th schedule of the Constitution, anti-defection law? The question is can. Not whether Constitution provides for it. The question is can. And the answer is a yes. Why? Because the interpretation of 10th schedule is this. Listen to me carefully. Under the 10th schedule, who can be disqualified? If I belong to a political party, but I voluntarily resign from that party, I will be disqualified. If I belong to a house but I abstain from voting, disqualified. If an independent member joins a political party after the election, disqualified. If a nominated member joins a political party 6 months after the nomination, disqualified. These are the provisions of anti-defection law. But what do we mean by voluntary resignation? If I belong to a house can be Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council, but I belong to a political party. How do I belong to the political party? Because political party gave me the ticket to contest the election. Because of that, I won the election and became the member of the house. Now, if I voluntarily resign from this party, I should be disqualified. But the courts had to interpret what is this voluntary resignation. The court said, we have to see your conduct. If your conduct outside the house is such that we can assume that you have voluntarily resigned from your political party. Conduct outside the house. Rajya Sabha election voting is not the proceeding of the legislature, which means it is the conduct of a member outside the house. If you have not voted for your party nominee, we can assume that you have voluntarily resigned from your political party, even if you have not submitted formal resignation. This can be the ground of disqualification under the 10th schedule of the Constitution, although not mentioned in the Constitution. But if this is the composition of the Rajya Sabha, what about Legislative Council? MLCs, members of the Legislative Council, they are elected by MLAs. But not only MLAs. The uniqueness of Legislative Council is that it is much more diverse in terms of its representation, in terms of its composition as compared to Rajya Sabha. In the Rajya Sabha, we have two kinds of legislators, either nominated or elected. In Legislative Council, we have a diversity. Diversity in the sense, 1/3 are elected by municipalities and district boards, local bodies. 1/12 are from the graduate constituencies. 1/12 are elected by teachers' constituency. 1/3 are elected by the MLAs of the Legislative Assembly. And the remaining ones are nominated by the governor from the fields of art, literature, science, social service, cooperative service. This cooperative service is not mentioned for the Rajya Sabha MP. This cooperative service is mentioned for the Legislative Council, MLC, if you are to be nominated by the governor. This is something that you have to keep in mind. Let's proceed further. When it comes to union legislature, we have a lower house, Lok Sabha, Legislative Assembly corresponding. Rajya Sabha, Legislative Council only in 6 states. What is the maximum strength of the legislative of the Lok Sabha? 552. Out of 552, 530 are to be elected by the states, 20 from union territories, and previously we had 2 nominated MPs in Lok Sabha, nominated from the Anglo-Indian community. But now, because of the 104th Constitutional Amendment Act, there is no reservation in Lok Sabha for the Anglo-Indian community. But even then we say the maximum strength is 552. Or we can say now the maximum strength, because of this 104th Constitutional Amendment, maximum strength is 550. Right? What about legislative assemblies? Do they also have a fixed number prescribed by the Constitution? No. Constitution provides for a range. And the range is minimum we can have 60 MLAs, maximum we can have 500 MLAs. Similarly for Legislative Council, minimum we can have 40, maximum we can have 1/3 of the strength of the Legislative Assembly. This question has been asked in the examination, so please be attentive and careful. That does not mean every state should have a minimum of 60 MLAs. There are some states which are exceptions. For example, Goa, Sikkim, Mizoram, they have less than 60 MLAs. Even that is allowed. For example, Sikkim is mentioned in Article 371 that the Legislative Council will have 30 MLAs. Otherwise, the range is provided. 60 and maximum it can go up to is 500. Clear? Very good. What's the tenure? Lok Sabha's tenure is 5 years, Legislative Assembly tenure is 5 years. Mamta Didi said, I won't resign because I have not lost the election. Governor said, doesn't matter, Didi. I am dissolving the Legislative Assembly. Why? Because your term is 5 years. Once the 5-year term is over, governor is bound to dissolve the Legislative Assembly. Can we extend the term of the Lok Sabha or Legislative Assembly? 1 year at a time. When? Only during national emergency. So when national emergency is in place, the term of the Lok Sabha or the Legislative Assemblies can be extended 1 year at a time. Is there any upper limit? No. But each time it can be extended 1 year at a time. Lok Sabha can be dissolved, Legislative Assembly can also be dissolved. You might have read that 1/3 members retire every 2 years in the Rajya Sabha. Is that true for Legislative Council as well? Yes, 1/3 members retire every 2 years. Clear? First up. What is the difference between Article 87 and Article 86? The President addressing both houses of the Indian Parliament. Listen to me carefully. Without looking at the screen, looking at the text, look at me, look at my face. The President addressing both houses of the Indian Parliament after every general election and the first session every year. Do we call it special session? Or do we call it a normal joint house session? It is called special address by the President under Article 87. So at the commencement of the first session after every general election to the House of the Public, House of the People, which means Lok Sabha, and at the commencement of the first session of each year, the President shall address both Houses of the Parliament together. This is called presidential address. Once this presidential address is given, the text of this address is provided by the cabinet, by the government. Then there is motion of thanks. Members of the Parliament, they thank the President for giving the speech, wonderful speech, fantastic speech. Then there is voting. Vote on motion of thanks. If this vote is defeated in the Lok Sabha, which means if simple majority is not obtained, the government has to resign, because this amounts to no confidence against the party in power. Because after all, the text is prepared by the cabinet, delivered by the President, but it is the government speech. And since voting has been defeated, it amounts to loss of confidence by the Council of Ministry. What if this vote of thanks is defeated in the Rajya Sabha? Doesn't matter. Will have no impact on the stability of the government. Why? Parliamentary democracy. Parliamentary democracy means Council of Ministers are collectively responsible to the Legislative Assembly, collectively responsible to the Lok Sabha, not responsible to the Rajya Sabha. But then under Article 86, there is a separate joint sitting or joint address. The President may address either house of the Parliament, either house. Here it is, the President will address both houses of the Parliament. This is called special address. After the general election and first session every year, this is called special address, joint session, both. But under Article 86, the President may address either house of Indian Parliament or both houses together. For what purpose? I will tell you why I am summoning you. Maybe this is the 75th year of India's independence. Maybe it is the 100th year of India's independence. Maybe something special has happened. I want to address both of you together. That is provided under Article 86, but that is not a special address. Special address is Article 87. Special address has to be both houses of the Parliament assembled together. This address under Article 86 can be either only for Lok Sabha, can be only for the Rajya Sabha, can be for Lok Sabha and Rajya Sabha together, but I will tell you for what it is. Whether it is with regard to any bill, for example, Women's Reservation Bill, I want you to vote on this Women's Reservation Bill so that we can implement this in 2029 itself. For that, I will address both houses of the parliament, or only Rajya Sabha, or only Lok Sabha. So it can be with respect to a bill or otherwise on any other matter. That's Article 86. So know the difference between Article 86 and 87. Plus, what are the legislative powers? Parliament has the power to make a law on any item mentioned in the union list, any item mentioned in the concurrent list, provided under the 7th schedule of the Constitution. Similarly, state legislature has the power to make a law on any item mentioned in the state list or any item mentioned in the concurrent list under the 7th schedule. But can state legislature, under any circumstance, make a law on union list? No. Such a power has not been prescribed for the state legislature. But can Parliament, union legislature, make a law on any item mentioned in the state list? Yes. What are those provisions? Article 249. In national interest, if a Rajya Sabha passes a resolution by 2/3 of the members present and voting, saying it is expedient in national interest, it is necessary in the national interest that Parliament makes a law on state list, Parliament becomes empowered to make a law on state list. What is the validity of this law? 1 year. Can it be extended further? Another 1 year. Can it be extended further? Another 1 year. Can it be extended further? Another 1 year. But each time you have to get the Rajya Sabha's approval. Rajya Sabha has to pass a resolution by 2/3 of the members present and voting. And that's how Parliament becomes empowered to make a law on state list. Similarly, when there is national emergency under Article 352, can Parliament make a law on state list? Yes. What is the validity of that law? 1 year? 2 year? 3 year? That law will continue as long as there is national emergency. But if national emergency is revoked today, this law will continue for a further period of 6 months. After that, the law will lapse. Which means the validity of a parliamentary law on an item mentioned in the state list depends upon for how long national emergency is in place. If the national emergency is revoked, this law will continue for a further period of 6 months. After that, it lapses. Under Article 252, when 2 or more states request the Parliament that you make a law on an item mentioned in the state list, Parliament becomes empowered to make a law on that state list. What is the validity of that law? Perpetual. It amounts to as if you have surrendered that subject. Parliament may never give this subject back to you. But the condition is 2 or more states, not less than 2. 2 or more states. Only 1 state requesting, Parliament will not enact a law. 2 or more states are requesting the Parliament to enact a law on a state list. Parliament becomes empowered to make a law on that state list. And is there any validity? These trap points are important. So you might be confused during the examination. The law under Article 252 also will have 1 year validity, or it will remain in force for 1 year and then it can be extended further. No, it amounts to surrendering your power, which means the validity will be forever. Parliament may tomorrow give this power back to you, but that's for the Parliament to decide. Similarly, if we want to implement an international agreement or an international treaty, for that Parliament becomes empowered to make a law, even if that item is on the state list. For example, we ratified United Nations Convention Against Corruption. Once you ratify a convention, that means now you have to establish structures, put structures in place so as to implement that convention. For that, we needed a strong anti-corruption ombudsman, Lokpal at the center, Lokayukta in the states. Lokpal and Lokayukta Act was enacted by the Parliament in 2013. But you understand, creation of a Lokpal is the job of the Parliament because it's under Union. How can Parliament enact a law on Lokayuktas? It can. Why? Because it is under Article 253, because we are trying to give effect to an international agreement. Similarly, when President's rule is in place, Parliament becomes empowered to enact a law on any item mentioned in the state list for that particular state. What is the validity of that law? Is the validity same as the validity of a law under Article 250? No. Which means, listen to me carefully, the law enacted by the Parliament for a particular state, because the state was under President's rule, this law will be valid even after the President's rule has been revoked. It is for the new Legislative Assembly to decide whether we want to continue with that law, or we want to modify that law, or we want to repeal that law. But that law's validity does not depend upon the continuance of President's rule. Even beyond President's rule, the law will continue. There are some bills which cannot be even introduced in the Legislative Assembly of a state unless and until prior approval of the President is given. Prior recommendation of the President is taken. Which is that bill? A bill if you want to impose a restriction on interstate trade and commerce. If a legislature of a state wants to enact a law, pass a bill which imposes restrictions on the interstate trade and commerce, such a bill under Article 304 cannot be even introduced in the legislature without the prior recommendation of the President of India. And this tells us the weakening of the position of the states vis-a-vis union when it comes to the legislative powers. And this is what we say, Constitution creates a strong center as against the strong states. And it is only this union legislature which has a constituent power. Constituent power in the sense, can the state legislatures amend the constitution? Introduce a constitutional amendment bill? No, only the union legislature has that power. States can only ratify, but union legislatures have the power to enact those bills, constitutional amendment bills. This is something that you have to keep in mind. What about ordinary bills? Now, what is an ordinary bill? Please keep one definition in mind. A bill which is neither a money bill under Article 110, nor a financial bill under Article 117, nor a constitutional amendment bill under Article 368. If it is a bill other than a money bill, other than a financial bill, other than a constitutional amendment bill, we call such a bill an ordinary bill. And ordinary bills can be introduced where? Either of the two houses. Just like in state legislature also. It can be introduced in either Legislative Assembly or Legislative Council. But if there is a deadlock, there is a joint sitting under Article 108. Deadlock in the sense, listen to me carefully. Mentioned deadlock here. What's the deadlock? Lok Sabha, Rajya Sabha. It can be either this or that, which means you can call it Rajya Sabha, you can call it Lok Sabha. Call it Rajya Sabha, call it Lok Sabha. Bill has been passed by Lok Sabha. Bill has been passed by Rajya Sabha. Is there any dispute? The bill is passed. Bill has been passed by Lok Sabha, bill has been rejected by Rajya Sabha. There is a deadlock. Bill has been passed by Lok Sabha, bill has been amended by Rajya Sabha. When it has been amended, it will go back to Lok Sabha. Lok Sabha looks at these amendments, says amendments are okay. The bill is passed because now there is no confusion, no dispute. But Lok Sabha rejects these amendments, which means passes the same bill again. These amendments are not acceptable. to the other house, there is a deadlock. Or Lok Sabha passes a bill, Rajya Sabha does not act on this bill for 6 months. We say there is a deadlock. And to resolve this deadlock, the president may notify joint sitting of the two houses. And when there is a joint sitting of the two houses, in this joint sitting, what is the majority required for this bill to be passed? The majority required is simple majority. Which means in this joint sitting, the will of the Lok Sabha prevails. Because of the numerical strength of the Lok Sabha, it is the will of the Lok Sabha which prevails over Rajya Sabha in the joint sitting. But who will preside over this joint sitting? Speaker of Lok Sabha. If Speaker is not present, then the Deputy Speaker of the Lok Sabha. If Deputy Speaker is not present, then the Deputy Chairman of Rajya Sabha. If Deputy Chairman also is not present, then anyone chosen at this joint sitting. These facts are extremely important. Extremely important in the sense there should be no doubt whatsoever. This is a joint sitting. Who will preside over joint sitting? Speaker. In absence of the Speaker, Deputy Speaker. In absence of Deputy Speaker, Deputy Chairman of the Rajya Sabha. What if Rajya Sabha Deputy Chairman is also absent? Can the Vice President of India, who is the Chairman of the Rajya Sabha, preside over joint sitting? No. Why? Because since this is a joint sitting and the Rajya Sabha Chairman, who is the Vice President of India, is not a member of the Rajya Sabha, he cannot preside over this joint sitting. Then who can preside? Anyone chosen at this joint sitting. Anyone chosen. Or will it be somebody who is chosen by the President? No, anyone who is chosen at this joint sitting. At this joint sitting, who can be chosen? You can be from Lok Sabha, you can be from Rajya Sabha. Do you have to be necessarily from Lok Sabha? No. Anyone chosen at this joint sitting will preside over the joint sitting. But under no circumstance will the President get to decide who will preside over. Under no circumstance will the Vice President of India preside over the joint sitting. Keep this distinction in mind. Right? Very good. Let's continue further. Money bills can be introduced only in the Lok Sabha, that too with the prior recommendation of the President of India. Similarly, in Legislative Assembly also, it can be introduced only in the Legislative Assembly, that too with the prior recommendation of the Governor. One conceptual question. Do these money bills necessarily have to be government bills? Or can these money bills also be private bills, private members' bills? This money bill can be either a government bill or a private member's bill. But Sir Lakshmikant says money bill necessarily has to be a government bill. Lakshmikant is wrong. Nowhere in the text of the Constitution is it mentioned that money bill necessarily has to be a government bill. The only requirement is it should get the prior recommendation of the President. If a private member can get the prior recommendation of the President, private members can also introduce a money bill. Now the question is not, will President and why will the President give recommendation to a private member to introduce a money bill? That's a separate matter. Will it happen? Will it not happen? We are not concerned with that. Can it happen? Yes. Not just that. Money bill is introduced in the Lok Sabha, passed in the Lok Sabha. What if it does not get the prior recommendation of the President? Even then you can introduce it. Really? Yes. How? I'll tell you. Lok Sabha passes this money bill. Money bill is sent to the Rajya Sabha. Do you know what differentiates a bill from a money bill? Certificate is issued to this money bill by the Speaker. Constitution says this certificate shall be final. So we don't know whether this was a money bill. But it has been certified as a money bill by the Speaker. When this money bill went to the Rajya Sabha, what are the options available with the Rajya Sabha? Rajya Sabha cannot reject a money bill. Rajya Sabha cannot even amend a money bill. Rajya Sabha can only make recommendations to a money bill. Or Rajya Sabha may not act on this money bill for 14 days. Even after the expiry of 14 days, the money bill is deemed to have been passed. Then this money bill will be sent to the president. President may say, how dare you introduce this money bill without my recommendation? I'm not going to sign it. He can do that. But what if he signs it? And then you go to the court. My lord, this money bill, when it was introduced in the Lok Sabha, prior recommendation of the president was not taken. Then how can this bill be passed by the parliament? It is unconstitutional. Here, what the court will say? Court will say this is only a matter of technicality mentioned in the constitution. Because if prior recommendation of the president was not taken, but later president signed it, it was just a matter of technicality that you should have introduced this money bill with the prior recommendation of the president. You did not seek my prior recommendation, but when the bill was passed, it was presented to me as the president, I signed it, which means I don't have a dispute over it. I don't have any questions on it. On this ground, that since this money bill was introduced without prior recommendation of the president, this cannot be the ground of declaring this bill unconstitutional if subsequently the president has given assent to this money bill. Can there be a joint sitting when it comes to a money bill? No. Can there be a joint sitting when it comes to the state legislative assembly? State legislature? No. Joint sitting is only at the union legislature level. Conceptually, you have to be strong. But financial bill can be introduced again with the recommendation of the president only in the Lok Sabha. But on this financial bill, there can be deadlock. And to resolve this deadlock, there can be a joint sitting. Now, the most tricky part, assent to bills. We say president is bound to act on the aid and advice of the Council of Ministers headed by the Prime Minister. Governor is bound to accept the aid and advice of the Council of Ministers headed by the Chief Minister, except when the governor is, according to the Constitution, bound to act in his discretion. Right? Ideally, all those recommendations are binding when it comes to executive matters. On executive matters, for example, we have to appoint the Attorney General for India. Advice is given by the Prime Minister to the President. President may ask, for example, the Prime Minister tells the President that Sarmad be appointed as the Attorney General for India. President will say, this boy, why? Don't appoint him. You will lose all the cases. Prime Minister will say, okay, I respect your counsel. We will drop him. We'll appoint someone else. So President has that power to ask the Prime Minister to reconsider that advice. But if the Prime Minister says, Madam President, don't interfere in my work. I'm asking you to appoint him, appoint him. This is binding on the President. She has to appoint me because it's an executive matter. But what if it's a legislative matter? On there, President has a discretion. President may say, okay, I'm signing this bill, which means I'm giving my assent. Or I'm withholding my assent, which means I'm not going to sign it. Or I will return the bill back for reconsideration. These are the options available with the president, where the president acts on her own. Similarly, the governor, what are the options available with the governor? Governor can give assent, governor can withhold assent, governor can ask for reconsideration of that advice, can ask the state legislature to reconsider that bill, or the governor can reserve a bill for the consideration of the president. But sir, this is where there is a confusion. Confusion is what? A two-judge bench judgment of the Supreme Court. Of April 2025 in Tamil Nadu case. And the presidential reference under Article 143 given by 5 judges. These 5 judges are Constitution Bench. Listen to me carefully. There is something called Judicial discipline. What is judicial discipline? If a judgment is given by a 5-judge bench, it is binding on the benches of lower strength. Can a 2-judge bench overturn the judgment of the 5 judges? No. Then you are violating the discipline. You can't do that. Can tomorrow a 5-judge bench of the Supreme Court say that there is no such thing as basic structure? No. How dare you? That violates judicial discipline because that judgment was given by the 13 judges of the Supreme Court. But if you want to review the Keshavananda Bharti judgment, you have to set up a bench which has more than 13 judges. That would be judicial discipline. Presidential reference given by 5 judges, according to which there is no timeline for the president or the governor. According to which there is complete immunity for the president or the governor. According to which there can be no mandamus issued to the governor if you are not acting on the bills. This is 5-judge bench, constitution bench, hearing a presidential reference. But a 2-judge bench of the Supreme Court in 2025 said there is a time limit, there is a timeline. Governor, come here. Bill has been passed by state legislature, it is sent to you. What are your options? So you tell me. See, if you go against the advice of the Council of Ministers, take the decision in 3 months. Which means what? The Council of Ministers is telling you, sign this bill. But you don't want to sign it. You want to return it. Or you want to withhold assent. Or you want to send it for the consideration of the President. You can't sit on this bill. You can't sit on this bill for an indefinite period. Because there is no such thing as pocket veto. Pocket veto is not provided by our Constitution. There is no such thing as pocket veto. Keep that in mind. But if you want to go against the advice of the Council of Ministers, you have 3 months. 3 months to do what? 3 months to reserve it for the President. Then President will decide. 3 months for you to return it to the legislature. Return how? You say, I am withholding my assent. When you're withholding your assent, that does not mean the bill is dead. It can never become a law. When you're withholding assent, you have to then send it back to the state legislature. If the state legislature passes this bill again, you have 1 month. To do what? To do just one thing, sign this bill. Now you tell me what will prevail now? This 5-judge bench of the Supreme Court in presidential reference or this 2-judge bench judgment in the April 2025 case? Because we have to keep in mind judicial discipline as well. Even then, this 2025 April judgment of 2 judges will prevail. Why? Because presidential reference by its very logic is an advice. It's not binding. If this judgment was reviewed by a 5-judge bench, then that judgment would have been valid. But this is not the review judgment. This is presidential reference. Only to give an advice. This advice is not binding on the government. That is why this April 25 judgment still prevails. Okay? Great. How does Constitution ensure that executive is under control of the legislature? For that, since we occupied this place here, the space here, let's talk about Legislative Assembly versus Legislative Council first. Legislative Council, Legislative Assembly. Legislative Council passes a bill. Legislative Assembly rejects a bill. What will happen to this bill? The bill is dead. This speaks volumes about the inferior nature of legislative councils. because the bills introduced originated in the Legislative Council. If they are rejected by the Legislative Assembly, the bill is dead. It can never become a law. Now, let's look at the different way. Let's say, where will I add it? Legislative Assembly passes a bill. Legislative Council also passes a bill. The bill is passed. There is no doubt. There is no dispute. Legislative Assembly passes a bill. Legislative Council rejects a bill. This bill will go back to Legislative Assembly. Legislative Assembly passes it again. Legislative Council says, how dare you pass it again? We rejected it the last time. Legislative Assembly says, reject it again. Because if you reject it again, it will be passed in the same manner, in the same form as passed by us. Legislative Council is inferior. Not just this. Legislative Assembly passes a bill, Legislative Council amends this bill. This bill will go back to Legislative Assembly. Legislative Assembly is furious. How dare you amend the bill passed by us? Don't you know we are directly elected by the people? Legislative Assembly amends this bill again and sends it back to Legislative Council. Now don't amend it further. Legislative Council says, so who are you? We are also elected by the people, not directly, indirectly by you. So we will amend it again. Legislative Assembly says, okay, you amend it again because the moment you amend it, the bill will be passed in the same manner in which it was passed by us. You are inferior. Legislative Assembly passes a bill. Legislative Council does not act on this bill for 3 months. This bill will go back to Legislative Assembly. Now, Legislative Assembly is furious. These guys, they have not acted upon our bill for 3 months. We will pass it again. Legislative Council says, you pass it again, but last time we did not act, we will not act again. If Legislative Council does not act on this bill for 1 more month, it will be deemed to have been passed in the same manner it was passed by Legislative Assembly. Which means the maximum Legislative Council can do, it can delay the passage of a bill by 4 months. That's it. So this is something that you have to keep in mind. Done. Executive is responsible to Lok Sabha, Union Executive. State Executive is responsible to the Legislative Assembly. Can the Rajya Sabha remove a government? No. Can Legislative Council remove a government? No. Why? Because this is what we have been discussing since afternoon. Parliamentary democracy. And parliamentary democracy says Council of Ministers collectively are responsible to the lower house of the legislature, which means Lok Sabha at the center and Legislative Assembly in the states. Further, within Lok Sabha or within the legislature, there are some tools available through which you can hold the government accountable. For example, question hour. This is there in Lok Sabha, Rajya Sabha as well. This is there in Assembly and Council as well. During question hour, you can ask questions. Can these questions be asked only of ministers? Mostly for ministers, but you can ask questions to private members as well. This is one of the myths that civil services aspirant they have developed, invented, that during question hour, the questions are asked only of ministers. Not true. You can ask question to a private member as well. But what sort of question will I ask a private member? Exactly. Which means if there is a need, you can ask. When is the need? For example, I am the private member. I have a private member's bill introduced in the legislature. You may have a question about it. Ask me. I will answer. But mostly it is for ministers. But that does not mean it is restricted only to ministers. And the questions can be either a starred question, unstarred question, or a short duration questions. Starred question, that means I'm asking you a question and I need an oral answer. If you are giving an oral answer, I will ask you 5 supplementary questions as well. If it's an unstarred question, that means I need an answer to this question, but it should be in the written format. But whenever I ask questions, it's not that randomly I will ask a question and you will come up with an answer. I have to give you questions beforehand so that you can prepare answers for it, because you need to give me authentic answer to these questions on the floor of the Parliament. Otherwise, you are violating and breaching my privilege. Which means even before the session starts, the questions are already given by the members of the Parliament through their portal, and then the speaker presents these questions to the respective ministers. But sometimes we need an answer to a question in less than 10 days. Those are what we call short duration questions. Right? That's something that you have to keep in mind. Question hour. Then there is 0 hour. 0 hour is an Indian innovation. Started in 1962. What is the 0 hour? In question hour, we have to first give notice to the ministers. We have already given them questions. Now they have to come up with answers. Is there a mechanism where we can ask urgent questions to the ministers without prior notice? For that, we have 0 hour. No confidence motion, is it mentioned in the Constitution? No. Where is it mentioned? It's mentioned in the rules of business and procedure of the Lok Sabha. This no confidence motion can be moved only in the Lok Sabha, because if this no confidence motion is passed, and what is the majority required to pass this no confidence motion? Simple majority. Then the government has only one option: resign. Similarly, this no confidence motion can be moved in Legislative Assembly only, because Council of Ministers are collectively responsible to either Lok Sabha or Legislative Assembly, not accountable to the upper houses. Censure motion, you are criticizing the policies of the union government. If this censure motion is passed, government need not resign. If this adjournment motion is passed, the government need not resign. But if this no confidence motion is passed, the government has to resign. There is another motion called confidence motion. Confidence motion is not mentioned in the Constitution. Confidence motion is not there in the rules either. But the difference is that no confidence motion is introduced by an opposition member, and confidence motion is moved by the Prime Minister himself or by the Chief Minister himself. Right? Very good. Further, when we talk about control over executive of Lok Sabha and the Rajya Sabha or the state legislature, control over the executive, how does legislature keep a control over the executive? Through questions, through motions, through resolutions, through budget, through debates. Once a question was asked, through which of the following tools is the legislature controlling the executive? Budget? Yes, if the legislature will not approve the budget, what is there for government to spend? That is how the legislature can keep a track and keep a check on the executive. Through debates also. That's how legislature keeps a check on the executive. Then there is something called calling attention motion. This calling attention motion is of Indian origin. That means Indian innovation. Can this calling attention motion be introduced in Lok Sabha or Rajya Sabha? Or only in Lok Sabha and not Rajya Sabha? or only in the Rajya Sabha and not Lok Sabha? Where is it introduced? I want you to know. Number of members required to introduce no confidence motion 50, censure motion 50, adjournment motion 50. What is this adjournment motion? For example, there is the agenda of the House. Today we are going to discuss XYZ bill. We are going to discuss the crisis in the Middle East. This is our agenda. This is what we want to do today. But if the opposition moves an adjournment motion, 50 members of the Lok Sabha are moving an adjournment motion to the Speaker. And the Speaker is told, please adjourn the normal agenda of the House. Let's discuss the matter of urgent public importance, urgent national importance. If this motion is accepted, there will be debate on this motion. This debate cannot last less than 2.5 hours. That means more than 2.5 hours should be allotted to debate this urgent matter of national importance. And after that, there is voting. If this adjournment motion is passed by simple majority, it amounts to censure of Council of Ministers, which means the government need not resign, but government is censured, extreme disapproval of the government. Drawing attention of the House to a matter of urgent national importance, urgent public importance. That's what adjournment motion is. Can we call the attention of an individual minister to a matter of urgent national importance, urgent public importance? For that, we have calling attention. This calling attention can be introduced in Lok Sabha as well, Rajya Sabha as well, which means it is similar to adjournment motion without its censure aspect, which means if this calling attention motion is to be decided, discussed, after that, there is no voting. Or even if you vote, that does not mean the government falls. Because even if this calling attention motion sails through, that does not mean the House does not have the confidence in the Prime Minister. That does not amount to the loss of confidence of the government. So analogous to adjournment motion is a calling attention motion, but the difference is it does not have the censure aspect of adjournment motion. Okay? Great. Who are the presiding officers? At the union level, we have Speaker and Deputy Speaker. Legislative Assembly, Speaker, Deputy Speaker. Rajya Sabha, Chairman, Deputy Chairman. Legislative Council, Chairman and Deputy Chairman. Now the difference is, Chairman is not an MP. Otherwise, Speaker, Deputy Chairman, Speaker, Deputy Chairman, all of them are elected by simple majority and removed by effective majority. Chairman and Deputy Chairman, they have to be MLCs. Chairman is not nominated by the governor, elected by the MLCs. Only in the Rajya Sabha, we have the chairman who is the ex officio chairperson. Whoever is the Vice President of India, that person is the chairman of the Rajya Sabha. But Constitution says the House shall choose two of its MLAs or MPs, one as the Speaker, the other as the Deputy Speaker. So both the positions, Speaker as well as Deputy Speaker, these are constitutional provisions under Article 93. The House shall choose two of its members, one as the Speaker, the other as the Deputy Speaker, both in Lok Sabha as well as the Legislative Assembly. The House shall, that means it is necessary. But the point is, Constitution says the House shall as soon as may be. So the Constitution does not talk about the time limit within which the Deputy Speaker should be elected or chosen. But in the last Lok Sabha, we did not have a Deputy Speaker. In the current Lok Sabha also, we don't have a Deputy Speaker. There have been many instances of states where there wasn't a deputy speaker. Rajasthan, Jharkhand, others. But it's a constitutional necessity because the constitution says the house shall. That means the post of the speaker and deputy speaker, these are not just for the sake of it. These are constitutional positions. The constitution says shall. We have to have speaker and deputy speaker. Why we do not have a deputy speaker, that's for the government to answer. But let's proceed further. One person, one value, one vote. That's how we can implement political justice in India. And political justice is one of the objectives of the Indian Constitution as mentioned in the preamble. Right or wrong? Right. That is why Constitution said after each census there should be readjustment. Which means after the census of 1951 there should be readjustment. After the census of 61 there should be readjustment. After the census of 1971 there should be readjustment. Which was done. That's how the seats in the legislative assemblies got increased. Seats in the Lok Sabha got increased. Readjustment after each census. But 42nd Constitutional Amendment Act was passed. The year was 1976, where the Parliament said, now we will not conduct delimitation. And we will pause delimitation till 2001. Why? No reason was given, but everybody realized what was the reason. The reason was to ensure that population stabilization takes place. Because the southern states argued that if on the basis of population we may get more seats in the Lok Sabha or less seats, but we have been fairly successful in implementing family planning programs. The northern states have not been successful. So we might witness a point where the southern states will be completely losing their voice, and the northern states, just because of their population, they are gaining more voice in the legislature. That is why Constitution was amended, saying no further delimitation till 2001. But then another Constitution was amended. When the time came for another readjustment or delimitation after the census of 2001, Mr. Vajpayee was the Prime Minister, another freeze implemented. We will not carry out delimitation, and if at all there is an increase in the seats, that will happen only after the census figures taken after 2026 are known. There is no census of 2021, 22, 23, 24, 25, 26. Now this process has begun. House listing has started. Population enumeration will take some time. This is India's first digital census. So if census is completed by 2027, which means census numbers are already known after the census of 2026, which means now on the basis of this census, there can be readjustment. Because now there is no longer a freeze. Because the freeze was only till 2026. Done? What is adjournment, prorogation, and dissolution? Adjournment is a brief interval in an ongoing session. Brief interval in an ongoing session. For example, we have had a session since 12 o'clock. At around 2:37, I give a break. Does that mean this polity marathon got over? No. We took a break, lunch break, coffee break. We will have a break again in some time. A brief interval in an ongoing session, that is adjournment. Who has the power to adjourn? This power is with the presiding officer. This presiding officer can be anybody Whoever is presiding over the house. Anybody in the sense? Either you are a speaker or you are a deputy speaker or you are a panel of chairpersons. Now, sir, what is this panel of chairpersons? If speaker presides over Lok Sabha, what if the speaker is not there? In his absence, deputy speaker has to preside over Lok Sabha. What if he is also not there or this post is vacant, this post has not been filled? Then the speaker, and remember this carefully, this we are talking about when the speaker is absent. When the speaker is absent, who will preside over Lok Sabha? Either the deputy speaker. What if he is also absent or vacant? Then a panel of chairpersons, maximum 10. The speaker, once he is elected as the speaker or chosen as the speaker, he will set up a panel of maximum 10 people so that if I am absent, anyone from this panel will preside over the Lok Sabha. Same is the case with the Legislative Assembly as well. And this individual who is presiding over Lok Sabha, he has the power to adjourn the House. An adjournment can be of two types. Adjournment with date and time specified, or adjournment sine die. When the presiding officer says the House is adjourned, we will meet 6 o'clock after the break. That's what I told you previously, which means I am telling you we are going for a brief break. There's a brief interval in an ongoing session, but I'm specifying the date and time when we are going to meet again. What if the speaker says the House is adjourned sine die, or the presiding officer says the House is adjourned sine die? That means we are ending, not the session, we are having a brief interval, but we don't know for how long this interval will last because we don't know when we are going to meet again. Normally, whenever the presiding officer adjourns the House sine die, President comes into the picture and prorogues the House. Prorogation means termination of the session. And who has the power to prorogue the House? President. If it is union legislature. Who has the power to prorogue the House? Governor, if it is the state legislature. And then there is dissolution. Dissolution means Lok Sabha is dissolved, Legislative Assembly is dissolved. Dissolution 1 is automatic. Legislature completing 5-year term, the Lok Sabha will be dissolved by the President. The Legislative Assembly will be dissolved by the Governor, just like it was done in West Bengal, in Tamil Nadu. But then this is automatic. The other is on the advice of the Prime Minister or Chief Minister. Prime Minister will advise the President, please dissolve Lok Sabha. President will dissolve Lok Sabha. Chief Minister will advise the Governor, dissolve Legislative Assembly. The Governor will dissolve Legislative Assembly. So does that mean this advice is binding on the President or the Governor? Yes as well as no. Yes, if the Prime Minister has the majority on the floor of the Legislative, on the floor of the Lok Sabha. No, if you have been defeated. A defeated Prime Minister advising the President to dissolve Lok Sabha may or may not be accepted by the President. Otherwise, it is binding on the President, binding on the Governor. Done? Great. Article 93, as I told you, talks about the Speaker and the Deputy Speaker of the House of the People. It's a constitutional requirement that the House shall, as soon as may be, elect, choose two of its people, two of its members. One is the Speaker, the other is the Deputy Speaker. Which means both the Speaker as well as the Deputy Speaker, they have to be MPs of Lok Sabha. A non-MP cannot be elected or chosen as the Speaker. But if you are holding the office of the Speaker or Deputy Speaker, When can you lose your office? You have to vacate if you cease to be the member of the House of the People. When do you cease? Listen to me carefully. For example, recently we saw in Karnataka, one MLA's election was quashed by the High Court. A BJP MLA was declared winner when postal ballots were recounted. You don't have to go too deep into that, but just understand the concept. I am the Speaker of the Legislative Assembly, or I am the Speaker of the Lok Sabha. I contested elections from Kota constituency in Rajasthan. I, Mr. Om Birla, I won the election. And after the election, I was appointed or chosen as the Speaker of the Lok Sabha. You filed a petition in the court that my election should be declared invalid, null and void, because I have resorted to unfair means. I have resorted to corruption, so on and so forth, corrupt practices. What if my seat has been declared vacant by the courts in an election petition, which means now I am no longer the member of the Lok Sabha? If I am no longer the member of the Lok Sabha, I shall vacate my post as the Speaker. I shall vacate my post as the Deputy Speaker. Or I can resign. I am the Speaker, I can submit my resignation to the Deputy Speaker. I am a Deputy Speaker, I can submit my resignation to the Speaker. So Speaker and Deputy Speaker, they resign by submitting their resignation to each other. Or I may be removed. On what grounds? These grounds are not mentioned in the Constitution. Three times in the past, we have witnessed some activity where we wanted to remove the Speaker. Now, this time also, Mr. Om Birla was sought to be removed. But the only condition, or we saw the chairperson of the Rajya Sabha, against whom there was also an activity that he should be removed, the previous one. The only criteria is, although the grounds for removal are not mentioned for the Speaker or the Deputy Speaker, but what is mentioned is that at least 14-day notice should be provided. Further, one privilege that is available with the Speaker. I am the Speaker of the Lok Sabha. Lok Sabha term got over. 5 years are over. Do I also resign along with other MPs of the Lok Sabha whose term also got over? No, I don't resign. I am the last person to submit my resignation. When do I submit the resignation? When the new Lok Sabha after the election is being convened for the first time. On that morning, I will submit my resignation and I will cease to be the Speaker of the Lok Sabha, because now the Speaker of the Lok Sabha is to be elected and someone else will be the Speaker. Is this a convention? No, this is a constitutional provision mentioned in the Constitution, provided further that whenever the House of the People is dissolved, the Speaker shall not vacate his house until immediately before the first meeting of the House of the People after the dissolution, which means when the new Lok Sabha will meet for the first time, if they are meeting today for the first time, morning of today, I will submit my resignation and I will cease to remain the Lok Sabha Speaker. Who I will submit my resignation to? The Secretary General of the Lok Sabha. Clear? Perfect. No person shall be the member of both houses of the Parliament. Which means, can you be at the same time representing Lok Sabha as well as Rajya Sabha? No. What if you are elected to Lok Sabha and the Rajya Sabha at the same time? You have 10 days to decide. Within 10 days, you have to choose. If I cannot choose, Rajya Sabha, Lok Sabha, Rajya Sabha, Lok Sabha. If I cannot choose, after the expiry of this 10-day period, my seat in the Rajya Sabha will fall vacant. Because we need to prioritize the Lok Sabha membership. Otherwise, unnecessarily, there is another fresh election. It amounts to voter torture. No person shall be the member of both the Parliament as well as the legislature of a state. For example, Mr. Nitish Kumar, MLC, got elected to the Rajya Sabha. Can you hold both the positions at the same time? No. What you have 14 days to decide. whether you want to retain Rajya Sabha membership or MLC membership. What if you are unable to decide? Then your seat in the Rajya Sabha falls vacant. And if there is an individual MP who is absent from Parliament for 60 days without permission, if you are absent with permission, then it's no issue. If you are absent without permission, then the House may declare that the seat becomes vacant. Then fresh election has to be conducted in that seat. This is also the power available with the Lok Sabha. Clear? Now listen to me carefully. When we talk about legislature, we spoke about union legislature, state legislature. What about UTs? Article 239 capital A talks about creation of local legislatures or council of ministers or both for certain UTs. This is very important provision. Constitution says under Article 239 capital A that Parliament may by law create for the Union Territory of Puducherry. What? A body. And this body will function as the legislature of that Union Territory, which means this body may be Legislative Assembly. But this Legislative Assembly can be elected or partly nominated or partly elected. That's for the Parliament to decide. Because Puducherry is a Union Territory. For states, all the MLAs have to be elected. There used to be one nominated MLA from Anglo-Indian community, but because of the 104th Constitutional Amendment Act, now we don't have that nominated MLA. But Parliament will get to decide for the UT of Puducherry that if we will give them a house, that house will function as the legislature. This legislature can be either completely elected or partly elected, partly nominated. Or we may not give them legislature, we will give them only council of ministers. That is also possible. Maybe for a union territory tomorrow we will only have a chief minister and council of ministers, not the legislative assembly. Or we can give them both legislature as well as chief minister. This is for Puducherry. What about Delhi? Delhi is a union territory. Delhi is the capital of India. And for Delhi, there is Article 239 AA. What it says? It says since the 69th Constitutional Amendment Act was passed in 1991, Delhi, the capital of Delhi, will be called as NCT of Delhi, National Capital Territory of Delhi. UTs, you would know, are administered by the union government, administered by the president through officers, and these officers can be suitably named. What is this suitably named? That means president may appoint an administrator for a union territory and give him the designation of a lieutenant governor, or may appoint somebody to take charge of the union territory and will call him chief commissioner, or may appoint somebody and give him the title of an administrator. So whatever title, whatever designation is prescribed by the president, that president will prescribe. But president will administer all these union territories through his agent known as the lieutenant governor. But Article 239 AA says that there shall be a legislative assembly in Delhi and maximum seats of this Delhi legislative assembly will be 70. At least 1/3 of the seats will be reserved for women. This is provided by 106th Constitutional Amendment Act, but not implemented yet. But in all these union territories, it is the president who is the head of the government. It is the president who appoints chief minister and ministers. Despite the fact that Delhi or Puducherry or J&K have a lieutenant governor, even then the chief minister or the ministers are sworn in by the president. Not directly, indirectly. The president may ask the lieutenant governor, you administer oath of office and secrecy to the Delhi chief minister, to Puducherry chief minister, to Jammu and Kashmir chief minister, but appointment will come from the president. Removal will also come from the president. Because after all, president is the executive head of all these union territories. One more interesting article is Article 240. It gives power to the president. That dear president, what you can do, you can give regulations for certain union territories. Why? For progress, their progress and good governance. Which are these union territories? Where the president has the power to make regulations for their good government. Andaman and Nicobar, Lakshadweep, Dadra and Nagar Haveli, Daman and Diu, Puducherry. These are the 4 union territories that you have to keep in mind. Very important. This is union legislature. Leader of the opposition in parliament. This is a statutory post. And this statutory post is both in Lok Sabha as well as the Rajya Sabha. But is there a criteria? We have heard that there is a criteria of 1/10 of the total strength. In Assam, it is 1/20th or 1/6. Who can be recognized as the leader of the opposition? This power is with the speaker. Speaker has to nominate you, recognize you. Chairman of the Rajya Sabha has to recognize you. That's the only definition of leader of the opposition. It's not mentioned in this law that you have to necessarily bag 1/10 of the seats. Not necessary. Any person who is part of the opposition can be recognized as the leader of the opposition by the speaker in Lok Sabha, by the chairman in the Rajya Sabha. And who can be appointed as the leader of the opposition? Somebody with the highest number of seats, apart from the ruling party, apart from those who are part of the ruling coalition. And this, if 2 or more parties have the same term, have the same strength, for example, TVK ends up getting, let's say, 60 MPs in 2029 elections. Congress will also get 60 MPs. This time, who is going to be the leader of the opposition? Because 2 of the largest political parties, they are at tie, 60 each. In this case, the speaker may decide that we will go ahead with Congress and give the leader of the Congress the opportunity to become the leader of the opposition. Why? Because when 2 or more parties which are in the opposition to the government, they have the same numerical strength, then the chairman of the Council of States or the speaker of the Lok Sabha will have to decide based on the status of the party. Which means if the Congress is a national political party and it has an existence for a long period of time, even before independence, TVK just became a political party and won the elections in Tamil Nadu. So by that logic, the status, if we have to differentiate on the basis of the status, then Congress will be, the leader of the Congress will be the leader of the opposition. Okay? There is no such thing as 1/10 of the seats, not mentioned in the law. But this leader of the opposition has the same status as that of the cabinet minister. Cabinet ministers, they don't take 2 salaries as the cabinet minister as well as the member of the parliament. Similarly, the leader of the opposition is not drawing a salary or an allowance as the member of the parliament. Because you take the salary and allowances of the leader of the opposition. Then there is another important law. The leaders and chief whips of recognized parties and groups in Parliament Facilities Act 1998. What does that mean? Party legislators. What is this party and legislators? I was given ticket by the BJP to contest elections, and I am Sunny Deol. I have no idea about politics. I know how to make movies, right? How to dance. My hand is very heavy as well, but I don't know anything about politics. But I have to be present in the Lok Sabha. I was not present, but I have to be present now if I'm elected again. But how would I know that on this particular bill, whether I should vote in favor or against? On this particular motion, whether I should vote in favor or against? I don't know. But since I was given ticket by the BJP, it is imperative on me to follow the directions of the party, because otherwise I don't know what to do. This is where the party will appoint a chief whip and tell Sunny Deol, why are you roaming around in a train with someone? You come here, there is a parliamentary session. So I'm asking you to come. I'm directing you to come. Come, attend the proceedings of the parliament. On this particular day, there is a voting. You have to vote in favor or you have to vote against. This is the job of the whip. And every political party has a whip. And what is that whip? For the ruling party, the Minister of Parliamentary Affairs is the chief whip of the government. And he is responsible to the leader of the house. Who is the leader of the house? Prime Minister. If Prime Minister is the member of the Lok Sabha. If Prime Minister is the member of the Rajya Sabha, then Prime Minister is the leader of the house in the Rajya Sabha. Which means Mr. Modi is the Prime Minister and the leader of the house in the Lok Sabha. In the Rajya Sabha, it may be Mr. J.P. Nadda. Previously, Dr. Manmohan Singh was the Prime Minister, but he was the leader of the House in the Rajya Sabha because he was not the Lok Sabha MP. But initially, it was Mr. Pranab Mukherjee who was the leader of the House in the Lok Sabha, and later on it became Sushil Kumar Shinde who was the leader of the House in the Lok Sabha, because if Prime Minister is not the member of this House, then a senior minister becomes the leader of the House. So this chief whip is responsible to the leader of the House. It is this chief whip who is the eyes and the ears of the leader of the party. He conveys the wishes of the leader to the members of the party and keeps the leader informed of the current opinion in the party. This is the job of the chief whip. Similarly, other political parties also have their whips. And the whip of the Trinamool Congress will tell its MPs whether you need to vote in favor or not. Now, since the Congress has ditched the DMK and now is part of the TVK-led alliance in Tamil Nadu, now the Miss Konimui, she has approached the Lok Sabha Speaker and said, please change our seating arrangements. Now, we have had a fallout. Now, we don't want to be seated with the Congress in the Lok Sabha. But what about other DMK members? How will they come to know whether we have to support the Congress on issues or we have to support the BJP? How do we get to know as individuals? For that, there is a whip. Every political party has a whip. Because party and the legislators, there is an umbilical cord. If you amputate, if you cut, if you sever this umbilical cord, then where is the relationship between the legislator and the party? After all, you are a legislator because party gave you the ticket. Otherwise, what is your existence? Whip recognized. How? The leaders and the chief whips of recognized parties and groups in Parliament Facilities Act 1998. Then who is the leader of the House? I told you Prime Minister, if Prime Minister is the member of that House. Otherwise, a senior minister. This practice we have seen in United Kingdom as well, because we have embraced parliamentary form of government, which is found in United Kingdom. There are a lot of conventions that we have incorporated from United Kingdom. There are a lot of things that we have imbibed from the United Kingdom. But there are also issues, there are also situations where we have departed from what is followed in UK. We don't follow that in India. For example, in Leader of the House case, we depart from the British practice. In Britain, Leader of the House, who is the Prime Minister, sits in the Business Advisory Committee. And it is this Business Advisory Committee which is presided over by the Speaker of the Lok Sabha. This Business Advisory Committee gets to decide how much time should we give a particular bill. How much time should we give to a particular member to speak on a particular bill? Basically, setting the agenda of the House is the job of the Business Advisory Committee. But Prime Minister does not sit in the BAC. He is represented in the BAC by Minister for Parliamentary Affairs, and since 1996, Leader of the House in the Rajya Sabha is also not the Business Advisory Committee member, but he is invited to its meetings as a special invitee. What is the job of this Leader of the House? The authoritative voice of the House is from the Prime Minister. For example, when Mr. Rahul Gandhi tried to provoke the Speaker of the Lok Sabha by saying, "Sir, the Prime Minister has not given you enough respect. You are the Leader of the House. We have to give you respect." The Speaker cut short Mr. Rahul Gandhi and said, "You're mistaken. I'm not the Leader of the House. The Leader of the House is the Prime Minister. I'm only the presiding officer of the House. The Leader of the House is the Prime Minister." Okay. One more important concept called lapse of bills. Here is a bill. Bill is a proposal. What if the House is adjourned? What will happen to this bill? Will it lapse? It doesn't. For example, we will not complete the legislature part right now. We'll take a break. Does that mean legislature part is done? You will have to do it on your own? No, once we return from the break, we will continue from where we left. Similarly, if there is a bill introduced in the Parliament and there is an adjournment which takes place, does that mean the bill lapses? It doesn't. If the House is prorogued, if the session is prorogued, what will happen to the bill? Will the bill lapse? No, it doesn't. The budget session has been prorogued. Tomorrow there will be monsoon session. We will take up this bill in the monsoon session. We could not take up this bill. We can take up this bill in the winter session. The bills do not lapse. But if the Lok Sabha is dissolved, all bills lapse except three. Except three types of bills, all other bills lapse. We're talking about bills. Which are these bills? Bills originating and pending in the Rajya Sabha. Both conditions need to be met. Those bills which originate in the Rajya Sabha and are pending in the Rajya Sabha, which means you can say these bills have not seen the light of the Lok Sabha. Now, Lok Sabha has been dissolved. Rajya Sabha cannot be dissolved. It's a permanent house, not subject to dissolution. This bill survives. It doesn't lapse. Bills awaiting President's assent. This bill also does not lapse. Why? Because both houses have passed the bill. Now this bill is waiting for the President. President signs this bill, the bill is passed. Why should it lapse? But hold on. What if the President has to return this bill for the reconsideration? In that case, the President will return it to the Rajya Sabha. A bill passed by both houses, then returned by the President to the Rajya Sabha. Will this bill lapse? No, because it has been returned to the Rajya Sabha. Rajya Sabha is the permanent house, not subject to dissolution. This bill will not lapse. Third type of bills, bills on which there was a deadlock. And to resolve this deadlock, President has already notified joint sitting. So there is this bill on which there is a deadlock. Now, on the advice of the government, I am notifying a joint sitting of the two houses to resolve the deadlock on this bill, because I cannot notify joint sitting on my own. I need the advice of the Prime Minister and Council of Ministers because that's not my discretionary power. But I've notified. And after notification, now there is a need to dissolve Lok Sabha. Will this bill lapse on which I have notified joint sitting? No, this bill will not lapse. These are the three bills which do not lapse. Now, what if I tell you, here is a bill. This bill is passed by Lok Sabha and now is pending in the Rajya Sabha. Will this bill lapse? A bill which is passed by Lok Sabha and is now pending in the Rajya Sabha. Will this bill lapse? Tell me the answer. Some say yes, some say no. This bill will lapse. But sir, Rajya Sabha is the permanent house. So what? What is the originator of this bill? Lok Sabha. It's not there. It has been dissolved. Both conditions have to be satisfied. Bills originating as well as pending in the Rajya Sabha. These bills will not lapse. If a bill's originator is Lok Sabha, now it is pending in the Rajya Sabha, it will lapse. It has to lapse. Okay? This is about the legislature. Now, shall we move ahead to executive or shall we take a break? Okay, let's continue. Executive. Union executive. State executive. Right? At the union level, we have president, vice president, Prime Minister, Council of Ministers, Attorney General for India. At the state level, you have to be absolutely sure who all are part of the state executive. Governor, Chief Minister, Council of Ministers, and Advocate General of the state. There is no concept of vice president at the state level or deputy governor at the state level. Otherwise, more or less matching. Whatever there is in the union level, that's there in the state level, because after all, we have the same system of parliamentary democracy, both at the center as well as in the states. Right or wrong? Right. The shortest article under the Constitution is Article 52, which says there shall be a President of India, which means this office of the President of India cannot remain vacant even for a brief moment. Somebody has to occupy this post at all times. If there is a brief interval in this office, we call such a position as interregnum. We have to prevent interregnum. Somebody has to occupy this post at all times. And then the Constitution says all the executive powers are vested in the President. But the issue is, what is this executive power? This executive power is not defined in the Constitution. When something is not defined, then what do? We either go to the courts and look at the interpretation given by the courts, or we follow the wisdom of constitutional experts. We follow books. According to courts, executive power is like a residue left over. When you exclude legislative powers, you exclude judicial powers. Whatever else is left, that's the executive power, and these executive powers are given to the president. The courts have said determination of the policy, carrying out general administration of the country, foreign policy of the nation, defense of the country, all these are executive powers, and all these executive powers are with the president. But that should not give you a misleading sense that president is all powerful constitutional functionary in India. That there shall be a president of India and all the executive powers are vested in the name of the president of India. No. Because you have to read both these articles with Article 74. Article 74 says there shall be Council of Ministers with the Prime Minister at the head to aid and advise the president. Initially, this is what was mentioned under Article 74. Later on, through a constitutional amendment, 42nd Constitutional Amendment Act 1976, Shrimati Gandhi was the Prime Minister. This provision, Article 74 was amended. Originally, it said there shall be Council of Ministers with the Prime Minister at the head to aid and advise the President. Now, one more line was added. Who shall act on that advice? That means it clearly says that President has no discretion. Whatever advice is given by the Prime Minister and Council of Ministers to the President, that is binding on the President. President cannot act on her own. She does not have a discretion. 2 years later, 44th Constitutional Amendment Act was passed. And this 44th Amendment said, provided the President may ask for reconsideration of that advice. But if the same advice is given again, President will have to act on that advice. Which means maximum what the President can do. The President is asked, appoint X as the Attorney General for India. She says, can I not appoint him? I will appoint Y instead. The Prime Minister may say, okay, Y can be appointed. If the Prime Minister says, no, X alone has to be appointed, the President cannot do anything but appoint X as the Attorney General. Long story short, Constitution says there shall be a President of India. All the executive powers are with the President, but she cannot exercise these powers on her own. She has to go by the advice given by Prime Minister and Council of Ministers. This is parliamentary democracy. Right or wrong? Right. But how is the President of India elected? President of India is elected by the people, but not directly, indirectly, through their representatives in an electoral college. Which means electoral college is what? Who have the vote? Who have the power to vote to elect the President of India? All those members are part of the electoral college. An electoral college consists of elected members of both houses of the Parliament. Elected? Not nominated? No, nominated members are not part of it. Where do we see the nominated members? Which means 12 nominated members to the Rajya Sabha. They cannot vote to elect the President of India. Similarly, elected members of the legislative assemblies of states. Which means all the elected MLAs of this country, all the elected MPs of this country, whether Lok Sabha or Rajya Sabha, all of them will be part of the electoral college. They will vote to elect the President of India. But sir, there are UTs which have a legislative assembly, where there are MLAs. For example, Delhi and Puducherry and Jammu and Kashmir. Explanation provided by Article 54 is, in this article, when we say electoral college consists of elected members of the legislative assemblies of states, this term states includes Delhi and Puducherry. Does it include the MLAs of Jammu and Kashmir? No. But sir, there are books which say yes, There are articles which say yes. I am saying no. Why? Listen to me carefully. If you change the manner and method of president's election, it is considered to be a federal provision of the Constitution. And to amend this federal provision, you require a constitutional amendment. And this constitutional amendment needs to be ratified by half of the states. Which means if you will provide this explanation that the state includes the Union Territory of Jammu and Kashmir, you need to introduce a bill under Article 368 to amend the Constitution. But this bill, if it is passed by both houses of the Parliament, should be sent to all the states. When one half of the states ratify this constitutional amendment, only then it can be sent to the President. Only then, once it is assented to by the President, that J&K, UT, MLAs will become part of the Electoral College. Otherwise, no. This process has not been done. And as such, J&K MLAs are not part of the Electoral College. Was it done, sir? When Delhi MLAs and Puducherry MLAs became part of the Electoral College, 100%. Constitution was amended. This constitutional amendment bill was ratified by one half of the state legislatures. Once they agreed that yes, Delhi and Puducherry MLAs should become part of the Electoral College, only then they became part of the Electoral College. Because changing anything in the manner and method of president's election is a federal provision, and amending federal provision requires ratification by one half of the states. What's the term of the president? These facts are extremely important. The term is 5 years from the date you enter the office. But you can also resign before completing 5-year term by submitting your resignation to the vice president. And do you know it is binding on the vice president to accept the resignation? Now, question is asked, if statehood is given to J&K, then what do you think? Then automatically they are part of the Electoral College. Because if J&K tomorrow becomes a state, then Electoral College consists of elected members of the legislative assemblies of the states. It is already a state, which means J&K MLAs are part of the Electoral College. Right? Great. Which article of the Constitution? What is the difference between Article 109 and Article 110? Article 109 talks about procedure for a money bill. What is the procedure? A money bill can be introduced only in the Lok Sabha, that too with the prior recommendation of the President of India. It needs to be passed by a simple majority by Lok Sabha. Then it is sent to the Rajya Sabha. Rajya Sabha cannot reject a money bill, cannot amend a money bill, can make recommendations, may not act on this money bill for 14 days. At the expiry of the 14-day period, the money bill shall be deemed to have been passed by both houses of the Parliament. Procedure, Article 109. But what is the definition of the money bill? That is provided under Article 110. And what is a money bill? A bill which talks about imposition of tax, alteration of tax, abolition of tax is a money bill. A bill which talks about withdrawal of money from Consolidated Fund of India is a money bill. A bill which talks about a charged expenditure is a money bill. A bill which talks about satisfying a court decree is a money bill. Right? These are definitions. 2 years ago, a question was asked on Article 109, that Article 109 talks about procedure for a money bill. There were some students who got confused. Money bill is spoken about in Article 110. So Article 109 may not be part of the money bill. It may be part of something else. Sometimes article numbers are asked directly, straight. Which provision of the Indian Constitution talks about the impeachment, talks about that president can be impeached on the grounds of violation of the Constitution? Is it Article 61? You might have read about Article 61, but it's not about Article 61. It's about Article 56. Article 56 says the president may, for violation of the Constitution, be removed. Article 61 talks about in which manner. What is the manner that we need to follow to impeach the President of India on the grounds of violation of the Constitution? That manner is provided in Article 61. But which provision talks about impeachment of the President on the grounds of violation of the Constitution? That's Article 56. But I told you that there is something called interregnum. We need to prevent it, because the office of the president can never remain vacant. What if the term of the president is 5 years, but just before that there was COVID? We could not hold the election. We cannot hold the election. What if there is a war? We cannot hold the election. This president, despite the fact, notwithstanding the expiry of your 5-year term, you can continue beyond 5 years, till the time your successor enters upon office, because we don't want an interregnum situation. But when the president resigns, submits resignation to the vice president, what is vice president going to do with this resignation? He will communicate this to the Speaker of the Lok Sabha. This is mentioned in the Constitution. But what is the procedure for impeachment? Toughest majority under the Constitution. Toughest majority under the Constitution is for the impeachment of the president. President can be impeached when a resolution is passed by both houses of the Indian Parliament by the majority of not less than 2/3 of the total strength of the House. Because we have seen majorities such as more than half of the members present and voting, more than 2/3 of the members present and voting. But this time we are talking about 2/3 of the total strength of the House. This is the toughest majority under the Constitution. This process can be initiated in either of the two houses. For example, we can start this process in Lok Sabha or we can start it in Rajya Sabha. If we start in Lok Sabha, you need to get 1/4 of the members writing to the Speaker of the Lok Sabha that we want to impeach the president. And president will be given 14-day notice that wait, hold on, you may be impeached. And if Lok Sabha passes this resolution by not less than 2/3 of the total strength of the House, matter will go to Rajya Sabha. Now, Rajya Sabha will act as an investigative house. Rajya Sabha will have to investigate all the charges against the president and then decide whether these charges can be truly construed as violation of the Constitution. Here the president may be asked to defend himself. Here the president has the right to defend himself. Can the president ask the Attorney General to defend him? No. He has to hire a separate lawyer for it. But either president can defend himself on his own or the president may appoint a lawyer to defend himself. But once Rajya Sabha also accepts it, Rajya Sabha also passes the resolution by 2/3 of the total strength of the House, the president stands impeached. What if this process is initiated in Rajya Sabha? Then investigation will be done by the Lok Sabha. So one house will press the charges. Other house will investigate the charges, whether violation of the Constitution has happened or not. And if it has happened, then the president is liable to be impeached if both houses pass a resolution by this type of majority. Special majority flavor 4. Right? Can the president be re-elected? President of United States cannot be re-elected for more than 2 terms. But is such a limit there in India? No. As long as you satisfy the criteria, you are eligible for re-election any number of times. But there is a convention in India. Convention means unwritten rule. Something which we follow, but something which is not mentioned. And the unwritten rule is, we also follow 2 terms. We also follow 2 terms because no president has been elected in India for more than 2 terms. That is why there is a demand now, because maybe this is how you can link it with current affairs. Prime Minister Modi became the longest serving head of India now. There was a chief minister of Sikkim, I think, who was the chief minister for close to 9,000 days. Now Mr. Modi has surpassed it. He is the prime minister now for the 3rd term. Should there be such a convention in India where the term of the prime minister also is restricted as per convention for 2 terms? Whether it should happen or not, that's the subject matter of the mains examination. But here you have to link it. Can the same person be re-elected as the president for n number of terms? Yes, there is no limit. As long as you meet the criteria, you meet the qualification. And what is the qualification? You should be the citizen of India. You must have completed 35 years of age. You should be qualified to be elected as the member of the Lok Sabha, which means your name should be mentioned in the voter list in any parliamentary constituency of this country. And you should also be not holding any office of profit. If you hold office of profit, you cannot contest the election to the post of the President of India. But the fact is, what if you are the President of India and you want to contest the election to the post of the President again? President of India has an office of profit. Does that mean if you want to contest elections again, you cannot do it? Because you're already holding the office of the President of India, that is office of profit? No, it is not office of profit for that time. Which means a sitting President of India or a Vice President of India or governor of a state or a minister either at the union level or at the state level, do you have to necessarily resign and then contest the election to the post of the President of India? No. You are a minister and contesting election. You are a governor contesting election. You are a vice president contesting election. You are a sitting president contesting election. But once you are elected as the president, you shall be deemed to have resigned from these positions. Which means after you have been elected as the president, you shall be deemed to have resigned from these positions. That is what you have to keep in mind. Can this president be a member of either House of Parliament or House of State Legislature? Because if you are a governor, you don't have to resign from governor's post then to contest election. For example, the Vice President of India recently. Vice President of India was also the governor of Maharashtra. Did he resign as the governor of Maharashtra and then contested the Vice President's election? No. You got elected as the Vice President of India. The moment you assume office, the moment you are administered of oath, it shall be deemed that you have resigned as the governor of the state. Similarly, do you as an MLA or an MLC or an MP, do you have to first resign and then contest election to the post of the President of India? No. You are a member of the legislature, you can contest election to the post of the president. But once you enter the office, it shall be deemed that you have vacated your seat in the legislature. The date you enter the office of the President of India, it shall be deemed that you have vacated the post of the president, your post of the legislature. Previously you were a member of. Apart from that, you cannot hold any office of profit. Apart from that, you cannot hold any office of profit. Done? Now, there is something called oath. Under Article 60 of the Constitution, oath or affirmation by the President. Once you are elected as the President of India, before you enter the office, you will be administered oath. Oath will be administered by the Chief Justice of India. In absence of the Chief Justice of India, it should be a senior judge of the Supreme Court. Okay? The difference is oath is for a believer. Affirmation is for a non-believer. I believe in the name of, I swear in the name of God, or I solemnly affirm. And President takes the oath that I, A.B., assuming the office of the President of India, will faithfully discharge the duties of my office. I will abide by the Constitution. Most importantly, I will protect, defend, and preserve the Constitution. That is the oath of the President of India. The President takes the oath to protect, preserve, and defend the Constitution. And this constitutional oath is administered to the President by the Chief Justice of India or a senior judge of the Supreme Court. Normally, the oath or affirmation is mentioned where? In the third schedule of the Constitution. But for President, it is mentioned in the text of the Constitution itself. For the Vice President, it is mentioned in the text of the Constitution itself. For the governor of that state, it is mentioned in the text of the Constitution itself. For any other functionary, whether it is CAG, judges, Chief Justice, members of the Parliament, it is mentioned in the third schedule of the Constitution. Right? Great. Now, this is a very important fact. What is the time of holding election to fill vacancy in the office of the President? And the term of office of a person elected to fill casual vacancy. The President's term, for example, is from 2017 to 2022. From 2022 to 2027. So once your term is about to expire, even before we know when the term is about to get over. So even before that, we will conduct the elections and we will fill the vacancy. So that once President Murmu's term is over, we already have a president elected, he can be sworn in so that there is no interregnum. But what if there is a vacancy which arises because of death? Death keeps no calendar. Or because you have resigned. Just like Vice President of India suddenly resigned. And he cited that I want to prioritize health. Whether that had to do something with what he did when Justice Yashwant Verma's motion was introduced. We don't have to get into that. Or you have been removed. In that case, it should be conducted as soon as possible, but the Constitution explicitly mentions in no case later than 6 months. Fact is important. But sir, for Vice President also, is it mentioned not later than 6 months? No, it's mentioned for the President. Whenever there is a vacancy in the office of the Vice President, you fill that vacancy as soon as possible. But is it mentioned for the Vice President? Not later. In no case later than 6 months? No, it's not mentioned. It's mentioned for the President. And once you are elected, the new person is elected, you will hold office for full 5-year term. Sir, I don't understand what is this full 5-year term. President holds office for 5 years. Vice President holds office for 5 years. I am the Vice President for 3 years. I resign, citing health concerns. A new Vice President is to be elected. Will this Vice President hold office for the remaining 2 years, or will he hold office for the entire 5 years? Entire 5 years. But you are an MLA. You got elected to the State Legislative Assembly for 5 years. After 2 years, you were disqualified under anti-defection law. After 2 years, you got disqualified because you got convicted. After 2 years, you resigned. After 2 years, you're dead. I will fill the vacancy. I will contest the election from your constituency. Will I hold the office for full 5-year term? No. I will hold office for the remainder of the term, because for your constituency, for your seat, there is a validity, 5-year. 2 years you have occupied. I will now occupy for the remainder of the 3 years. But for president, vice president, that's not the case. The moment you're elected, the moment you assume office, from that time we calculate 5-year term. These facts are important. Constitution says under Article 63 that there shall be a Vice President of India. But this office can remain vacant as well. Sir, how do you know? It happened recently. Vice President of India, Mr. Dhankar, resigned citing health concerns, and then for few weeks, couple of months, there was no Vice President. Because what is your role? To preside over Rajya Sabha? For that we have a deputy chairman. You're not needed. Our constitution forgot about mentioning that we have to fill the vacancy quickly. There are two roles for the vice president. One, you are the ex officio chairman of the Council of States, which means you will preside over Rajya Sabha. Just like Speaker of the Lok Sabha does, you have to do that for the Rajya Sabha. And you will have to act as the President of India whenever there is a vacancy. These are the two roles prescribed for the Vice President. Vice President to act, which means notice. Vice President does not become the President of India. Vice President acts as the President of India. When? When there is a vacancy in the office or during absence of the President. What causes vacancy in the office of the President? When the President is dead, when the President has resigned, when the President has been impeached. That's what causes vacancy. Is it only during the vacancy that Vice President acts as the President of India? No. During absence as well. Absence can be President is away, or President is sick. But President will get to decide whether you can act as the President or not. It's not necessary that whenever there is an absence in the form that I have been traveling to a foreign country, which happened during President Rajendra Prasad's term, or I'm sick, which again happened during Dr. Rajendra Prasad's term. But President will get to decide in my absence whether Vice President will act or not. In my sickness or during my sickness, whether Vice President will act as the President or not. Vice President will act as the President of India for how long? Till the new President is elected. And I told you previously, new election has to be conducted as soon as possible and not later than, in no case, not later than 6 months. Or when President is unable to discharge his functions because of his absence or illness or any other cause, the Vice President will act as the President of India. Till what time? Till the time President resumes. When the Vice President is acting as the President of India, does that mean he can discharge all the powers of the President? Or is there some restriction that since you are only acting as the President, you can touch this but not this? No, you enjoy all the powers, including salary, emoluments, allowances, privileges. That's your role as the Vice President of India. Vice President is also elected by the people, but not directly, indirectly through an electoral college. An electoral college consists of members of Parliament, which means nominated members of the Rajya Sabha. Are they part of the electoral college to elect the President of India? Yes. Are nominated members part of the electoral college to elect the President of India? No. But are nominated members of Rajya Sabha part of the process of impeachment of the President? Yes. Which means these nominated members of the Rajya Sabha, They do not participate in the election of the president, but they participate in the impeachment of the president. Elected members of the state legislative assemblies, they participate in the election of the president, but they do not participate in the impeachment of the president. But who is part of the electoral college to elect the vice president of India? Members of Lok Sabha and Rajya Sabha. Elected, nominated, doesn't matter. Members of Lok Sabha and Rajya Sabha. And you're elected based on proportional representation system by means of single transferable vote through secret ballot. Right or wrong? Right. What is the term of vice president? Vice president will hold office for a term of 5 years from the date he enters upon office, which means the current vice president, Mr. C.P. Radhakrishnan, will he hold office for entire 5 years or the remainder of the term of Mr. Dankar? No, full 5-year term from the date you entered office. And you may want to resign, and if you wish to resign, you submit your resignation to the president, and president is bound to accept this resignation. Or you may also be removed. On what grounds? Grounds not mentioned in the Constitution. On what grounds is the President of India impeached? Violation of the Constitution. On what grounds is the Vice President removed? Not mentioned in the Constitution. Which means he can be removed on any ground. For example, the grounds which were suggested by the opposition against just Mr. Dankar was that he is biased against us. He does not give us opportunities. But the thing is that you have to give 14-day notice to the Vice President. At least 14-day notice should be given. And the Vice President is removed from his office based on the resolution passed by Rajya Sabha by effective majority. So whenever Constitution mentions majority of all the then members of the House, you have to keep in mind that Constitution is talking about effective majority. But it should be acceptable to Lok Sabha. Lok Sabha should accept it by simple majority. Right? Vice President's term is over, 5 years term is over. But we haven't had the election of the new Vice President. This Vice President will continue to remain in office till the time the successor enters upon his office. For the President of India, whenever there is a casual vacancy caused by death, impeachment, resignation, election should be conducted as soon as possible and not later than 6 months. Election to fill vacancy caused by expiration of the term should be completed before the expiration of the term. Casual vacancy because of death, resignation, removal should be conducted as soon as possible. But should it be conducted within 6 months? That is not mentioned in the Constitution explicitly under Article 68. It is mentioned under Article 62 for the President that within 6 months you have to conduct as much as possible. But it is not same for the Vice President of India. And Vice President takes the oath administered by the President. And what is the oath? That I will faithfully discharge the duty upon which I am about to enter. He doesn't take the oath to preserve, protect, and defend the Constitution. If President is, there's a vacancy in the office of the President, who will act as the President of India? Vice President. What if Vice President office is also vacant? This is where there is a contingency. Something that was not envisaged by the Constitution makers. Or Constitution makers said, if tomorrow there is such a contingency, if something is not provided in this chapter, then Parliament may make a law on that contingency. And this happened when Mr. Zakir Hussain died and Mr. V.V. Giri was the Vice President, and Mr. V.V. Giri wanted to contest election to the post of the President of India. So many things. He wanted to resign, And then at that time, Parliament enacted a law called President Discharge of Functions Act. According to that law, according to that statute, if the president is not there, vice president is not there, then Chief Justice of India will act as the President of India. If CJI is also not there, then any senior judge of the Supreme Court will act as the President of India. But that's a statutory provision, not a constitutional provision. Clear? At this stage, we will take a break. It's 8:30. We will come back at 9:10. 40-minute break for your dinner. Resumes at 9:10 p.m. Okay? See you on the other side. Shall we continue? If I'm audible, please let me know. Okay. Article 74, we discussed previously. There shall be a council of ministers with the Prime Minister at the head to aid and advise the President. Up till this was the original constitution. 42nd Constitutional Amendment Act was passed. Another phrase was added, who shall act according with that advice. And then 44th Amendment said, gave the power to the President that you can seek the reconsideration of that advice. But if the same advice is given again, it is binding on the President to accept that advice and act accordingly. But whatever advice is given by Prime Minister and Council of Ministers to the President, there is a bar on the interference by the courts. The courts cannot inquire into what advice was given to the President by the Council of Ministers. So here there is explicitly no judicial review. Keep that in mind. Prime Minister shall be appointed by the President. This is what we call situational discretion for the President. Just like we had an issue in Tamil Nadu. Constitution says that the Chief Minister shall be appointed by the Governor. But who this Chief Minister is, can be, that's not provided. But other ministers shall be appointed by the President on the advice of the Prime Minister. Which means here there is no discretion for the President, there is no discretion for the Governor. Only those ministers, only those individuals recommended by the Prime Minister can be sworn in by the President as the ministers. But who the Prime Minister is, this is where there is a discretion. Who the Chief Minister is, this is where there is a discretion. For example, in case of Tamil Nadu, Mr. Vijay made a mistake. That's why there was a delay in the government formation. What was the mistake? Is there a political party which has got the absolute majority in Tamil Nadu Legislative Assembly? No. In that case, what are the options available with the governor? How will the governor appoint the chief minister? You might have heard about S.R. Bommai case. But S.R. Bommai case was not about government formation. S.R. Bommai case was about the misuse of Article 356, the President's Rule. But even then, the Bommai judgment spoke about that in case the government is to be formed, the governor will have to act according to Sarkaria Commission recommendations. Sarkaria Commission on Center-State Relations, which was appointed in 1980s. Sarkaria Commission says, if there is no political party which has the majority on the floor of the Legislative Assembly, in that case, the governor cannot act arbitrarily and appoint anyone as the chief minister. The governor has to follow a sequence. And the sequence is, first, the governor should invite a pre-poll alliance. Please come and form the government. But is there a pre-poll alliance in Tamil Nadu which has the numbers? AIA-DMK led alliance, they don't have the numbers. TVK contested alone, they didn't have the numbers. DMK led alliance didn't have the numbers. So if pre-poll alliance is not possible, then the next option is invite the leader of the single largest party to form the government. Sir, then what is the mistake of Mr. Vijay? If single largest party also is unable to form the government, then you ask a post-electoral alliance to come together and form the government. This is where the governor is not wrong. Wrong in the sense, Mr. Vijay should have approached the governor saying, I am the single largest party, invite me and to form the government. I will prove majority on the floor of the Legislative Assembly. He did not approach the governor on this ground. He approached the governor saying, we have a post-electoral alliance with the Congress, with other smaller parties. Now, when you are approaching the governor on this ground, then the governor will have to satisfy himself whether you have the majority or not. So the governor was not wrong. He should have approached the governor saying, since no political party has won the election, no pre-poll alliance also has won the election, going by the Sarkaria Commission recommendations, you have to invite me. I'm the leader of the single largest party with 108 MLAs. Invite me to form the government and I will prove majority on the floor of the Legislative Assembly. Instead, he said Congress is supporting us, other parties are supporting us. Then they asked for letters. And this is where there was delay, and ultimately today morning, Mr. Vijay was sworn in as the Chief Minister of Tamil Nadu. But be that as it may, the point is, total number of ministers, including the Prime Minister. What should be the composition of the Council of Ministers? Initially, there was no limit. Unlimited number of ministers could be appointed. Mr. Vajpayee was the Prime Minister. 91st Constitutional Amendment Act was passed. The year was 2003. A limit was imposed. The strength of the Council of Ministers, including the Prime Minister, shall not exceed 15% of the Lok Sabha. Same is that for the state as well. The strength of the Council of Ministers, including the Chief Minister, shall not be more than 15% of the strength of the Legislative Assembly. Right or wrong? Right. I'll tell you one difference and you tell me whether you were aware of this or not. If maximum strength is mentioned now in the Constitution, that the maximum strength would be 15% of the Lok Sabha, including the Prime Minister. This is where the UPSC may play with the words, including or excluding the Prime Minister, including the Prime Minister, including the Chief Minister. But there is a minimum mentioned. Is there a minimum number mentioned? Minimum number is 12. But this minimum number of ministers can be 12. This is mentioned only for states, not at the union. So the minimum strength of the Council of Ministers, including the Chief Minister, shall be 12. Maximum 15% of the Legislative Assembly. But this minimum minister number should be 12. That's not there for the union. That's only for the states. Keep that in mind. Clear? In case of Delhi, it is 10% of the Legislative Assembly. So Delhi can have maximum of 7 ministers, including the Chief Minister, because the strength of the Legislative Assembly of Delhi is 70. Here is an interesting provision inserted by 91st Constitutional Amendment Act. What used to happen, I am a defector. I defect from my political party with a hope that I will be made a minister. Then I will contest election. Then I will win the election. But till that time, I can be appointed as a minister. 91st Constitutional Amendment disqualifies someone to be appointed as a minister if you have been disqualified under 10th schedule of the Constitution. But if you have been disqualified and after your disqualification you contested the election and you won the election, then you can be appointed as a minister. Then there is no bar. But a defector cannot be appointed to any remunerative political post, cannot be appointed as a minister. Remunerative political post, any post for which the salary is withdrawn from the consolidated fund, for which the salary is given from the public revenue. So that is 91st Constitutional Amendment Act. Keep that in mind. Is there a lag? Don't tell me there is a lag. There is no lag. Okay. The ministers shall hold office during the pleasure of the president. This is where we call it individual responsibility. Individually, the ministers are responsible to the president. You are appointed by the president, you can be removed by the president. But this is not the discretion of the president. The president can remove you, appoint you only on the advice of the prime minister. There is no discretion. But collectively, the Council of Ministers shall be responsible to Lok Sabha, parliamentary democracy. And before you enter office, you have to be administered 2 types of oaths. Oath of office, oath of secrecy. And where is this oath mentioned? In the 3rd schedule of the Constitution. Now, I am neither a member of Lok Sabha nor Rajya Sabha. What if, or I'm not a member of the Tamil Nadu Legislative Assembly. What if Mr. Vijay calls me and says, we need experienced people. Please come and join the government. I will make you a minister. Can I be appointed as a minister? Yes. Despite the fact that I'm not a member of the legislature, I can be appointed as a minister, but within 6 months, I have to become the member of the state legislature, or I have to become the member of the either house of the parliament. But now listen to me carefully. If you notice this provision, it does not say you have to become an elected member of the legislature. It only says you have to become the member, which means this member can be either elected or this member can be nominated. So if you are not a member, can you be appointed as a minister? Yes. But within 6 months, you have to become the member of the legislature, which means you can be nominated to Rajya Sabha, or you can be nominated to the Legislative Council if such a council exists for that state. This is something that you have to keep in mind. Important fact. Then cabinet committees. How many cabinet committees do we have, or how many cabinet committees can we have? This is the discretion of the Prime Minister. Right now, we have 8 cabinet committees at the union level. These cabinet committees are extra constitutional bodies. That means these committees are not mentioned in the Constitution. But where are they mentioned? They are mentioned in Government of India Transaction of Business Rules 1961. Which are these cabinet committees? First is the Appointments Committee of the Cabinet. Keep in mind, how many committees do we have? What is the composition of that committee? What is the role of that committee? If the Prime Minister is a member of that committee, if Prime Minister is not the member of the committee, which means someone else is the chairman of that committee, because Prime Minister being the member of the committee invariably means Prime Minister is the chairman of that committee. Appointments Committee, the chairperson is Prime Minister. What is the other composition? Prime Minister and the Home Minister. What is the role? Appointing top bureaucrats, such as secretaries, additional secretaries, heads of public sector undertakings, regulators, SEBI, RBI, so on and so forth. Cabinet Committee on Accommodation. It is headed by the Home Minister. Is Prime Minister part of it? No. What is the role of this Cabinet Committee on Accommodation? Decides the allocation of government accommodation to ministers, members of the parliament, senior government officials. That's the role. Cabinet Committee on Economic Affairs. Is Prime Minister part of it? Yes, which means Prime Minister is the chairman of this committee. What are the decisions taken by Cabinet Committee on Economic Affairs? All major economic policies, investments, large infrastructure projects. For example, should we ban the export of onions? Should we resort to more import of oil seeds because inflation is high? All these major economic decisions are taken by Cabinet Committee on Economic Affairs. Cabinet Committee on Parliamentary Affairs. This Cabinet Committee on Parliamentary Affairs is headed by the Defence Minister. What is the job of this committee? Who summons Parliament? President. But is that the discretionary power of the President? No. President summons Parliament based on the advice of the government. Technically, that advice comes from Cabinet Committee on Parliamentary Affairs. What is going to be the parliamentary agenda? What are the bills that we are going to introduce in the upcoming session? What is going to be our priority and strategy in the parliament? That is decided by Cabinet Committee on Parliamentary Affairs, which is headed by the Defence Minister. Previously, it was headed by the Home Minister. But later, it was changed and now Defence Minister is the head of the Cabinet Committee on Parliamentary Affairs. Cabinet Committee on Political Affairs. And this is the question which was once asked in the examination. It is also known as the Super Cabinet. Super Cabinet in the sense, all the important political decisions which are, after all, the government has to take political decisions. All these important political issues, center state issues, are decided by Cabinet Committee on Political Affairs. Cabinet Committee on Security, headed by Prime Minister, and 4 top ministers are part of it. Home Minister, External Affairs Minister, Finance Minister, Defence Minister. If there is any defence proposal where we have to spend 1,000 crores or more, for example, we have to acquire more Rafale jets, we have to acquire more S-400 defence systems, we have to look into the internal security of this country. all these super critical decisions involving the national security are taken by Cabinet Committee on Security. 2 more cabinet committees got added in 2019. So between 2014 till 2019, these 6 cabinet committees were there. 2 more got added in 2019. One is Cabinet Committee on Investment and Growth, Cabinet Committee on Employment and Skill Development. Both these committees are headed by Prime Minister. So the question may be, which of the following committees do not include Prime Minister? Cabinet Committee on Accommodation, Cabinet Committee on Parliamentary Affairs. Which of the following committees is also known as the Super Cabinet, Cabinet Committee on Political Affairs? Which of the following committees includes the membership of 4 top ministers, Cabinet Committee on Security? Which of the following cabinet committees were last added in the Government of Allocation of Business Rules? Cabinet Committee on Investment and Growth, Cabinet Committee on Employment and Skill Development. Keep that in mind. Let's recap what we discussed. Article 52 deals with the President of India. There shall be a President of India. All the executive powers are vested in the President, but President does not exercise these powers on her own. She exercises these powers on the advice of the Prime Minister and Council of Ministers through officers. How is the President of India elected? By an electoral college consisting of elected members of Parliament, elected MLAs of states, including Delhi and Puducherry. How is the President elected? What's the manner? Proportional representation system by means of single transferable vote through secret ballot. What is the term of the President? 5 years. Even after the expiry of 5 years, the President may still continue to remain in office until the successor assumes office. Why? I told you this is to prevent interregnum. Is the President eligible for re-election? Can be re-elected any number of times, although we have a convention that your term is limited to 2 terms. Condition, qualification, citizen of India, 35 years of age, you should be qualified to be a member of the Lok Sabha, no office of profit. What are the conditions of your office? You cannot hold office of profit even after you have been elected as the President. You are provided with official residence, for which do you have to pay the rent? No. Oath is administered by the Chief Justice of India or in his absence, the senior judge of the Supreme Court. Election to fill vacancy as soon as possible, not more than 6 months. Vice President is a constitutional post, part of the executive. What is your role? You are the ex officio chairman of the Rajya Sabha. You are not a member of the Rajya Sabha, but by virtue of you being the Vice President of India, you will preside over Rajya Sabha, which means you are the ex officio chairman of the Rajya Sabha. And your role is that of presiding over Rajya Sabha, and in case there is a vacancy in the office of the President, you will act as the President of India. You will not become the President of India. You will act as the President of India. But only during vacancy? No, during absence as well. During absence, President will get to decide whether Vice President will act as the President of India if I'm sick or if I'm traveling abroad. What is the electoral college of the Vice President? Members of both houses of the Parliament, which means elected as well as nominated. What is your term? 5 years. Vacancy needs to be filled within 6 months, but not mentioned in the Constitution. This is convention. Explicitly, it is mentioned in the Constitution to fill the vacancy not more than 6 months. That's for the President, not for the Vice President. Oath is administered by the President that I will faithfully discharge the duties of the office about which I am about to enter. Other contingencies, Parliament may by law provide. For example, the contingency is, Constitution says, in absence of the President or when there is a vacancy in the office of the President, Vice President shall act as the President of India. What if Vice President's office is also vacant? This is a contingency. For that, there is a law that needs to be enacted by the Parliament. Has Parliament enacted that law? Yes, in 1969. President Discharge of Functions Act 1969, which mandates that in case there is a vacancy in the office of the President and the Vice President, Chief Justice of India shall act as the President of India. In absence of the Chief Justice of India, a senior judge of the Supreme Court shall act as the President of India. Does that mean the CJI will continue to occupy both the positions as the Chief Justice of India as well as the acting President of India? No. Why? Because that would be violation of the separation of powers. What is that? Which means you cannot be the part of the executive as well as the judiciary. Separation of executive and judiciary is mandated by the constitution, which means CJI will have to resign and then act as the president of India. After new president is elected, what will happen to this Chief Justice of India? Will he lose the post of the judge as well? No, he can come back and resume the post of the judge of the Supreme Court. But at the same time, you cannot be the Chief Justice as well as the President of India. These facts are extremely important. If there is a dispute with regards to the election of the president or the vice president, where do we go? Do we go to a high court? Do we go to a tribunal? This dispute can be resolved by the Supreme Court of India, and the decision of the Supreme Court shall be final and binding. President has the power under Article 72 that you can grant pardon, reprieve, remission, you can commute sentences. But this is not the discretion of the president. President acts on the advice of the Home Minister. Home Minister gives this advice once this matter is decided by the cabinet. So this is not the discretion of the president. Similarly, governor also has the power to grant pardons or to commute sentences. But the difference is that president can pardon death sentence. Governor cannot pardon a death sentence. What the governor can do? Governor can commute a death sentence. Right? That's the difference. Is the president bound by the aid and advice of the Council of Ministers? Yes. 42nd and 44th amendments have made it categorically clear that the president is bound to accept the aid and advice of the Prime Minister and Council of Ministers. He can seek reconsideration of the advice, but only once. Prime Minister is appointed by President, but ministers are collectively responsible to the Lok Sabha. Attorney General for India, highest office of the Union, and this is something that we have covered in the constitutional bodies. Right? Let's continue. States. States we have discussed. We have governor, we have chief minister, we have council of ministers, and we have the advocate general of the state. Similarly, when we talk about states, we have governor, we have legislative assembly, and we have 6 states where we have a legislative council. Constitution says under Article 153 that there shall be a governor for each state. But the current governor of Tamil Nadu is also the governor of Kerala. Can he be appointed as the governor of Maharashtra as well? Or is there a limit that the same person can be appointed as the governor of up to 2 states? Is there any limit? There is no limit. Original constitution said there shall be a governor for each state. But 7th Constitutional Amendment Act 1956 provided that the same person may be appointed as the governor of 2 or more states. Which means the same person can be appointed as the governor for 2 or more states. This is something that you have to keep in mind. And this governor, once you are appointed, is there a tenure mentioned in the constitution? What will be the term of office of the governor? It is mentioned. And what's the term? 5 years. Is it explicitly mentioned in the constitution? Yes. But we say this 5-year is subject to doctrine of pleasure, which means the governor will hold office during the pleasure of the president. On this, there is an important case. BP Singhal, 2010. Just because there is a change in the government at the center, is that a sufficient ground for removing a governor of a state? No. Who said this? A constitution bench of the Supreme Court in BP Singhal 2010. Yes, governors will hold office during the pleasure of the president, but there has to be a sound ground on the basis of which you want to remove a governor. This decision to remove a governor cannot be arbitrary. Clearly, the change of the government cannot be the ground for changing the governor. Clearly, you cannot say that this governor, now we are appointing a better person as the governor. That's why we are replacing him. No, there has to be a strong reason on the basis of which you want to remove a governor. It cannot be done arbitrarily. But the governor may, by writing under his hand, addressed to the president, resign from his office. Even before completing 5 years, you may resign by submitting your resignation to the president. Who is qualified to be appointed as the governor of a state? Constitution talks about only two requirements, two qualifications. You have to be the citizen of India and you must have completed 35 years of age, full stop. You should not be holding any office of profit. That's also there. But these are the only two qualifications. Does that mean the qualification that the governor should be a non-resident? If you are appointed as the governor of Kerala, you should not be from Kerala. And while appointing the governor, chief minister of that state shall be consulted. These are only conventions, unwritten rules. They're meant to be followed, but they are not explicitly provided in the Constitution. Constitution says, if you are a citizen of India, you have completed 35 years of age, you are not holding any office of profit, you are eligible, qualified to be appointed as the governor of a state. Just like the president. Can the president, if you are a member of the parliament, member of the state legislature, minister at the union, minister at the state, can you contest election to the post of the president? Or do you have to first resign? No, you contest the election. Once you win the election, once you are administered oath, once you have been administered oath, you have entered the office, it shall be deemed that you have vacated your previous post. You don't have to resign. It shall be deemed that you have vacated your previous post. Similarly, can a sitting member of the parliament or can a sitting member of the state legislature be appointed as the governor of a state, or do you have to first resign from the post of the MP or an MLA or an MLC? No, a sitting member can be appointed as a governor. But the moment you enter upon your office, it shall be deemed that you have resigned from the seat in the parliament or the seat in the legislature. But what if the same person is appointed as the governor of Tamil Nadu as well as Kerala? How should we pay salary to this governor? Will all the expenses be borne by Tamil Nadu because it's a bigger state? Or will all the expenses be borne by Kerala because Kerala is God's own country? Or will it be shared between Tamil Nadu and the Kerala? What is the proportion? What is the percentage? 60, 40, 50, 50? Who will get to decide? Parliament or president? President will get to decide. So president will decide. If the same person is appointed, and when the same person is appointed as the governor of two or more states, the emoluments and allowances payable to the governor shall be allocated among the states in such proportion as the president may order determine. And to provide for the independence of this office, the Constitution says the allowances, the salary of the governor shall not be diminished during his term of office. Because if you do that, you are violating the independence of the office of the governor. This is to ensure independence of the office of the governor. Clear? Council of Ministers to aid and advise the governor. There shall be, similar to Article 74, there shall be Council of Ministers headed by the Prime Minister to aid and advise the President, who shall act on that advice. Similarly, there shall be Council of Ministers headed by the Chief Minister to aid and advise the governor, who shall act on that advice, except when the governor has to act in his discretion. One fact for your prelims is that this discretion is not defined in the Constitution. But the Constitution says, if at all there is a dispute, if a question arises, whether this matter is under the discretionary power of the governor or not, who will decide it? Constitution says governor gets to decide. Which means governor gets to decide what are my discretionary powers. But obviously, everything and anything is subjected to judicial review. And Supreme Court has clarified in numerous instances that summoning the legislature is not the discretionary power of the governor. Dismissing a minister is not the discretionary power of the governor. Reading out a speech which is presented by the cabinet is not the discretionary power of the governor. But for that, we have to clarify it from the courts. If we read the constitution, it says if there is any question, whether what has been done by the governor, whether the governor has to do it as part of his discretion or not, the word of the governor shall be final. So if this statement is asked in the examination, you should consider it correct. And again, just like 74 clause 2, the advice tendered by Council of Ministers to the President shall not be inquired into any court of law. The similar provision exists for the states as well. The question whether any, and if so, what advice was given by Council of Ministers to the governor, this shall not be inquired into any court of law. Clear? Other provisions for ministers. Chief Minister shall be appointed by governor. On the advice of the Chief Minister, other ministers shall be appointed. In appointment of the Chief Minister, there is what we call situational discretion. But is there a discretionary power available with the governor when it comes to the appointment of ministers? No. Ministers shall be appointed by the governor only on the advice of the Chief Minister. But Constitution further says that in states such as Chhattisgarh, Jharkhand, Madhya Pradesh and Odisha, there shall be a minister in charge of tribal welfare. So which are those states where it is mandatory for the governor to appoint a minister for tribal affair? You need to keep in mind these are the areas of Chhattisgarh, Madhya Pradesh, Jharkhand and Odisha. The total number of ministers shall not exceed 15% of the Legislative Assembly, but minimum cannot be less than 12. Minimum 12, maximum it can go up to is 15% of the Legislative Assembly. Let's look at the question on your screen and answer this question. Which of the following is or are mentioned in the Constitution of India? The executive power of the Union is vested in the President. The supreme command of the defense forces of the Union is vested in the President. The President is bound by the aid and advice of the Council of Ministers except when the President is required under the Constitution to act in his discretion. Such a provision is not there for the President. Executive power is vested with the President. Supreme command of the defense forces is also vested with the President. How many statements are correct? 2 statements. B is the right answer. B, not C. Because Constitution does not talk about discretion for the President. The holders of which of the following offices can contest elections to the post of the President without resigning? Governor of a state, Vice President, Union Minister, Minister at the state level, Chairman of Indian Statistical Institute? No, because this is an office of profit. So why do you randomly pick up this office, Chairman of the Indian Statistical Institute? Because this was a matter of dispute when Shri Pranab Mukherjee became the President of India. His opponent P.S. Sangma approached the Supreme Court and said that Mr. Pranab Mukherjee, before he contested the election, he was the Chairman of the Indian Statistical Institute. He had not resigned from this post, which means he was holding office of profit. Supreme Court rejected this petition, but nevertheless, it becomes important. So 1, 2, 3, 4, B is the right answer. Right? Clear. Now, when you elect the President of India, who has the right to vote? Who is part of the Electoral College? Members of the Parliament, elected members, and elected members of the state assemblies. Right? Election Commission of India has directed that ballot papers that we use, because election to the office of the President is not conducted through EVMs. Similarly, for Vice President of India, it is also not conducted through EVMs. Why? Because for President and Vice President, you have to give your preference. Such a system has not been designed. The existing EVMs, they don't have such mandate that we will allow you to give preference. EVM is like a calculator, a counter. You press the button, vote is registered. It does not allow you to give preference. That is why we use ballot papers for the election of the President, Vice President, including for Rajya Sabha MPs. But Election Commission has said that ballot papers should be printed in two colors: green, which will be used by the members of the parliament; pink, when it will be used by the members of the state legislative assemblies. Fact sometimes may be relevant for your examination. When it comes to the President of India, we say it is proportional representation system, which means as is the population of that particular state, that will be the value of vote of the MLA of that state. When it comes to the value of votes of an MP, value of vote of an MP of Rajya Sabha is equal to the value of the vote of an MP in Lok Sabha. So both MPs of Lok Sabha, Rajya Sabha, they have the same value. But value of vote of an MLA varies from state to state. Because it is dependent upon the population. And which population figures do we keep in mind? 1971 census. Why? Because this was the last census on the basis of which the seats were increased, enhanced in the Lok Sabha and the legislative assemblies. This was the last time when full-fledged delimitation was carried out in the entire country. That is why we take the population figures of 1971 in mind to calculate the value of vote of every member of the state legislative assembly. Every state. Sometimes the questions have been asked slightly tricky on this value of vote. But for that, look at the screen. Highest value of vote of an MLA is in UP, then Maharashtra, then West Bengal, then Bihar, because of the population. How do you calculate this? Value of each MLA is calculated when we look at the population of that state according to 1971 census, divided by total number of elected MLAs into 1 by 1000. This is how we calculate the value of vote of an MLA. And that is how a particular state is given the value of votes. For that particular state, for UP, your value is 83,824. Minimum is, lowest is for Sikkim, 224. Mizoram, 320. Puducherry, Arunachal Pradesh, 480. This is the maximum, this is the minimum. Because this is for the entire state, not just individual MLA, for the entire state. In which of the following circumstances can the President act in his own discretion without the aid and advice of the Council of Ministers? Can the President use discretion in summoning the Parliament? No. Promulgation of an ordinance? No. Dismissal of a minister from the cabinet? No. Dissolution of the Lok Sabha when no party has a clear majority? Yes. And whenever Lok Sabha is dissolved, it calls for fresh elections. Clear? Question number 4. Which of the following is not a form of veto power available to the President of India under the Constitution? Let me know what is the right answer. Which of the following is not a form of veto? President of India, we can say, has absolute veto, has suspensive veto as well, has pocket veto as well. But qualified veto is provided for the US President of the United States of America. But is this veto power mentioned in the Constitution? No. Which of the following is not a form of veto provided available to the President under the Constitution? Under the Constitution, there is no such thing as veto. So all of the above, none of these veto powers are available with the President. Okay? Very good. Which of the following statements is or are correct regarding the ordinance making power of the governor of a state? Governor has an ordinance making power under Article 213. President has the ordinance making power under Article 123. What is this ordinance making power? In simple terms, Parliament has to make a law on union list or concurrent list. State legislature has the power to make a law on state list or concurrent list. But for that, state legislature has to be in session. What if state legislature is not in session? What if Parliament is not in session? What if one house is in session but the other house is not? Will it work? Only one house will be in a session to enact a law? No, both houses have to be in session. In such a situation, what if we need a law now, but Parliament is not in session, or legislature is not in session, or both houses are not in session? Ordinance making power is available with President or the Governor. But the fact is, once this ordinance is promulgated, you have 6 weeks from the time Parliament is convened again to convert this ordinance into a law, which means to replace this ordinance with a bill and get this bill passed. If you cannot do that, then ordinance will lapse. But if I were to ask you, what is the maximum validity of an ordinance? We say it is 7.5 months. Why 7.5 months? Does Constitution say how many times should Parliament convene in a particular year? What is the minimum or the maximum number of days Parliament should meet in a particular year? No. Constitution only says, and same is the case for the states, that the Parliament or the legislature may meet as often as possible, but in such a manner that the time between the last day of the previous session and the first day of the next session should not be more than 6 months. Which means Parliament must meet at least 2 times in a year. What if Parliament is not in session now? Can ordinance be promulgated? Yes. But within 6 months, Parliament has to be reconvened. And then within 6 weeks of the reassembly of the Parliament, this ordinance has to be replaced by a law, which means the maximum validity of this ordinance would be 6 months plus 6 weeks, which is 7.5 months. Is it constitutional? Listen to me carefully. Concept. Is it constitutional for the governor to prorogue a house just because you have to promulgate an ordinance? Yes. Is ordinance making power subject to judicial review? Yes. But what sort of judicial review? Limited judicial review. Limited judicial review in the sense, the petitioner has to convince the courts and prove in a court of law that the action of the president or the governor is mala fide. That means there was no need to promulgate an ordinance. This ordinance has been promulgated in bad faith. If that is something that you can prove in a court of law, then this ordinance will be declared unconstitutional. But ordinance, does it have any relation with emergency? Does ordinance making power have any relation with the emergency? No. Emergency is separate, ordinance making power is separate. Can ordinance be promulgated during normal circumstances? Yes. The only requirement is either one or both houses of the Parliament are not in session. Either one or both houses of the state legislature are not in session. An ordinance can be promulgated only when the state legislature is not in session. This is correct. When either one or both houses of the Parliament are not in session. The governor, before issuing an ordinance, has to be satisfied of the existence of circumstances rendering it necessary to take immediate action. Correct. This is something that has been communicated by the courts. C is the right answer. When the governor has to promulgate an ordinance, or the president has to promulgate an ordinance, you have to satisfy the president or the governor that there is a requirement, there is a necessary need. The circumstances have made it absolutely necessary for an ordinance to be promulgated because Parliament is not in session, legislature is not in session. One more fact. Can an ordinance be promulgated to amend the Constitution? No. You can promulgate an ordinance only to pass an ordinary law. To pass a law for union list, concurrent list. You cannot promulgate an ordinance to amend the Constitution. Can you promulgate an ordinance to pass, let's say, financial matter or a money matter? Yes. But can you promulgate an ordinance to amend the Constitution? No. That is not the power available with the president. Clear? Good job. The oath or affirmation by the president is mentioned in the third schedule of the Constitution. It's mentioned in the text of the Constitution itself. If a motion calling for the impeachment of the president is moved in a house, the same house shall investigate the charges against the president. The other house shall investigate the charges against the president. If both the houses of the parliament pass a resolution approving impeachment of the president, then the president stands impeached at the expiry of 14 days of the passage of that resolution. The president stands impeached forthwith, immediately, not at the expiry of the 14-day period. How many statements are correct? None of the statements are correct. D is the right answer. Can ordinance be issued to legislate on state list? Yes. The governor has the power to promulgate an ordinance on any item mentioned in the state list. The union ministers hold office during the pleasure of the Prime Minister, during the pleasure of the President. There is no provision in the Constitution which makes President answerable to the Parliament for the acts of the government. Correct. There is no such provision. You cannot hold President accountable to the Parliament for the actions of the ministers. You hold individual ministers accountable. While in India, the Prime Minister can be a member of either house of the Parliament, in Britain, the Prime Minister shall be a member of the lower house of the British Parliament. You have to be the member of House of Commons in order to be appointed or eligible to be appointed as the Prime Minister in Britain. But in India, you can be either from Lok Sabha or Rajya Sabha. 2 and 3, how many statements are correct? B is the right answer. According to the Constitution, which of the following is not the duty of the Prime Minister vis-a-vis the President? It's the duty of the Prime Minister to convey to the President all the decisions that are taken by Council of Ministers. It is the duty to submit to the consideration of Council of Ministers any matter on which the decision has been taken by a minister but which has not been considered by the Council. It is a duty. Minister individually has taken a decision, but this decision was not discussed in the cabinet meeting in the Council of Ministers. It is the responsibility of the Prime Minister to convey to the President. To communicate to the President any legislative proposal she may call for. Yes. To communicate to the President the steps being taken by the Union in a state when there is a breakdown of constitutional machinery. This is not mentioned in the Constitution. This is not the duty of the Prime Minister to convey to the President what are the steps being taken in a state where there is a breakdown of constitutional machinery. Ideally, yes. Because look at the first statement, to communicate to the President all decisions of the Council of Ministers relating to the administration. By that logic, it becomes your duty to convey to the President what steps have you taken in a state where there is a breakdown of constitutional machinery. But the question is asking, according to the Constitution, this is not mentioned in the Constitution. These 3 things are mentioned. 4th is not mentioned. Question is asking which of the following is not the duty. 4th is not the duty. So only one statement. A is the right answer. Under the Indian Constitution, addition or removal of a cabinet committee is the prerogative of Prime Minister. To deal with problems relating to center-state relations. To consider economic and political issues that have to be judged with a wider perspective. To deal with policy matters concerning foreign affairs that do not have external or internal security implications. How many are under the jurisdiction of Cabinet Committee on Political Affairs? All of them. That is why we call it a super cabinet. But sir, policy matters related to foreign affairs, should it not be covered by Cabinet Committee on Security? It says that do not have external or internal security implications. If there is external or internal security implication, then this matter will be dealt by Cabinet Committee on Security. Otherwise, it will be dealt by Cabinet Committee on Political Affairs. Vacation of seats, something that we have covered previously. Let's recap it quickly. If a person is chosen as member of both houses of the people as well as Council of States, but you have not taken seat yet, you have not been administered oath yet, you have to send a notice to the Election Commission within 10 days that which seat you want to retain. If you cannot take up this decision, then in that case, your seat in the house will become vacant. Which house? Here is the member who has been elected to both houses of the people, which means Lok Sabha as well as Rajya Sabha. You have not taken seat in either of the two houses, which means you have not been administered oath. Will you retain both? No. You have to give up one. Which one will you give? You have to tell Election Commission within 10 days. If you can't say to the Election Commission within 10 days, then your seat in the Rajya Sabha will fall vacant, so that we prioritize your seat in the Lok Sabha. If a person who is already a member of the House of the People and now he is chosen as the member of the Council of States, his seat in the Lok Sabha falls vacant. You are already a member of one house. Now you want to be elected to the other house. If you have been elected to the other house, you have to give up your previous seat. Similarly, if you are already a member of the Rajya Sabha, but now you have been elected to the Lok Sabha, your seat in the Rajya Sabha falls vacant. But sir, isn't this contradictory to what we discussed here? Here it is, if you have been elected to Lok Sabha, Rajya Sabha at the same time, or you have been elected to Lok Sabha today, Rajya Sabha later, but you have not taken the seat. You have not been administered oath. Can you retain both the seats? No. You have to give up one within 10 days. If you can't give up one, your seat in the Rajya Sabha will fall vacant. But if you're already a member of the Rajya Sabha, you have taken the seat as well, you have been administered oath as well, now you have been elected to the Lok Sabha, your seat in the Rajya Sabha falls vacant. That's something that you have to keep in mind. Can you be elected to more than one seat? In Parliament or state legislature, for example, Mr. Vijay has been elected to 2 seats in the Tamil Nadu Legislative Assembly. Can you retain both the seats? No. You have to convey which seat you want to retain within 14 days. If you don't do that, all the seats will become vacant. All the seats will become vacant. So these facts are important, relevant for your examination. Let's now quickly jump to emergency provisions of the Constitution. Emergency provisions which convert, albeit briefly, for a brief period, our federal polity into a unitary setup. What are these emergency provisions? Number 1, we have Article 352. Article 352 deals with national emergency. What does the Constitution say? If the President is satisfied, what will satisfy the President? President is satisfied because of war or external aggression or armed rebellion. Then what the President can do? President can proclaim national emergency. Does that mean war should already have broken? External aggression should have started? Armed rebellion should have taken place? Only then can the President impose and proclaim national emergency? No. Even in anticipation. If the president is satisfied, if the president anticipates that there may be war, there may be external aggression, there may be armed rebellion, the president may proclaim national emergency. Is this proclamation of national emergency subject to judicial review? Yes. Limited judicial review, which means you have to convince the courts that the action of the president is malified. There was no reason to impose national emergency. If you can convince the court, then the courts will have to declare this imposition of national emergency as void. But what is the validity of national emergency? These facts are important for prelims. 1 month. Validity is 1 month? Yes, 1 month. But within 1 month, both Lok Sabha as well as Rajya Sabha, they will have to approve national emergency by special majority. If both the houses approve, this national emergency will continue for 6 months. Can it be extended further? Another 6 months, but get approval from both houses of the parliament by special majority. Can it be extended further? Yes, get the approval. What if you can't get the approval? National emergency lapses. Is there any upper limit that national emergency can be imposed for a maximum period of 6 months or maximum period of 3 years or maximum period of 5 years? There is no upper limit. But the only thing is there is a periodic parliamentary control. It can be imposed, but once approved, it will continue for 6 months. Then again, you need parliamentary approval to provide for the extension of national emergency. Then continue. Then again approval. Then continue. Periodic parliamentary control. But is this a discretionary power of the president to impose national emergency? No. President does this on the advice of the cabinet. That too on the written advice of the cabinet. Cannot be done on the oral advice of the Prime Minister, only on the written advice of the cabinet. Keep this in mind. This national emergency, once it is approved by both houses of the parliament, it continues for 6 months. It can be extended any number of time, maximum limit not provided by the constitution, but you require parliamentary approval every 6 months. How can you revoke national emergency? Revocation of national emergency at any time by the president, obviously on the advice of the cabinet, because this is not the discretionary power of the president. Or if it is not approved by Rajya Sabha and the Lok Sabha. If one house approves the emergency, other house does not, or this national emergency is revoked, lapses. Can there be joint sitting? If one house approves, the other house does not, let's have a joint sitting to approve national emergency by simple majority. No, there is no joint sitting. Separately, both the houses have to approve national emergency by special majority. Right or wrong? Right. There is a special power available to Lok Sabha. And listen to me carefully, this is a very important point. What is the special power of the Lok Sabha? Under Article 352, Clause 8, if Lok Sabha is in session already, members will write to the Speaker. 50 members will write to the Speaker. If Lok Sabha is not in session, 50 members will write to the President. Dear President, please summon Lok Sabha. Why? Because we want to discuss national emergency. And in this special session, because this is meant to be a special session, in this special session, if the resolution is passed by simple majority, where the Lok Sabha has resolved by simple majority that we wish to discontinue national emergency, then it is binding on the President to revoke national emergency. This is a special power available with Lok Sabha. This is not the power available with Rajya Sabha. And that's how national emergency can be revoked. If the national emergency is imposed on the grounds of war or external aggression, we call it external emergency. If it is imposed on the grounds of armed rebellion, we call it internal emergency. And whenever emergency is imposed on the grounds of war or external aggression, Article 19, its enforceability is suspended. That does not mean Article 19 is suspended. Its enforceability is suspended, which means you can't approach the court. How about armed rebellion? Article 19's enforceability is not automatically suspended. Then the president will have to issue an order to suspend Article 19. And one by one, every fundamental right's enforceability can be suspended, except Article 20 and 21. These two fundamental rights cannot be, their enforceability cannot be suspended even during national emergency. And what happens during national emergency? Keep one thing in mind, just one thing. There is something called union list, state list, concurrent list. Who has the power to make a law on union list? Parliament. Who has the power to make a law on state list? State legislature. Who has the power to make a law on concurrent list? Both parliament as well as state legislature. During national emergency, you should keep in mind that there is no such thing as state list. Whatever items are there in state list, you can say that they are part of the concurrent list. Now you will understand it better. How? That does not mean that during national emergency, legislatures of the states, they don't function. They function. But Parliament assumes concurrent power of legislation, which means the Parliament can make a law on any item mentioned in the state list. And during national emergency, we can assume that all items in the state list are in effect mentioned in the concurrent list. And any item mentioned in the concurrent list, both Parliament as well as state legislatures have the power to make laws. This is what happens during national emergency. During national emergency, directives can be issued against the state by the center. And all these directives are coercive in nature, which means if these directives are not abided by, the government can be dismissed. And during national emergency, I told you the term of the legislature can be increased 1 year at a time. There is no upper limit, but 1 year at a time, it can be enhanced. But once national emergency is revoked, within 6 months of the revocation of national emergency, the term will be over. National emergency. Then there is President's rule under Article 356. If the President is satisfied, and what will satisfy the President on the basis of the report of the Governor or even otherwise. Is the report of the Governor necessary for the imposition of the President's rule? No. No, not necessary. Even without the report of the Governor, if the President is satisfied that there is breakdown of constitutional machinery, the President can impose and proclaim President's rule in that state. Obviously, this is not the discretionary power of the President. This is done on the advice of the government. Which means this Governor's report, if at all it is there, will be sent to the President. President will consult the Cabinet. Cabinet will give the advice, and that advice is binding on the President. President's rule. But what is the validity of the President's rule? President's rule will be valid for 2 months. But within 2 months, it needs to be approved by Lok Sabha as well as Rajya Sabha. By what type of majority? Simple majority. If approved, it continues for 6 months. If not approved, it lapses. Can it be extended further? For another 6 months. Can it be extended further? 1 year is the limit. If at all you wish to extend President's rule beyond 1 year, what you need to do, 2 conditions need to be satisfied. Either of the 2 conditions. Either Election Commission of India will say it is difficult for us to organize elections, hold elections. Number two, national emergency is imposed in the entire country or in that state or any part of that state. Then you can extend President's rule 6 months at a time for a further period of 2 years. Which means the maximum constitutional validity of a President's rule is 2 years plus 1 year, which means 3 years. What if you want to extend President's rule in a state beyond 3 years? Then you have to amend the constitution because the maximum validity of a President's rule is 3 years. What happens during President's rule? Number one, Chief Minister dismissed. Is it a necessary consequence? Yes. That's what President's rule is. The Chief Minister is dismissed, the Council of Ministers are gone. That's a necessary consequence of a President's rule. Which means if there is no Chief Minister, no Minister, President will be the head of the executive for that state. And he will govern that state through his officer who is the governor. This is what we call President's rule. What about the Legislative Assembly? It is not dissolved immediately. It is kept under suspended animation. The President, for example, let's assume the government in Tamil Nadu falls. Congress withdrew support. Smaller parties, communists, they withdrew support. No other government is possible. President's rule will be imposed in Tamil Nadu, which means now the President will administer Tamil Nadu through his officer who is the governor. But what will happen to the Legislative Assembly of Tamil Nadu? Will it be dissolved? Not immediately. Because the governor will have to satisfy himself. The governor will look at Legislative Assembly and will wait if a new government is possible or not. Will DMK approach us to form the government? Will AIDMK approach to form the government? Will TVK again approach me to form the government through other allies? Maybe, because elections are a costly affair. We have to ensure as much as possible that we do not impose another election on the people because this amounts to torturing the voters. But if the governor realizes later that from this existing Legislative Assembly, no other government is possible, only then he will dissolve the Legislative Assembly. And once the Legislative Assembly is dissolved, it paves way for fresh elections. But during the time when the Legislative Assembly is dissolved, who will make laws for the state of Tamil Nadu? Parliament. Parliament will become the legislature of that state. That is President's rule. Is the President's rule or the imposition of the President's rule also subject to judicial review? Yes. SR Bommai v. Union of India. Then there is financial emergency. Let me know if I'm going too fast. I will slow down, but I want you to finish as much as possible. Plus, there is a limit. The limit is that we cannot go beyond 12 o'clock because we started the session at 12. We can't go beyond 12 because then the stream will expire. And YouTube does not allow a live session of more than 12 hours. So I know I'm going fast, but that's how it should be because we are revising. Okay. If the President is satisfied that the financial system or the credit system in this country or any part of this country is threatened, then the President may proclaim financial emergency. Once financial emergency is imposed, it continues for 2 months. But what has to happen within these 2 months? both Lok Sabha as well as the Rajya Sabha, they will have to pass a resolution approving financial emergency. Once approved by simple majority, financial emergency continues forever and ever and ever unless and until it is revoked by the president. So national emergency, once it is imposed within 1 month, both houses of the parliament by special majority will have to approve national emergency. But financial emergency and president's rule, once imposed within 2 months, both houses of the parliament will have to approve these emergencies by simple majority. Once approved, financial emergency continues forever and ever and ever unless and until revoked by the president. Once approved, president's rule continues for 6 months. Get the reapproval, continue for 6 months. Maximum validity is 3 years. For national emergency, once approved, continues for 6 months. Can be extended n number of times without any limit, but it requires periodic parliamentary control. Every 6 months, both houses of the parliament will have to approve national emergency by special majority. Financial emergency has never been imposed in India. And what will happen because of financial emergency? All the money bills, the president will ask the states, reserve it for me. The salary of constitutional functionaries can be reduced. Because one way in which we ensure independence of the offices of, let's say, president, of, let's say, CEC, or of, let's say, CAG, of, let's say, the judges, that their salaries cannot be varied to their disadvantage after the appointment, except during financial emergency. Because during financial emergency, we want the union government to have all the access to the resources which can take this country out of that financial mess. These are the emergency provisions. Let's now look at judiciary. Integrated judiciary, Supreme Court at the top, High Courts, District Courts, then we have Gram Nyayalas. High Court, Supreme Court, District Courts, we say these are constitutional courts. High Court and Supreme Court we call superior judiciary. District courts we call them subordinate courts. Gram Nyayalas, these are statutory courts provided by the Gram Nyayalas Act of 2009. Let's continue. Establishment of the Supreme Court. There shall be a Supreme Court of India consisting of Chief Justice of India and not more than 7 judges. Now you might have read recently the cabinet has approved a bill where 4 more judges will be provided to the Supreme Court, which means now the Supreme Court will have, although it has not been passed yet, in the upcoming monsoon session this bill will be passed. Right now we have a Chief Justice of India and 33 other judges. After that bill is passed, we will have a Chief Justice of India and 37 other judges, which means we will have total 38 judges. Who will determine the composition of the Supreme Court? That power is with the Parliament. And how will Parliament do that? By enacting a law. Is this law a constitutional amendment bill? No, this is an ordinary law. And an ordinary law is to be passed by simple majority. Which means there shall be a Supreme Court of India which consists of the Chief Justice of India and not more than 7 judges. Can we increase the number of judges, puny judges? Yes. How? By parliamentary law. What sort of law would that be? A constitutional amendment bill? No, it has to be an ordinary law passed by simple majority. Currently, we have Chief Justice of India and 33 other judges. If the bill is passed, then we will have a Chief Justice of India and 37 other judges. And how these judges are appointed? Appointed by the president. And you would know on the basis of the recommendations of the collegium. On the basis of the recommendations of the collegium. Who is going to be the Chief Justice of India? Constitution does not talk about how the Chief Justice of India is to be appointed. Constitution only says that every judge of the Supreme Court shall be appointed by the President, after consultation with such of the judges of the Supreme Court and High Court as he may deem necessary. But whenever the President has to appoint judges other than the Chief Justice of India, the Chief Justice of India shall always be consulted. But who is this Chief Justice of India going to be? Existing under the current situation, outgoing Chief Justice nominates a successor. And this successor should be fit to hold office. Which means current Chief Justice of India, before his term gets over, he will nominate his successor if that successor is fit to hold the office, and then recommend that name to the President. President will appoint that person as the Chief Justice of India. Which means an outgoing Chief Justice nominates a successor, and that successor becomes the Chief Justice of India. Other judges are appointed by the President based on the recommendations of the Collegium, which includes Chief Justice of India and senior judges of the Supreme Court. Right or wrong? Right. Acting Chief Justice. Look at these facts. Whether Collegium system is good, bad, ugly. Whether we need a Judicial Accountability Commission. Whether the way in which the judges are removed, whether that law is effective or not. That's the subject matter of the mains examination that we will discuss in the mains examination. Let's look at the facts currently, concepts currently, so that you are able to solve questions in the upcoming prelims exam. When the office of the Chief Justice of India falls vacant, and what leads to vacancy? Maybe Chief Justice of India has been removed, or Chief Justice is dead, or Chief Justice has resigned, or Chief Justice is absent, or unable to perform the functions of his office. Whatever reason. Who will perform the office, who will perform the functions of the Chief Justice of India? For that, acting Chief Justice will be appointed. And who will appoint this acting Chief Justice? The President will appoint. When? When the office of the Chief Justice is vacant. Or when the Chief Justice is present, but because of his absence or otherwise, maybe because of his health conditions, he is unable to perform the duties of the office. Then who will perform the duties of the Chief Justice of India? An acting Chief Justice. Who appoints the acting Chief Justice? President. But Constitution also talks about ad hoc judges. Ad hoc judges in the sense, we have a large pendency of the cases. And we want to resolve these cases as quickly as possible. Then what the Constitution says, we are unable to hold the sittings of the court because there is no quorum. Minimum number of judges who should be present so that the court can function. For example, we are reviewing the Shabarimala case. 9-judge bench of the Supreme Court is hearing this matter, which means our entire attention is devoted on the Shabarimala case. What will happen to the other cases? In this circumstance, ad hoc judges can be appointed by the President. President on the advice of the Chief Justice of India. Sir, here it is mentioned NJAC. I told you previously also, when Constitution is amended, terms or provisions are added to the Constitution. Later on, this amendment is declared unconstitutional by the Supreme Court. That does not mean Constitution goes back to its original self. Constitution stands amended, but it is eclipsed by the, not eclipse is not a right word for this. The Constitution remains this way it was when it was amended. It's just that these provisions will not enter into force because they have been declared unconstitutional. That is why you will see NJAC mentioned in the Constitution, in the original text of the Constitution, because although it has been declared unconstitutional, but that does not mean we will have to delete it from the provisions of the Constitution. Who are these ad hoc judges? We will take judges from the High Court. If these High Court judges are qualified to be appointed as the Supreme Court judges, The Chief Justice of India will ask them, please come. We are consulting the Chief Justice of the High Court as well. From these high courts, we will bring in ad hoc judges to the Supreme Court because there is lack of quorum in the Supreme Court. What is the qualification for a Supreme Court judge? You should be a citizen of India and you should be an advocate in one or more high courts for 10 years. Citizen of India, in the eyes of the president, you should be a distinguished jurist. Citizen of India, and you should be a judge of one or more high courts for 5 years. If in high courts we already have judges who have tenure of more than 5 years, which means they're duly qualified to be appointed to the Supreme Court. Since in Supreme Court there is lack of quorum, we need these high court judges who are qualified to be appointed as the Supreme Court judges. For some time, we call them ad hoc judges. Can the retired judges also be asked to come and preside over the sittings of the Supreme Court? Yes. But for that, you have to take the consent of the president. You have to take the consent of this retired judge as well. A retired judge of the Supreme Court may be asked to sit in the Supreme Court again. But this time you have to seek the consent of the retired judge. He should give consent that yes, I can come back to the Supreme Court. I can preside over some sittings because we are the retired judges of the Supreme Court. Similarly, Constitution also talks about acting Chief Justice of a High Court. If the office of the Chief Justice of a High Court is vacant, or the Chief Justice is unable to perform his duties, then who will perform the duty of the Chief Justice of that High Court? Acting Chief Justice will be appointed by the President. This is acting Chief Justice. But in the High Court, we have additional judges or acting judges. Listen to me carefully. In Supreme Court, we have ad hoc judges or retired judges can be called to sit in the sittings of the Supreme Court. Or we may have acting Chief Justice. In High Court, we have acting Chief Justice. We may have acting Chief Justice, but we have additional or acting judges as well. Acting Chief Justice, acting judge. There is no such thing as acting judge in the Supreme Court. If there is a temporary increase in the business of a high court, large number of cases have been filed or large number of cases are pending, the president may appoint judges as additional judges. Who are these additional judges? If you are eligible to be appointed as a high court judge, you will be appointed as an additional judge. But you cannot be appointed as an additional judge for more than 2 years. Normally what happens? President appoints additional judge to the Madras High Court, then within 2 years you are made the permanent judge of that High Court. So initially you start off with as an additional judge. Here is another matter, and listen to this carefully. When any judge of a High Court other than the Chief Justice of India, other than the Chief Justice of that High Court, is by reason or absence or for any other reason unable to perform the duties of his office. So this is the judge of a High Court, not the Chief Justice of this High Court, judge of this High Court. Now I am unable to perform my duty because of sickness, because of illness or whatever reason. Or maybe I have been appointed as the acting Chief Justice of this High Court. But I am unable to perform my duty. In this case, the president may appoint a person who is duly qualified to act as the judge of the court until the permanent judge resumes his office. Sir, what is the difference? This sounds similar. Acting and additional. Additional judges are appointed when there is a temporary increase in the business of the High Court. Or when the president feels that temporarily the number of judges for this High Court should be increased. For that, additional judges are appointed. Acting judges are appointed when the existing judge is promoted as or is serving as or is acting as the Chief Justice of that High Court. Which means that now we have less number of people in the High Court. Or in the High Court, the same judge is unable to perform his duties. Till this permanent judge returns, becomes healthy again. Or till this acting Chief Justice, now we have a regular Chief Justice, you come back as the judge of that High Court. Till this permanent judge resumes, we will appoint an acting judge. But no person shall be appointed as an acting judge or an additional judge after you have attained the age of 62. Because what is the retirement age of the judge of the High Court? 62. What is the retirement age for the judge of a Supreme Court judge? That is 65. Okay? Great. Supreme Court acts as a court of record. And what does that mean? Supreme Court acting as a court of record. Number one, your judgments are saved, recorded for posterity. You have the power to punish for contempt. If any court satisfies this criteria, we call it the court of record. Which means in India, only high courts and the Supreme Court act as a court of record, not the district court. Does that mean district courts' rulings, verdicts, judgments are not saved for posterity? No, they are saved. But district courts cannot punish for its contempt. Does that mean you can commit contempt to the district court? No. Then, High Court concerned will punish you for committing contempt to the district court. Which means if I am presiding over a district court, you have committed contempt of this district court, I cannot punish you because I am not the court of record. But my concerned High Court will punish you on my behalf. The seat of the Supreme Court shall sit in Delhi or any other place or places. Which means, can the Supreme Court sit only at one place or at multiple places at the same time? Can we have multiple benches of the Supreme Court? Yes. Who says this? Constitution. Constitution says the Supreme Court shall sit in Delhi or in such other place or places as the Chief Justice of India may, with the approval of the President, from time to time appoint. What is the original jurisdiction of the Supreme Court? Supreme Court hears federal cases. It comes under original jurisdiction. What is the difference? There is something called original jurisdiction and there is something called exclusive jurisdiction. What is the difference between original and exclusive jurisdiction? If a case can be filed directly in the Supreme Court, we say on such cases, Supreme Court has the original jurisdiction. If a case can be filed only and only in the Supreme Court, we say Supreme Court has the exclusive jurisdiction on all these cases. Sir, I don't understand. For violation of fundamental rights cases, can you go to the Supreme Court? Yes. Can you directly approach the Supreme Court? Yes. Which means on fundamental rights violation cases, Supreme Court has the original jurisdiction. But does Supreme Court have the exclusive jurisdiction on fundamental rights violation cases? Why not? Because you can also approach the High Courts under Article 226 if your fundamental rights are violated. Okay. Which means your fundamental rights are violated, you can directly approach the Supreme Court. Supreme Court has original jurisdiction on these cases. But you may not want to approach the Supreme Court. Can you approach the High Court under Article 226? Yes. Which means on fundamental rights, Supreme Court does not have exclusive jurisdiction. Then which are those cases where Supreme Court has exclusive jurisdiction? If there is a dispute with regards to the election of the President and the Vice President, where do you go? You go to the Supreme Court. Can you go to any other court in this country? No. Which means on these election disputes with regards to President or the Vice President, Supreme Court has the exclusive jurisdiction. There are federal cases involving disputes between center and the state, dispute between amongst the states. All these are federal disputes. Such disputes can be filed only and only in the Supreme Court, not in any other court. We say on all these matters, Supreme Court has original as well as exclusive jurisdiction. But this original jurisdiction, can we enlarge the jurisdiction of the Supreme Court? Or can we have exceptions to original jurisdiction? Yes. What are the exceptions? pre-constitutional treaty. What is the exception? Matters related to Finance Commission. What is the exception? Interstate river water disputes. These are the exceptions to original jurisdiction. Why? Because we consider all of them are political matters. And these political matters are best resolved by the political leaders, by the parliament, by the political executive. But can we enlarge the jurisdiction of the Supreme Court? For example, I was telling you about fundamental rights when we discussed Article 32. And then we discussed Article 33, 34, 35. In Article 35, I told you who has the power under this part, state legislature or the parliament. In a sense, Supreme Court has the power to issue writs for the protection of fundamental rights. Habeas corpus, mandamus, certiorari, prohibition, quo warranto. Can this power of the court to issue writs be extended to other rights also, legal rights also? Who will have to give you this power that you can issue writs for the protection, upholding of rights other than the fundamental rights as well? That power will be given by the Parliament under Article 139. Conferment on Supreme Court of powers to issue certain writs for purposes other than those mentioned under Article 32. But can we give Supreme Court the jurisdiction that now you can resolve matters related to elections also? You alone will have the power to look at the disputes involving service matters of public servants. Long story short, who has the power to enlarge the jurisdiction of the Supreme Court? That power is available with the Parliament. Further, whatever judgment is given by the court, by the Supreme Court, we say it is binding in all the courts throughout the territory of India. Any verdict that is given by the court, it's binding. And whatever judgment is given by the court, we say it is the law of the land. Where is it mentioned? It's mentioned under Article 141. Supreme Court can issue any order so as to give complete justice. Which provision of the Constitution talks about this? Article 142. Complete justice in the sense? One person, he failed to submit the fee on time to an IIT. This person is a Dalit. Now, every organization or an institution has rules. Are we denying you the admission? No. Did we give you the opportunity that you can submit your fee by this time? Yes. But you have failed to submit the fee. We cannot change rules for you. Because we have some discipline, we have to abide by rules. If we change it for you, then we have to change it for everybody. Then it will be chaotic. This Dalit boy approached the Supreme Court. Normally, what will the court do? Court will listen to your argument, court will listen to the other argument. University is not wrong, IIT is not wrong because they are abiding by their own rules. And they are not discriminating against this Dalit boy. So is there any way in which court can issue an order to save the life and the career of this Dalit boy? Ideally none. Because in a dispute, one is a winner, the other is a loser. In this case, Supreme Court said, but look at this boy, he's a Dalit boy. Look at the kind of sacrifices he would have made to reach where he has reached. Just because he was unable to provide for fee on time, he struggled to arrive at the fee. That doesn't mean he should lose his career. we are issuing an order under Article 142. Let IIT accept this fee even after the expiry of the date. Court can issue any order and it is not constrained whether there is a rule, there is no rule, there is law, there is no law. Court can do anything so as to give complete justice. That's Article 142. This provision, Article 143, becomes important for your exam. If at any time it appears to the President that a question of law or a fact has arisen, it has already arisen or is likely to arise, which is of such nature and such public importance that it is expedient, necessary to obtain the opinion of the Supreme Court, the President may refer this matter to the Supreme Court. And such a presidential reference should be heard by 5 judges of the Supreme Court. And this opinion will be given by the Supreme Court. But this opinion is not binding on the government because it is only a presidential reference. This is only an opinion. This cannot be binding on the government. But this is a presidential reference. But one interesting thing. Can a presidential reference modify a judgment, a prior judgment of the court? Prior judgment of the court? Yes or no? No modification. Okay? There can be modification without changing the essence of the judgment. How? Listen to me carefully. Very important point. 1993, second judge's case. Supreme Court said appointment of judges is an integrative, participatory, consultative exercise to select the best possible talent to the judiciary. So, President, if you have to appoint a judge to the Supreme Court, you consult Chief Justice of India and 2 senior judges of the Supreme Court. 5 years later, third judge's case, presidential reference, 1998. Supreme Court said, no, now you should consult Chief Justice of India and 4 senior judges of the Supreme Court. And right now, the government is consulting 4 judges and the Chief Justice of India. Is this not modification of the earlier judgment of the court? Can a presidential reference of 1998 modify the judgment of the court in 1993? Modification is allowed without changing the essence. Can this presidential reference say, no, now there is no collegium system, we will go back to executive having the complete control over judicial appointments? No. Presidential reference cannot modify the essence of the original judgment, but it can modify it to make it more practicable. Now, even after 1998 presidential reference, it is the collegium system which recommends to the president who should be appointed as the judge of the Supreme Court and High Court. It's just that the composition has now been changed without changing the essence. That is allowed according to the Supreme Court. That's Article 143 of the Constitution. Constitution further says, there shall be a high court for each state. But that does not mean there should be one high court for every state, which means there can be common high courts as well. That is why for 28 states and 8 union territories, we have 25 high courts. These high courts will also be court of record. That means their judgments, rulings, verdicts will be saved for posterity, will be cited, and nobody can challenge the authenticity of these judgments. And at the same time, these high courts, they will have the power to punish people for its contempt. And each high court will consist of Chief Justice and as many judges as the President may from time to time appoint. This is where it becomes interesting. What is the composition of the Supreme Court? The Supreme Court shall consist of Chief Justice of India and as many judges as may be appointed according to a parliamentary law. So Parliament will decide what is the composition of the Supreme Court. Chief Justice and 33 other judges. Or later Chief Justice and 37 other judges. But what is the composition of a High Court? The High Court will consist of Chief Justice and as many judges as President may appoint from time to time. Not Parliament will determine, President will determine. That's the difference between the two. Another important fact. No person, who is this person? Who after the commencement of the Constitution has held office of a permanent judge of a High Court shall plead or act in any court or before any authority except the Supreme Court of India and other high courts. What does that mean? I have been the judge, permanent judge of Calcutta High Court. Now I have retired. Can I practice in the Calcutta High Court? No. Where can I practice? In Supreme Court. Where can I practice? In Madras High Court. If I have served as a permanent judge of Madras High Court, Calcutta High Court, Punjab and Chandigarh High Court, after my retirement, I can practice in Supreme Court, I can practice in 22 other courts, but I cannot practice in these 3 high courts. Justice Muralidhar, who was the Chief Justice of the Odisha High Court, who was the judge of the Delhi High Court as well. He was the one who gave the judgment in the Nas Foundation case. Now he is the senior advocate of the Supreme Court. So can after their retirement High Court judges practice in the Supreme Court? Yes. Can after their retirement they practice in any other High Court where they have not served previously? Yes. Article 222. Who will provide that a particular High Court's jurisdiction be extended to Union territories? Parliament, not the President. So these are trap points. President or Parliament? Parliament or President? Who will decide the composition of a High Court? That it will consist of Chief Justice of India and as many judges as may be appointed by the President. But what is going to be the composition of the Supreme Court? That will be determined by a parliamentary law. There are only 2 union territories in India which have their own high courts. So can union territories have their own high courts? Yes. Which are these union territories which have their own high courts? Delhi and Jammu and Kashmir. What about other high courts, other union territories? They come under the jurisdiction of the neighboring states' high courts. Who assigns this neighboring states' high court to a union territory? Parliament. That is why, which high court has the jurisdiction over Chandigarh, Punjab and Haryana High Court? Which high court has the jurisdiction over Ladakh, Jammu and Kashmir High Court? Which high court has the jurisdiction over Lakshadweep? Which high court has the jurisdiction over Lakshadweep? Kerala High Court. Which high court has the jurisdiction over Puducherry? Madras High Court. Which high court has the jurisdiction over Andaman and Nicobar Island? Calcutta High Court. That's how the Great Nicobar project is challenged in the High Court of Calcutta. And the High Court of Calcutta dismissed the arguments of the central government. Who will extend the jurisdiction of a high court to a neighboring high court to a union territory? That is determined by the Parliament. Clear? Hyderabad is not a union territory. Hyderabad is the capital of Telangana and Telangana already has a high court. There are 12 schedules of the Constitution. Originally there were 8. Later 4 more schedules were added. So now we have total 12. Originally if there were 8, 9th schedule was added by first Constitutional Amendment Act. The question was once asked in your prelims examination. The 9th schedule to the Indian Constitution was added during the Prime Ministership of Pandit Nehru. Daman and Diu, Dadra and Nagar Haveli, they come under the jurisdiction of the Bombay High Court or Gujarat High Court. I think the Bombay High Court. So neighboring High Court. 10th schedule was added by the 52nd Constitutional Amendment Act 1985. 11th schedule was added by 73rd Amendment. 12th schedule was added by 74th Amendment. These facts you have to keep in mind. 1992, 1993. What is Schedule 1 about? The names and details of the states and union territories. Schedule 2 talks about salaries, allowances of various constitutional functionaries, President, Prime Minister, Vice President, so on and so forth. Schedule 3 talks about oath or affirmation. For whom? Prime Minister, ministers, members of the Parliament, judges, CAG, so on and so forth. Schedule 4 talks about, and you have to keep in mind, it does not talk about the oath of the President, Vice President, Governor of the state. No. Those are provided in the text of the Constitution itself. Fourth schedule talks about allocation of seats to the states in the Rajya Sabha. Schedule 5 talks about administering the tribal areas in states other than Assam, Meghalaya, Mizoram and Tripura. Why these states are excluded? Because these states are exclusively covered under Schedule 6 of the Constitution. Schedule 7 talks about distribution of the legislative subjects into union list, state list, concurrent list. Schedule 8 talks about 22 languages. Originally there were 14, later 8 more got added, 22 languages specified in the 8th schedule. 9th schedule, any law which is placed in 9th schedule is immune from judicial review, provided this law was inserted into the 9th schedule before 24th April 1973, the Keshavananda Bharati judgment. Any law which is placed in 9th schedule after Keshavananda Bharati judgment, there can be judicial review. 10th schedule talks about anti-defection law. 11th schedule talks about what are the powers, items, subjects that we can give to panchayats, to rural local bodies. 29 items, agriculture, so on and so forth. What are the provisions, what are the matters that we can give to the municipalities, urban local bodies? 18 items are specified. Cattle ponds, burial grounds, cremation ghats. These are mentioned under 12th schedule of the Constitution. Right or wrong? Now let's talk about last thing, a very important thing from where almost every year questions are asked. Local bodies. Give me 10-15 more minutes. After that promise, I will leave you. I know it's been a long day. I think we are now into the 12th hour of this session. So congratulations. Local government, local bodies. In rural areas, in urban areas. Rural areas, panchayats. In urban areas, municipalities or municipal corporations. Right? Great. 1956, a committee gave its report. Balwant Rai Ji Mehta. And this committee recommended democratic decentralization. Rejected the top-down approach which was followed. And what is that top-down approach? Central government will decide what is best for a village or a particular district. Or the state government's deciding. Or shouldn't it be bottom-up approach? Village will decide what is going to be our priority. So do we need a bottom-up approach or a top-down approach? Balwant Raji Mehta said better would be give democratic decentralization, decentralize the powers, establish Panchayati Raj institutions, a three-tier structure where there should be panchayats in every village, group of villages, and at the district level as well. Genuine transfer of power should be enabled. This report was sent to Pandit Nehru, the government, 1957. Pandit Nehru said, it's a good suggestion, but we can't implement it at the union level. Why? Because if you look at distribution of legislative subjects under 7th schedule of the Constitution, local government comes under the domain of the states. If you look at entry 7 of the state list, it's mentioned local government. Who can enact a law on local governments? It's only for the states to decide. So we can't suggest anything. But what we can do is we can call a meeting of the NDC, National Development Council, where Prime Minister is part of it, ministers are part of it, chief ministers are part of it, and we can discuss. And in January 1958, when this meeting was organized, all the states accepted, said, okay, we will implement Panchayati Raj system. We will go for democratic decentralization. But don't insist upon us what is the template that we wish to follow. Some states followed 4-tier structure. Some states followed 2-tier structure. Some states followed 3-tier structure. But nevertheless, Panchayati Raj institutions were established. The first time it was established was in Nagaur in Rajasthan on October 2, 1959, to coincide with the birth anniversary of the Mahatma. Because after all, it talks about Article 40 of the Constitution. Implementation of a directive principle, which is a Gandhian directive principle. The state shall organize village panchayats and empower them with power so as to enable them to function as units of rural local self-government. Panchayati Raj institutions. But then there were a lot of problems. Problems in the sense, sometimes, I will add few slides here. Sometimes elections were held, sometimes elections were not held, sometimes elections got delayed, so on and so forth. But then what happened? I might have deleted the annotations. If that happens, that is going to be very problematic. But I will try and ensure that I restore the annotations. Okay. So what happened? Elections were conducted, but then elections got delayed. Elections were conducted, panchayats were established, then they were dissolved. Long story short, various committees, various commissions were set up by the union government saying, how can we better our Panchayati Raj system? And a most important report was prepared by L.M. Singhvi Committee. And L.M. Singhvi Committee recommended give constitutional status to panchayats. Give constitutional status to panchayats. Rajiv Gandhi's government tried to introduce constitutional amendment bills because if it's a constitutional body now, you can't delay elections. You can't dissolve panchayats and not re-establish them. Constitutional protection is given. Elections cannot be at the whims and the fancies of the state government. Powers are to be necessarily given to the panchayats. So on and so forth. But when L.M. Singhvi Committee recommended constitutional status, Rajiv Gandhi's government tried to introduce bills, but the states objected, saying this is violation of federal principles. How can Parliament enact a law on state list without seeking the approval of the states? We don't want to give our approval. This constitutional amendment bill got defeated. Then came VP Singh. VP Singh's government also tried to do something, but then VP Singh's government also got dissolved. Then came PV Narasimha Rao. And PV Narasimha Rao's government, what it did, it tried to create a consensus amongst the states, which is where it becomes important for your exam. Panchayati Raj institutions, urban local bodies, they are established in every state, not according to constitution, according to the laws passed by the respective state legislatures. Which means whenever we see panchayats in states, urban local bodies in the states, these are constituted on the basis of the laws enacted by the state legislature. But when the state legislature enacts this law, while enacting this law, it has to necessarily provide for those compulsory provisions which are provided by the 73rd and 74th Amendment. And if it wants, it can also incorporate these voluntary provisions in their respective laws. We wish that you incorporate these voluntary provisions as well. But necessarily you have to incorporate these compulsory provisions. You may incorporate these voluntary provisions as well. 73rd Amendment was passed, which dealt with panchayats. 74th Amendment was passed, which dealt with urban local bodies. But you have to keep in mind that panchayats and municipalities are established in every state based on the laws passed by their respective state legislatures. So if Karnataka has to establish Panchayati Raj, Karnataka state legislature will enact a law. But what will be the provisions of this law? Law will take a look at 73rd Amendment and will include those which are to be compulsorily included, and may also decide to include those provisions which are voluntary. But that's for the state legislature to decide. This is how, through give and take, consensus was achieved and arrived at, and that's how constitutional status was given to panchayats. Now it is necessary to have a three-tier structure. What is this three-tier structure? Let's focus on panchayats. The foundation of the panchayat is Gram Sabha. Gram Sabha has to be constituted. And what is the composition of the Gram Sabha? Every registered voter of the village will be part of the Gram Sabha. Gram Sabha has to be constituted. It is compulsory. Who is part of the Gram Sabha? Every registered voter of that village is part of the Gram Sabha. But what were the powers of the Gram Sabha? That state legislature will decide. Then a three-tier structure needs to be created. Gram Panchayat, Panchayat Samiti, and Zilla Parishad. Is Gram Sabha an elected body? No. All the registered voters of that village, everybody who is above the age of 18 is automatically part of the Gram Sabha. What are the powers available to the Gram Sabha? That's for the state legislature to decide. But then we have to create a three-tier structure where there is Gram Panchayat, elected body. Panchayat Samiti in a group of villages at the block level, elected body. Zilla Parishad at the district level, elected body. And members are all elected by the people themselves. So this is what we call democratic decentralization. Who is going to be the head of the Gram Panchayat? That is for the state legislature to decide. Who is going to be the head of the Panchayat Samiti and Zilla Parishad? The chairman has to be indirectly elected. Which means all the members of the Panchayat Samiti, they will decide one amongst us will be the chairman of the Panchayat Samiti. All the members elected to the Zilla Parishad, together we will decide one of us will be the head of the Zilla Parishad, will be the chairman of the Zilla Parishad. But who is going to be the head of the Gram Panchayat? That's for the state legislature to decide. Whether directly elected, indirectly elected, doesn't matter. That's for the state legislature to decide. But in all these three levels, there will be a reservation. This is the only tier of government where there is a reservation for women in force. Although we have a 106th Constitutional Amendment Act, but that is contingent upon delimitation, census, and then reservation for women will take place. The only institution, the only tier where we have reservation for women implemented, it is this Panchayat and municipalities, urban local bodies and rural bodies. Reservation for women. But what is the percentage of reservation? Not less than 1/3. Can it be 50%? Yes, there are various states which have provided 50% reservation for women. Not less than 1/3 is a constitutional imperative. Can there be reservation for SCs and STs? Yes. What is the proportion of their reservation? Be absolutely sure about the facts. It is not 1/3. It is in proportion to their population. In proportion to their population. Can there be reservation for OBCs? That's for the state legislature to decide. That's a voluntary provision. Reservation should not only be for seats. Reservation should also be for the post of the chairpersons. That means not less than 1/3 of the post of the chairperson shall be reserved for women. Chairperson posts shall be reserved for SCs and STs in proportion to their population. What is going to be the term of this panchayat? 5 years. Can it be dissolved earlier? Yes. If it is dissolved prematurely, the reconstituted panchayat will remain in office for the remainder of the term. Which means that the term of the panchayat is 5 years. But after 2 years, this panchayat was dissolved. New panchayat has to be constituted. The term will be the remaining one, the 3 years. But it is not possible to organize this new panchayat if the elections are necessarily to be conducted within 6 months. Who is qualified, or what are the disqualifications on the basis of which you can be a member or disqualified as the member of panchayat? If you are qualified to become an MLA, you are qualified to become a member of the panchayat. Except voting, except age, minimum age is 21 years. The age for an MLA is 25 years. But if you are qualified to become an MLA, you are qualified to become the member of the panchayat. But additional qualifications can be prescribed by the state legislature by law. That is why there are some states where educational qualifications are a must, where you should have a functional toilet and then you can contest the elections. You are qualified to contest the election. If you are disqualified to become a member of the state legislative assembly, you are disqualified from being the member of the panchayat as well. But additional disqualifications can be prescribed by state legislature by law. Is anti-defection law of the 10th schedule applicable to panchayats and municipalities? No. Can states have their own anti-defection law on the basis of which they will disqualify these panchayat members? Yes. Additional qualification, additional disqualification can be prescribed by the state legislature by law. And who will organize this election? This election, superintendent's direction, conduct and control is vested in a constitutional body called State Election Commission. Something that I have covered in the video on constitutional bodies. State Finance Commission, constituted every 5 years by the governor. I have covered in that video on the constitutional bodies. But the constitution says, what are the powers? State legislature may give one or all items that are mentioned in the 11th schedule to the panchayats. State legislature may, although there are experts who say ideally this term should have been the state legislature shall. But that is how a consensus was arrived at, and that's how constitutional status was given to panchayats. So panchayats are to be organized in every state based on the law enacted by the state legislature. Gram Sabha has to be constituted, which consists of the registered voters of that village. Gram Panchayat, Panchayat Samiti, Zilla Parishad, these are three tiers which you have to necessarily create. To all the three tiers, direct election will take place. Who is going to be the chairman of the Gram Panchayat? That state legislature will decide. Who is going to be the chairman of the Panchayat Samiti and the Zilla Parishad? That is indirectly elected. But whatever developmental works are to be taken into account, the district collector will have to implement based on whatever the panchayats decide. How the election will take place, that's for the State Election Commission to decide. Who is going to be eligible to contest for the election of the panchayats? If you're eligible to be if you're eligible to become an MLA, you are eligible to become the member of the panchayat. If you're disqualified from being an MLA, you are disqualified from being the member of the panchayat. But one condition is age. To become an MLA, you should be 25 years plus. To become a member of the panchayat, you should be 21 years of age. Panchayats constituted for 5 years. State Election Commission, State Finance Commission. Whether these 29 items are to be given to the panchayats or not, whether all of them or some of them or none of them, that's for the state legislature to decide. Whether in panchayats there can be reservation for OBCs, that's for the state legislature to decide. This is Panchayat, the 73rd Constitutional Amendment Act. Clear? So that's about it. We will have to wrap it up now. If this session was of any help to you, let me know in the comments. Do not forget to like this video. All the best for your prelims examination. And if you need something else, something more, something different, maybe a lecture here and there, maybe a doubt session, whatever it is, do let me know in the comments. Once the live session is over, I may not be able to go through the chats. So please drop me a comment under this video. I will go through your comments, and whatever possible at my end, I'll do that for your success, for your dream. Okay, thank you so much for staying with me. Good night. All the best. Take care.